Why, sir? Wait. All fresh memos, Kodi. Ella Monday.
ಇದು ಸೆಟಲ್ಮೆಂಟ್
FR ಇದ್ರೆ ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕು, ಇಲ್ದಾರೆ ಬರೋಲ್ಲ.
ಆ ಕಡೆಯಿಂದ
Wait.
ಒಂದ್ ಸೆಕೆಂಡ್ ಇಲ್ಲ ಸರ್, ನಮ್ದು ಕೊಡ್ಬೇಕು ಸಬ್ಮಿಷನ್.
ಪೋಸ್ಟ್ ಏನ್ ಮಾಡ್ತಾರೆ?
ಸೆಟಲ್ಮೆಂಟ್ ಯಾವಿದೆ ಎಲ್ಲ ಕೊಡಿ. ಯಾವ್ದು ಸೆಟಲ್ಮೆಂಟ್ ಯಾವತ್ ಬೇಕು ಅಂತ ಅದ್ರಲ್ಲೇ ಬರ್ದಿರಿ.
I have written the date.
ಆಮೇಲೆ ಮೆಮೋಸ್ ಅಲ್ಲಿ ಫ್ರೆಶ್ ಇದ್ರೆ ಸ್ಕ್ರೂಟಿನಿಗೆ ಅಂತ ಬರೀರಿ, ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಅಂತ ಬರೀರಿ.
ಫಾರ್ ವಿಡ್ರಾಲ್.
One minute. Settlement.
Lord, in this case, October.
Wait, sir. Withdrawals have.
For withdrawal. Kodi, sir. Withdrawal.
If you say like this, where is the memo? Yes. Now what's the problem, sir?
Madam, fresh matter.
Madam, vacating stay yavattu nale. Which year, sir? Tomorrow. Vacating stay tomorrow. 2023 matters will come. Yes.
My lord, vacate.
All of you are collected like this. Sorry, pending matters ella kottbidi memo. Vacating ಯಾವ ವರ್ಷದ್ದು? 20 Thursday.
That pending matter no stay.
Vacating 20.
Friday. ಅಯ್ಯೇ ಹಾಕಿದ್ರೆ ಮಾತ್ರ.
Pending ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಅಂದ್ರಲ್ಲ.
ನಿಮ್ದೇನು ಸರ್? ವಿಕೆಟಿಂಗ್ ಸ್ಟೇನಾ? ಫಾರ್ ಸ್ಟೇನಾ? ಅದು ಮಂಡೇ ಬರುತ್ತೆ.
2023. Vacating.
Friday, sir. All that will post on Friday. Don't give a memo. We'll post on Friday. Memo ಬೇಡ, ನಾ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ತೀನಿ. ಅರೆ so what? Friday post ಮಾಡಿಸ್ತೀನಿ.
My lord, vacating stay.
Give all the pending memos.
That no stay pending matter.
All the pending memos ಕೊಡಿ.
That pending matter no stay Lord.
No stay ಇದ್ರೆ ಮಂಡೇ ಬರುತ್ತೆ. ಯಾವ ವರ್ಷದ್ದು? ನಾನೇ ನೋಟಿಸ್ ಮಾಡಿರೋದಾ? ಹಾಗಾದ್ರೆ ಸ್ಟೇ ಇಲ್ಲ ಕೊಡಿ.
My lord, vacating stay 2022 matter.
Vacating stay, please give all the vacating stay memos wherever you have filed.
The petitioner wrongly challenged me.
23, 22 na. ಸ್ವಲ್ಪ ಕೇಳ್ಬಿಡಿ, ಅವ್ರಿಗೆ ಲಿಸ್ಟ್ ಕೊಡಿ. I'll come. Wait.
Pending matter.
It's all right, sir. Pending matter. Kodi. Maybe, sir. Please give all the pending memos. No date, sir. Please give all the pending memos. It will come according to the years. Why? Interim notice vanished. Okay, let's see. Kodi. Give all the pending memos.
Submission.
Give, sir.
Pending matters, my lord.
230 ಬೇಕಾದ್ರೆ ಮಾತ್ರ ಮೆನ್ಷನ್ ಮಾಡಿ, ಇನ್ ಮಿಕ್ಕಿದೆಲ್ಲ ಕೊಡಿ. ಸಿವಿಲ್ ಸೂಟ್, ಕ್ರಿಮಿನಲ್ ಸೂಟ್, ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್.
Vacating interim matter. Vacating interim matter.
ಮೇಬಿ ಸರ್, ಪ್ಲೀಸ್ ಗಿವ್. ಏನ್ ಪರವಾಗಿಲ್ಲ ಸರ್, ಕೊಡಿ.
My lord.
Give all the memos. Pending, please give all the memos.
Pending matter, my lord.
Matter it pertain to anything. Give the memos.
Pending matter.
ಎಲ್ಲ ಕೊಡಿ ಮೆಮೊ.
Last 3 weeks ಇಂದ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಪರವಾಗಿಲ್ಲ ಸರ್, ಕೊಡಿ, ಏನಾಗಲ್ಲ.
My lord, there is no stay.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ತಾನೆ?
Pending matter. No
ಇಂಟ್ರಿ ಆರ್ಡರ್ ಇಲ್ವಾ?
ಇಲ್ಲ sir.
ಮಂಡೇ ಬರುತ್ತೆ, ಕೊಡಿ.
My lord.
My lord, there is no interim order pending matter, sir.
ನಾನೇ, if I have myself issued notice,
No,
please don't move it. I will not
2023
grant an interim order.
No, my lord, 2023 matter.
If I have issued notice and you are moving, not grant
No,
interim
my
order, I will dismiss it.
Please, my lord.
Yes.
My lord.
My lord.
LPM ಮೇಲೆ matter.
Wait.
My lord.
ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಆಯ್ತಾ?
My lord.
ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ನೋ ಸಬ್ಮಿಷನ್. ಇಂಟ್ರಿ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂದ್ರೆ ಮಂಡೇ ಬರುತ್ತೆ, ಅದು ಕೊಡಿ.
Madam, vacating.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಇದ್ರೆ ಕೊಡಿ.
My lord.
ಇಲ್ಲ ಸರ್, ಇಂಟ್ರಿ ಆರ್ಡರ್ ಇಲ್ವಾ? ಮಂಡೇ ಬರುತ್ತೆ, ಕೊಡಿ. Give all the pending memos.
My lord, specific, my lord, one commission.
Whatever year it is, give the pending memos.
One commission.
Date, who gave the dates? Judicial order. Memo ಮೇಲೆ ಆಗಿದ್ರಿಲ್ಲ. Yes.
ಅಲ್ಲ ಕೊಡಿ. Fresh matter.
ಅದ್-
Fresh matter.
ಅದ್ ತಗೊಳ್ಳಿ madam. We'll refer it to mediation. ನಾಳೆ ಹಾಕಿ.
Matters pertaining to MPML.
ಮಾಡಿ.
1 minute. MPML Thursday ಕೊಡಿ. ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ Thursday. ಅದು ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದ್ರು ಬರುತ್ತೆ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Malad.
Fresh matter. Is it fresh matter?
Two matters are fresh.
All right, yes.
No interim order.
ಆಗಿಲ್ಲ ಇನ್ನು ಮೆಮ್ಮ ಕೊಡಿ.
Malad, fresh matter 7107.
Maybe sir, give it pending or fresh.
Malad, fresh matter. Malad,
Monday.
Malad, fresh matter.
Pending. Fresh ಇದ್ರೆ
fresh
Monday
matter.
ಬರುತ್ತೆ ಕೊಡಿ.
Malad,
Fresh matter Monday ಬರುತ್ತೆ ಕೊಡಿ.
Malad, fresh matter, criminal petition 7107.
Wait sir, I'm coming. Wait. Yes. ಹಾ ಅದು ಕೊಡಿ. ನಾಳೆಗೆ ಹಾಕಿ. Yes. Yes. Monday ಕೊಡಿ. ಅದಕ್ಕೆ ಮುಂಚೆ ನಾನು ತಗೊಳಲ್ಲ ಸರ್. Don't ask this week at all. Monday fresh matters ಅಷ್ಟೇ. ಏನಾದ್ರೂ ಇರ್ಲಿ Monday. Yes. Unless ಮಧ್ಯಾಹ್ನ ಅರೆಸ್ಟ್ ಆಗ್ತಿದ್ದೀರಾ, ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ ಅಂದ್ರೆ ಬೇರೆ ಮಾತು. Yes.
Malad, fresh matter.
ಸರ್ ಲವ್ ಮ್ಯಾರೇಜು ಅರೇಂಜ್ ಮ್ಯಾರೇಜು ಮೊಮ್ಮೆಗೂ ಅದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ ಸರ್? ಲವ್ ಮ್ಯಾರೇಜ್ ಆದ್ರೆ ನಾಳೆನೆ ತಗೋಬೇಕಾ? ದೆನ್ ಅಂದ್ರೆ ಆಲ್ ರೈಟ್. ಲವ್ ಮ್ಯಾರೇಜ್ ಆದ್ರೆ ನಾಳೆನೆ ಬೇಕಾ? 2:30 ಬೇಕಾ? ಏನ್ ಹಾಗಾದ್ರೆ 2 weeks ಬಿಟ್ಟು ಹಾಕಿ ಅದು.
Malad.
But being spoken, my lord.
ವೆಯ್ಟ್ ಸರ್. ಅರ್ಜೆನ್ಸಿ ಏನ್ ಹೇಳಿದ್ರೆ ನಥಿಂಗ್ ಟು ಡೂ ವಿತ್ ಕಂಪ್ಲೇಂಟ್ ಅದು. ವ್ಯಾನ್ ಇಟ್ಕೊಂಡ? ಎಸ್ ಸರ್, ಯಾಕೆ ಬೇರೆ ಜಾಗ ಇರ್ಲಿಲ್ವಾ? ಮೇಡಮ್ ಪಾರ್ಕ್ ಮಾಡಿರ್ಬೋದು ಬಿಡಿ ಸರ್. 2:30 ತಗೊಳ್ಳಿ. ಎಸ್ ಎಸ್ ಸರ್. ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ದ ಸ್ಟೇಟ್ ಯು ಆರ್ ಮೂವಿಂಗ್. ಹಾ ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಸರ್. 2:30 ಬೇಕಾ ಸರ್? ಯಾಕೆ ಸರ್?
ಇದು ಯಾವತ್ತು ಬಂದಿದ್ದು?
ಈಗ ಮ್ಯಾಟ್ರ್ ನಾಳೆ ಇದೆಯಾ? 2:30 ತಗೊಳ್ಳಿ. ಸೊ ಮಾರ್ಕ್ ಮಾಡಬಾರ್ದಾ? ಹಾ ನೆಕ್ಸ್ಟ್ ಡೇ ಯಾವತ್ತು? ಹಾ ಸರಿ, ನಾಳೆಗೆ ತಗೊಳ್ಳಿ. FR ನಂಬರಾ? ಕಂಪ್ಲೈ ಮಾಡಬೇಕು. ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ? ಯಾವಾಗ ಬೇಕು? ಫಾರಿನ್ಗೆ ಹೋಗ್ತಾ ಇದ್ದೀರಾ? ಕೊಡಿ. ಯಾವಾಗ ಹೋಗ್ತಾ ಇದ್ದೀರಾ? ಮುಗಿಸ್ಕೊಂಡು ಹೋಗ್ತೀರಾ? ಆಯ್ತು, ಮುಗಿಸ್ಕೊಂಡು ಹೋಗಿ ಕೊಡಿ. ಆಯ್ತು, ನಾಳೆಗೆ ತಗೊಳ್ಳಿ. ಎಲ್ಲಿಗೆ? ಅಲ್ಲಲ್ಲಿ ಫಾರಿನ್ಗೆ ಎಲ್ಲಿಗೆ? ಥೈಲ್ಯಾಂಡ್ಗ? ಆಯ್ತು 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 ನಾಳೆ. That will come on Friday, sir. Friday that will be it will be listed on Friday for pronouncement. Yes. ಹೌದಾ? ಅಲ್ಲೇ ಹಾಕೊಳ್ಳಿ. ಟ್ರಾನ್ಸ್ಫರ್ ಇಲ್ಲ, ಇಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ, ಅಲ್ಲಿ ಹಾಕೊಳ್ಳಿ. ಯಾವ ಟ್ರಾನ್ಸ್ಫರ್? ಇಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ, ಅಲ್ಲಿ ಹಾಕಿ. ಮೆಮೊ ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಮಧ್ಯಾಹ್ನಕ್ಕೆ ತಗೊಳ್ಳಿ, ಕ್ಲೋಸ್ ಮಾಡೋಣ ಇಲ್ಲಿ. ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಯಾಕೆ ಮಾಡಿಲ್ವಾ? ಕೊಡಿ.
ಕ್ರಿಮಿನಲ್ ಪೆಟಿಷನ್ ನಂಬರ್ 7.
ನಾಳೆ ತಗೊಳ್ಳಿ. ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ 2:30 ತಗೊಳ್ಳಿ. ಎರಡು ಅದೇನಾ? ಇನ್ನೊಂದು ಯಾಕೆ ಕೊಟ್ರಿ? ಬೈ 1 get 1 ಫ್ರೀ ಅಲ್ಲ ಇದು. ತಗೊಳ್ಳಿ ಒಂದು ವಾಪಸ್. ಹಾ ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಹಾಕಿ. ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ರೆ ಮಾತ್ರ ಬರುತ್ತೆ. ಎಸ್. ಅದು ಯಾವ ವರ್ಷದ್ದು? ನಾಳೆ ಕೊಡಿ. ನಾಳೆ ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಎಲ್ಲ ನಾಳೆ ಹಾಕಿ.
7107.
ಆನ್ಸರ್ ದಿ ಕಾಲ್. ಎಸ್. ಪೆಂಡಿಂಗ್
My lord, fresh
ಮ್ಯಾಟರ್
matter.
ನೋ ಸ್ಟೇ ಅಂದ್ರೆ ಮಂಡೇ ಬರುತ್ತೆ.
My lord, fresh matter, criminal petition 7107 of 2024.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್ ಯಾವ್ದು ಅಂತ.
As that we have filed in June, my lord.
Monday,
Today
Monday.
there is not listed.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಓನ್ಲಿ ಆನ್ ಮಂಡೇ. ಡೋಂಟ್ ಆಸ್ಕ್ ದಿಸ್ ವೀಕ್.
Already we have filed.
ಇಲ್ಲ
memo,
ಅಂದ್ರೆ
my
ನೆಕ್ಸ್ಟ್
lord.
ಮಂಡೇ. ಎಸ್.
My lord, there is a-
ವೆನ್ ಡು ಯು ವಾಂಟ್ ದಿಸ್ ಮಂಡೇ ಆರ್ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ?
Next Monday, this Monday. my lord.
ಪ್ಲೀಸ್ ಗಿವ್
My lord, sir, filed for vacating stay.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ. ಏನಪ್ಪ ಏನು
I filed for vacating stay. Vacating.
ಫಾರ್ ವಾಟ್ ಸರ್?
ಎಲ್ಲ ಸೀನಿಯರ್.
ಸೊ ವಾಟ್? ಅಂಡ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಸೀನಿಯಾರಿಟಿ ಮೇಲೆ ಬರುತ್ತೆ, ಮೆಮೋ ಮೇಲೆ. ನೋ ಪ್ರಿಫರೆನ್ಸ್ ಹಿಯರ್. ಎಸ್.
ಏನ್ ಮೇಡಮ್ ಅವರು?
ಹಾ, ಸೊ ವಾಟ್? ಸೊ ವಾಟ್? PC Acta. That I have not granted stay. Mother-in-law, there are allegations, I have not granted stay and I will not grant stay. If you want to take the risk, you can take. Yes, give it. I am aware of that case. Memo ಮೇಲ ಏನ್ ಪರವಾಗಿಲ್ಲ. ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್. ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್. ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಡಿ ಮೆಮೊ ಕೊಡಿ. ಯಾವ ಡೇಟ್ ಇಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡಿಲ್ವಾ? ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ. ಮಂಡೇ ಬರುತ್ತೆ ಕೊಡಿ ಮೇಡಮ್. ಎಂಟ್ರಿ ಮಾಡಿ ಇಲ್ಲದೆ ಇರೋದು ಏನಿದೆ ಮಂಡೇ ಹಾಕಿ. ಪ್ರಿಮೆಚೂರ್ ರಿಲೀಸ್ ಅದು. ಎಸ್.
Entry ಮಾಡಿಲ್ಲ ma'am. Stay application is pending for consideration.
ನಾನೇ ನೋಟಿಸ್ ಮಾಡಿರೋದಾ? ತೊಗೊಳ್ಳಿ. ಎಸ್, ಕೊಡಿ.
My lord, I had filed for vacating stay. I've handed over the.
ವಿಚ್ ಇಯರ್ ಸರ್?
2023, I filed for.
ಟುಮಾರೋ. ವೇಕೆಟಿಂಗ್ ಸ್ಟೇಸ್ ಎಲ್ಲ ಟುಮಾರೋ ದೆಲ್ ಕಮ್.
Fresh matter.
ಮಂಡೇ ಸರ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮಂಡೇ ಕೊಡಿ ಅಲ್ಲ.
Vacating of state.
And if they are FR numbers, they won't come on Monday, go and comply. Yes.
Revoking of stay, 2024 matter.
All of you put together will sing a song. Wait, sir. Somebody is making a mention, wait. Yes. 138 ಅಲ್ಲ. Accused 138 ಅಲ್ಲ. Police station ga. ಯಾರು? Which police station?
Jalali police station.
ವೈ 138 ಅಲ್ಲಿ ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಕ್ ಶುರು ಮಾಡಿದೀರಾ? ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಕೊಡಿ. 230 ತಗೊಳ್ಳಿ. ಎಸ್.
My lord, respondent police is calling daily.
ಆನ್ಸರ್ ದ ಕಾಲ್ ಮೇಡಮ್. ನೋ ಮಂಡೇ. ಎಸ್.
Last week you gave a
ಮಂಡೇ.
130
Monday.
proceedings, my lordship. The company party ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ false submission.
Monday.
1 and 2 ಅಂತ ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ ಇದೆ.
ರೆಸ್ಪಾಂಡೆಂಟ್
ಹೌದು, respondent.
ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ sir.
ಹಾಕ್ಬಿಟ್ಟು ಬನ್ನಿ. ಎಸ್.
Monday kindly.
ಹಾಕ್ಬಿಟ್ಟು ಮೂವ್ ಮಾಡಿ.
Limitation.
ಹಾಕ್ಬಿಟ್ಟು ಮೂವ್ ಮಾಡಿ.
Please.
Yes.
fresh matter.
Swami,
Wait,
revoking of
ah.
stay, Swami.
Huh?
Revoking of stay, 2024 matter pending.
ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀರಿ.
24 ಅಂದ್ರೆ ಫ್ರೈಡೆ ಬರುತ್ತೆ ಬಿಡಿ. ಎಸ್.
The petitioner is a senior citizen. And he-
ಫ್ರೆಶ್ ಆರ್ ಪೆಂಡಿಂಗ್ ಸರ್?
Fresh, my lord.
ಮಂಡೇ.
The urgency, my lord.
ಏನು ಸೀನಿಯರ್ ಸಿಟಿಜನ್ ಆದ ತಕ್ಷಣ ಅರ್ಜೆನ್ಸಿನಾ?
The proprietor of a real estate firm.
ಸೊ
Now a disgruntled former director of the firm, my lord, has set the criminal law.
ಆಲ್ ರೈಟ್. ಸೊ ವಾಟ್?
My lord, because the law.
Bail ತಗೊಂಡಿಲ್ವಾ? ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ? ಬೇಲ್ ತಗೊಂಡ್
Then
then leave it.
he's also
Monday.
an influential person, my lord. that-
ಮಂಡೇ. ಎಸ್. ಮಂಡೇ. ಎಸ್. ಎಸ್.
Trial prisoner,
ಹಾ?
trial prisoner.
ಹಾ.
We had made a request for home cooked food. Writ petition was filed, and the court directed us to approach the magistrate.
ದರ್ಶನ್ ದ.
Yes.
ಹಾ.
Filed a criminal petition.
ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಫಾರ್ ವಾಟ್? ಕ್ವಾಶಿಂಗ್.
We have sought to, setting aside the order passed by the learned magistrate now.
ಹೂ ಇಸ್ ರಿಜೆಕ್ಟೆಡ್ ಇಟ್ ನೌ.
Rejected. But he's
Ah.
unwell, that is my instruction, is unwell and.
Ah.
Seeking for an interim order.
Interim order for what?
We are seeking for an interim order. In fact, doctor now recommends that he should be supplied with. Lots of, I'll be in a position.
No. That's, see, all right. You ಕೊಡಿ, ಅದು ಯಾವಾಗ ಬೇಕು ಅವಾಗ ಕೊಡಿ, ತೊಂದರೆ ಇಲ್ಲ. ನಾಳೆ ನಾಡಿದ್ದು ಯಾವಾಗಾರು.
Tomorrow.
ವೆನ್ ಸ್ಟೇಸ್ ಗ್ರಾಂಟೆಡ್ ಏನಾಗ್ಬೇಕೀಗ? ಕಸ್ಟಡಿ. ಈಗ ಏನ್ ಬೇಕು? 311 ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕಂತ. ಆಯ್ತು 230 ತಗೊಳ್ಳಿ. ಯಾರು ಸ್ಟೇಟ್ ಪಾರ್ಟಿನ ಬೇರೆ ಯಾರು ಪಾರ್ಟಿ ಇದಾರ? ಆಗ ನಾಳೆ ತಗೊಳ್ಳಿ. ಯಾವತ್ ಬೇಕು ಮೇಡಮ್? When do you want? No, whenever you want settlement will take. ನಾಳೆ ಬರುತ್ತೆ. Why? Student? You may be ready, everybody are ready, madam. What is the, is the criminal case coming in the way of his career? Madam, ಅದು ಫ್ರೈಡೆಗೆ ಹಾಕಿ ನಂಬರ್ ಕೊಡ್ಬೇಕು. ಫ್ರೈಡೆಗೆ ಹಾಕಿ ಅದು ಯಾರ್ದು? ನಾಡಿದ್ದು? ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಮಂಡೇ ಎಸ್, ಇದು ಮಂಡೇನೆ. ಕಂಪ್ಲೈ ಆಗಿದ್ರೆ ಬರುತ್ತೆ ಮಂಡೇ ಬರುತ್ತೆ.
Lots.
I'll call the case. ಯಾವುದು ರಿವಿಷನ್? ಯಾವ್ದು ಇದು? ಫಾದರ್ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡೇ ಬಿಟ್ರ? ಆಯ್ತು ಸರಿ, ಆಯ್ತು. ನಾಳೆ ಕ್ಲೋಸ್ ಆಯ್ತು. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಮೇಡಮ್ ಒಂದು RP ಇದೆ, ಅದು ಇದು CH ಜಾಧವ್ ಅಪಿಯರ್ ಆಗಿದೆ.
Serial number 35, my lord.
You want to withdraw? Adjournment?
No, I have adjournment, my lord.
Adjournment?
Please.
Mention when it is called.
I have issued NOC, my lord.
You may have done anything. Mention when it is called.
Serial number 80.
Withdrawal ಇದ್ರೆ ಮಾತ್ರ ಕೊಡಿ. Yes. Withdraw. List 2 ಇದೆಯಾ? ಏನು ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಕರ್ದ್ಬಿಡಿ. List.
List number 2, order still number 1.
ಯಾರಿಲ್ವಾ? A week's time to comply with the office objections.
Number 2,
ಇದರಲ್ಲಿ office objection, my lord. I have mentioned the age of the petition.
Overruled Monday.
number 3. Petition or my.
Overruled Monday.
Number 4,
Number 3, Sneha's mentioned as Lata in the police FIR.
Huh?
Petition number 3, name of petition number 3 is mentioned as Lata.
Monday. Yes.
Fine.
Next.
I appear to the petitioner. I made all the accusers pro forma respondents. In fact,
Delete them. Who asked you? ಹೊಸ trend start ಮಾಡಿದ್ದೀರಾ? All other accused, if accused number 3 is there, all 10 accused as respondents. What is this? Yes.
the 3 other matters are connected.
Office objections be complied with in the 2 days time is granted to comply with the office objections. In the event the office objections stand complied, list this matter on Monday in the fresh matters list.
Fellows, can it be on 28th?
You can't, it can't be, sir. Yes. Monday, yes.
6,
Overruled Monday.
7,
Companies feel like that.
Company seal. With 2 days time is granted to comply with the office objections. In the event they stand compliant, list on Monday in the fresh matters list without a memo moved before this court. Next. Office objections, maintainability stands overruled. List the matter on Monday in the fresh matters list.
2nd,
ಅಲ್ಲ, even otherwise, correct. ಅವರು PNDT ಅಂತ ಕೊಂಡು 2 days time is granted to comply with the office objections. In the event they stand compliant, list. Sir, ಬೇರೆ ಎಲ್ಲ ಇದೆ. ಬೇರೆ 4 objection ಇದೆ. ಮಾಡಿ, yes. Learned counsel for the petitioner submits office objections have been complied with office to verify and list the matter on Monday in the fresh matter list in the event they stand compliant. Next.
10,
Maintainability overruled Monday fresh matters list. Next.
11,
But earlier I challenged the FIR into the crime stage.
Overruled Monday, fresh, ಬೇರೆ ಏನಿದೆ? ಅದೊಂದೇನಾ? The office objections que maintainability stands overruled. Insofar as the other objections are concerned, the petitioner is granted 2 days' time to comply with the same. In the event they stand complied, Monday fresh matters list without a memo.
Connected matter is there.
Civil dis, office objection ಬಂದಾಗ merits ಮೇಲೆ ಎಳ್ಳೇಬೇಡಿ. Typed copy of all manuscripts ಮಾಡಿ.
ಇದೇನ್ serial number ನೋಡಿ.
ರೀಡಬಲ್ ಇದೆಯಾ? ಯಾವುದು? ರೀಡಬಲ್ ಇಲ್ಲ ಅಂದ್ರೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿಲ್ಲ ಅಷ್ಟೇ. ಲಿಸ್ಟ್ ಓವರ್ ರೂಲ್ಡ್ ಮಂಡೇ.
13,
Prayer column.
ಪ್ರೇಯರ್ ಕಾಲಮ್ ಏನು?
ದೊಡ್ಡದಾಗಿದೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಚಿಕ್ಕದ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಬಟ್ ವಿ ಕಾಂಟ್ ಡೂ ಇಟ್.
ಓವರ್ ರೂಲ್ಡ್ ಮಂಡೇ.
ಒನ್ ಸಬ್ಮಿಷನ್.
ಇವತ್ತೇನ್ ನೋ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕೇಳೋದೇ ಇಲ್ಲ.
ಫಸ್ಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಫೈನಲಿ ಅಂತ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕೋಸ್ಕರ
ಯಾಕೆ ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ಅದು ನಾವು ಅವಾಗ್ಲಿಂದ ಟ್ರೈ ಮಾಡ್ತಾ
ಯಾವ ಟ್ರೈ ಅಲ್ಲ, 11th June ಫೈಲ್ ಮಾಡಿರೋದು, ಅಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ಟ್ರೈ ಮಾಡ್ತಾ
ಏನಕ್ಕೆ ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ರಿ?
ಪೋಸ್ಟಿಂಗ್ ಟ್ರೈ ಮಾಡಿ
ಫೈಲ್ ಮಾಡಿರೋದೇ 11 Juneಗೆ, ಏನ್ ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ರಿ ಆಮೇಲೆ?
ಅದಕ್ಕೋಸ್ಕರ ಫೈನಲಿ ಇದು ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಮ್ಯಾಟ್ರ್ ಏನು?
138 ಮ್ಯಾಟರ್ ಅಲ್ಲಿ 91 ಇದರಲ್ಲಿ 91 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ.
ಯಾವಾಗ ಹಾಕಿದ್ರಿ 91 ಅಪ್ಲಿಕೇಶನ್? ಅಟ್ ದಿ ಫ್ಯಾಗ್ ಎಂಡ್ ಪಾಸ್ ಓವರ್. ಎಸ್. ನೆಕ್ಸ್ಟ್
14,
is your file?
That is the reason I'm mentioning a lot. This is not filed by me, it has been tacked on to me.
Tagged on to you? ಗುರುನಾಥ್ ನೀವಲ್ವಾ?
Second is serial number 14.
Shashi Kiran.
Correct.
You are not Shashi Kiran?
I'm Shashi Kiran, but it's tagged on to me, SMS is also being delivered, but I have not filed this.
The Lochana S. Babu is the advocate. It's wrong, wrongly listed. Registry to appropriately list the name of the advocate who has filed the case, responsibly list, yes. Adralena will office objections overrule ಮಾಡ್ತಾರೆ.
15,
No, office 2 days time to comply with the office objections. Next. Overruled Monday.
16,
Maintainability ಯಾಕೆ? Overruled Monday.
17,
Lord, in this case, the 91 crime, 91 and 1991.
My lord, sir, I appear for respondent number 2.
You appear on Monday, madam. I'll post it on Monday. Second,
Order sheet available in the trial court record is after when the case is registered in the LPC. So prior to that, 91 to 98, because the order sheet is not available in the trial court.
Overruled Monday.
18,
So section 125 proceeding after a mutual consent of divorce. 125
Overruled Monday.
18,
Second petition. No representation list after 4 weeks. Yes.
20,
petition. There was a notification by the Honorable CMM Court that that circumstance, so the matter is pending adjudication on the file of 9th ACM. Earlier it was on the file of 7th ACM.
Overruled Monday.
21,
Overruled Monday. Monday, but Tuesday. Yes, next Tuesday, madam.
Last date proceedings I have downloaded copy, madam.
Overruled Monday.
23,
ಹೀಗಿದ್ರಲ್ಲ ಇಲ್ಲಿ 23. ಹಿರೇಮಠದ್. ಅದೇ overruled Monday.
24,
Relevant portion of that.
Monday.
55.
But address shown in the Aadhaar card was the old one. Now the present address is the cost title address.
Monday.
26.
All pages are sought for typed copy. Anyway, I'm complying that also. In fact, I said I'm not laying upon, but now I,
If you rely, we will reject the interim order.
no, I'm filing the.
Registry ಮಾಡ್ಬಿಡಿ. 2 days time, learned counsel submits that 2 days time is granted. If 2 days time is granted, the office objections will be complied with. Complied with. In the event they stand complied, list the matter on Monday in the fresh matters list, without a memo. Same, yes.
58.
Downloaded order sheet already.
Overall Monday. ಅದೊಂದೇನಾ? Yes, Suyog, ಏನಿದೆ?
59.
Why did you come in? Adjournment ಕೇಳಕ್ಕ? You missed the bus, wait. Yes,
Challenging the charge.
overall Monday. Yes, madam.
Appear for petitioner, madam. Age and.
Overall Monday.
51.
The second dead person made a per se objection. I mean, permit you to deal with second respondent.
Learned counsel seeks, learned counsel submits that he would delete the second respondent.
Dead
ಯಾಕೆ
person.
ಕಂಪ್ಲೇಂಟ್ ಬೇಕಲ್ಲ?
Complaint, ಯಾಕಂದ್ರೆ he has to, I'm the owner of the vehicle, my friend has taken the vehicle.
Third respondent, sir,
Third.
not needful to be done in the next 2 days. In the event it is complied, list the matter on Monday in the fresh matters list.
52.
For petition, my lord. Case number mentioned in the charge sheet is on. It's a 8782.
Monday. Next.
33.
The petitions, I produced the Aadhaar card for each.
Present address. So? Monday, yes.
34.
Monday. No petition. 2 weeks time to do the needful. Next.
36.
I appear for the petitioner. Three, respondent 3 is the owner of the property on whose power of attorney I executed the sale deed. Respondent number 4 is person in whose favor I have executed various sale deeds, which the complainant says are based on the forged document.
Keeping open the office objections list on Monday in the fresh matters list. Next.
37.
Monday.
38.
For petitioner, my lord. To engage in senior counsel.
For office objections.
No.
ಮತ್ತೆ? No merit, sir. Yes. Maybe, sir. Engage him for Monday. When is the next date? Saturday. You think Saturday? Kerwood Bunny. Password. Yes.
39.
Monday. Overruled Monday.
For the petitioner, objection may be overruled, my lords, for the reason, my lords.
Overruled. Monday.
Stay, my lord.
Stay. Why?
GST authorities, my lords, are threatening to file an report, my lords.
Enforcement.
Enforcement.
Password.
42.
Overruled Monday.
43.
For the petitioner. Without making me, I am a complainant before the police, without making me a party in the petition proceedings. The respondent, the petitioner has obtained an order to release the gold in.
ಇದೇನಿದು
I have filed a review.
ರಿವ್ಯೂ ಪೆಟಿಷನ್ ಏನಾಗಿದೆ ರಿಲೀಸ್ ಆಗೋಗಿದೆಯಾ?
My lord, there are 3 PF numbers, out of that 2 PF numbers.
Where is the order?
The order is at page 14.
ಮುತ್ತೂಟ್ ಫೈನಾನ್ಸ್
Yes.
ಲಾಂಗ್ ಬ್ಯಾಕ್ ಆಗಿರೋದು 12 January
Yes, my lord.
GM ಅಲ್ಲಿ.
Yes, my lord.
Huh.
When we filed an application before the magistrate for release of the gold,
ಹಾ
they came in to furnish this order copy. And as per the order of this honorable court, some portion of the gold has been released in their favor. And all this gold has been stolen from my shop, my lord. And accused was arrested.
ಆಯ್ತು ಇವರು ಸರ್ವ್ ಆನ್ ದಟ್ ವೆಂಕಟರಮಣ
Yes, sir.
learned counsel for the petitioner to serve on the counsel who represented the petitioner in the writ petition or any other counsel appearing for Mrs. Muthoot Finance Limited. We will stay this order now. ಇನ್ನು ಮಿಕ್ಕಿದ ಗೋಲ್ಡ್ ರಿಲೀಸ್ ಆಗಬಾರ್ದ ಮೇಲೆ
Release agide with the condition of whatever they imposed by the
Whatever.
honorable court.
operation of the order in writ petition 1015/2024 shall remain stayed. List on Friday in the fresh matters list. Office objection stands overruled. Next,
44.
Appearing for respondent to. Yesterday I have received copies. Rest time file objections.
1 minute.
Wakalat.
This is
Monday.
244. My lord, this is a split up charge sheet. Companion accused is already acquitted.
So what?
The split up, my lord, the other petition.
So what?
But the proclamation, my lord, issued against me.
So what? Why did you not appear?
My lord, I was in the US, I was
Second-
one of the
second
directors of the
respondent.
company. I was in
All
the US,
right.
I did not even.
Nim second list of
Second
first,
respondent.
second list of first list, sir.
First list.
With second list, wait. Yes. You were in the US.
I was-
List tomorrow and the fresh matters list. Office objections stand overruled ಅಂತ ಮಾಡಿ ನಾಳೆ. Yes.
55.
The name. Surname.
Monday overruled. Next.
56.
My lords, relevant.
Overruled Monday.
Grateful.
47.
The entire charge sheet has been
Not produced.
produced, but the date of arrest and date of release has been mentioned.
Whether any case file pending, you can't write that, is it?
From the petition.
You can't write that? Yes, 2 days to comply with the office objections. In the event they stand complied, list the matter on Monday without a memo being moved before this court. Yes, before the court. Next,
48.
The objection is with respect to better copy of annexure.
blank set synopsis, better copy. 2 days time is granted to comply with the office objections. In the event they stand complied, list the matter on Monday in the fresh matters list without a memo being moved. Yes, next. Parvala. ಬೇರೆ ಇದೆ ಸಿನಾಪ್ಸಿಸ್ ಎಲ್ಲ ಬ್ಲಾಂಕ್ ಬಿಟ್ರಿ, ಯು ಆರ್ ನಾಟ್ ರಿಲೈಯಿಂಗ್ ಆನ್ ದ ಸಿನಾಪ್ಸಿಸ್?
That is over the course of time.
No, do it. Yes,
59.
ರಿಟ್ ಪೆಟಿಷನ್ ಪ್ಲೀಡಿಂಗ್ ಕೇಳ್ಬಿಡಿ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೊಟ್ಬಿಡೋಣ. ಎಸ್,
But 49 was only annexure A is. Not
overruled Monday.
plus the petitioner, kindly for tomorrow.
ಯಾಕೆ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
Yes.
ಏನ್ ಅರ್ಜೆನ್ಸಿ?
Plus, petitioner is the director of a hospital who manages the day-to-day affairs.
ವಾಟ್ಸ್ ದ ಪ್ರಾಬ್ಲಮ್ಸ್? ನಾಳೆಗೆ ಏನು?
Problem is the help of police, they are not allowing to carry out the operations of the.
ಆಯ್ತು, ಟುಮಾರೋ ಇನ್ ದ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಎಸ್. Office objection sustained. ಶ್ರೀನಿವಾಸ್, ಏನ್ ಹೆಡ್ ಆಫ್ ದ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಗಿಲ್ವಾ? What logic is this? Who is the de facto complainant? Complainant ಅವರೇನಾ? ಲೋಕಾಯುಕ್ತ. Overruled Monday. Yes. ಏನ್ ನಿಮ್ಮನ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದಾರಾ ಸರ್? ನಿಮ್ಮನ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದಾರಾ?
Police notice ಕೊಟ್ಟಿದ್ದಾರೆ.
ಪರವಾಗಿಲ್ಲ. Yes.
Retired about in 2011 and 2014.
Tomorrow in the fresh matters list. Yes.
Matter still number 1.
Where were you, sir? It's my Monday ಹಾಕಿದೀವಿ.
Time for compliance ಅಂತ.
ಮಾಡಿ.
The only objection is that inside copy extract of the order sheet has been produced, my lords.
Whatever, yes. Compliant, order ಆಗಿದೆ. Next.
Matter still number 1. This one.
I remember withdraw. Charge sheet has been. Charge sheet has been filed.
ಮತ್ತೆ ಯಾಕೆ ಹೇಳಿಲ್ಲ ಅದು even before filing of the petition ಆಗಿರೋದು. So, yes. ಅವ್ರು ಹೇಳಿದ್ದದ್ನ.
I did not, I verified it.
Dispose with liberty.
Higher petition. 76 and 420 MIPs.
65 ಲಕ್ಷ ವಾಪಸ್ ಕೊಡ್ತೀರಾ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದೆ, ಅದನ್ನ ಹೇಳಿ ಫಸ್ಟ್. ಐ ಡೋಂಟ್ ಫರ್ಗೆಟ್ ಸರ್.
12 ಲಕ್ಷ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ರಿ ಬಿಫೋರ್
ಮಿಕ್ಕಿದ ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಅಂತ ಕೇಳಿದೆ. ಕಾನ್ಸೆನ್ಷುಯಲ್ ಅದೆಲ್ಲ ಇರ್ಲಿ. Why did you take 65 lakhs?
12 lakhs has been paid. She suppressed that fact and filed the complaint.
That's all right. Pay the remaining.
Notice was barely soon.
But pay the remaining.
But it's hell.
ಪರವಾಗಿಲ್ಲ. I'll believe you. 12 lakhs ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ.
12 lakhs.
Huh?
12 lakhs.
ಅದೇ 12 lakhs ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ I'll believe you.
Before filing the complaint, we have.
ಇನ್ನು 53 ಲಕ್ಷ ಸರ್. 53 lakhs ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
Not fact that the petitioner has lost his job. Financial crisis.
No. Then you face trial. No problem. 376 ಇದೆ ಹೆಂಗೋ.
376, your lordship.
ಅದ್ ನೋಡೋಣ.
The last
Sir,
date of it when I.
You want me to, I'll dismiss it, no problem. You face trial. ಅವಾಗ ಫೈನಾನ್ಷಿಯಲ್ ಕ್ರೈಸಿಸ್ ಎಲ್ಲ ಕ್ರೈಸಿಸ್ ಸರಿ ಹೋಗುತ್ತೆ.
ಅಲ್ಲ 420 ಬಗ್ಗೆನೇ ಏನಾದ್ರು ಹೇಳೋದಿದೆ ಅಂತ ಕೇಳಿ.
No.
For the last 2
ವಾಪಸ್.
years they were in relationship.
ವಾಪಸ್ ಮನಿ
Date ಕೊಡಿ sir. Stay ಮಾಡಿ ಒಂದು date.
ನೋ ಸ್ಟೇ ಮಾಡೋದೇ ಇಲ್ಲ.
Stay ಇಲ್ಲ ಅಂದ್ರೆ the proceedings will begin in the trial court.
Let it begin, sir. The pinch should be known, only then you will come out with money. Consensual acts, all that is fine. Why did you take money and not return it? Complaint ಹಾಕ್ತಾ ಇರ್ಲಿಲ್ಲ ಅವರು.
That's what she said in the.
Complaint ಹಾಕ್ತಾ ಇರ್ಲಿಲ್ಲ.
That's
Sir,
true. Even
to
we are
any,
saying in the
to any
complaint.
lady, 65 lakhs is too much, sir. Please give it. Otherwise, I'll send you for trial. Consensual acts, everything is fine.
Court tomorrow.
See, these financial transactions, cheating the lady and assaulting the lady. There's no license, sir, for all this. Consensual acts you have.
Tomorrow you sit down for chat. They
Very
become
good.
charged for the trial.
Correct. ತೊಂದ್ರೆ ಇಲ್ಲ.
You want to mobilize the funds, you may request.
No problem, sir. That will be subject to the results.
Even the artery is not appearing before this court in spite of service of.
ನೋಡೋಣ, sir. Why are you worried?
At least we can have negotiate with them.
ಅವ್ರ ಹತ್ರ ಎಲ್ಲ ಕ್ವಶನ್ ಕೇಳ್ಕೊಂಬಿಡಿ, ಎಲ್ಲ ಒಂದೇ ಸರಿ ಹೇಳ್ಬಿಡಿ.
Then my learned friend can secure the second respondent, we can have it.
No, you first deposit it here.
Yeah, ಅದು ದುಡ್ಡು ಅವರು 65, they claim that 65 lakhs.
ಹೌದು,
I have paid 12 lakhs
ಆಯ್ತು
by bank transfer.
ಆಯ್ತು.
They have suppressed those.
ಅದು
funds
ಬ್ಯಾಂಕ್
and
ಟ್ರಾನ್ಸ್ಫರ್, ಇದು ಬ್ಯಾಂಕ್ ಟ್ರಾನ್ಸ್ಫರ್. ಸೊ 53 ಲಕ್ಷ ಬಾಕಿ ಇದೆಯಲ್ಲ.
ಆಯ್ತು, 40.
ಹಾ
40.
43. 65ಕ್ಕೆ 12 ಹೋದ್ರೆ 43 ಹೆಂಗಾಯ್ತು?
53.
22 12 ಕೊಟ್ರದ್ದು. 65ಕ್ಕೆ 12 53. ಮ್ಯಾಥಮೆಟಿಕ್ಸ್ ಎಲ್ಲ ಅಷ್ಟೊಂದು ವೀಕ್ ಇಲ್ಲ.
At least still next date of hearing it all.
ಮೊಬಲೈಸ್
Mobilize ಮಾಡಕ್ಕೆ ಸ್ವಲ್ಪ time.
ಇಲ್ಲ, ಅದು ಸ್ಟೇ ಕೊಟ್ಬಿಟ್ರೆ ಮೊಬಲೈಸ್ ಆಗಲ್ಲ.
Stay ಕೊಟ್ರೆ at least the proceedings will be started.
No.
Then I have an opportunity to mobilize the fund.
No problem, sir. Return the money to the lady.
Huge amount.
Why did you take huge amount, sir?
Yes.
Why did you take huge amount? These acts, I can hold. Consensual act alla anta I can definitely hold. It's only 2-year relationship with nothing.
Correct.
Yes,
Only
That's it.
the thing remains for to.
no problem. Money. Give it back. List, ಯಾವಾಗ 2 weeks ಕೊಡ್ಲಾ, 3 weeks ಕೊಡ್ಲಾ?
2 weeks.
ಆಯ್ತು.
Stay ಕೊಟ್ಟಿಲ್ಲ.
The learned counsel appearing for the petitioner submits that the matter is set for framing of charges tomorrow. the issue is that the petitioner, on the pretext of a relationship between the with the complainant, has taken 65 lakhs from her, and therefore the offense of section 420 is laid against the petitioner. The learned counsel submits 12 lakhs is already paid. The remainder, even according to a simple calculation, is 53 lakhs. Therefore, 3 weeks' time is granted to the petitioner to seek learned counsel of the petitioner to seek instructions as to whether the amount would be returned to give a quietus to the entire problem. The framing of charges that the charges that are framed by the concerned court will, however, remain subject to the result of the subject petition. No stay. Nadili. Notice ಆಗಿದೆಯಾ? ಹಾ.
Await ಇದೆ.
ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
3 is the relaxation of condition.
This you want to go out and
My daughter is there and come back.
where is the travel itinerary? Affidavit, travel itinerary, all that you file, then we will consider.
Relaxation of that condition.
For that itself, sir. I don't blanket relax madode illa. Yes.
Connected petition, my lord. In fact, I have been illegally arrested and detained.
Adu we will answer that. Now you file an affidavit, I'll take it on Friday. We'll send it. Yes.
Friday some inconvenience next week.
Our travel ನೀವು ಹೋಗ್ತೀರಾ ಜೊತೆಗೆ?
ಅಲ್ಲ ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ
ಅದು ನೋಡೋಣ. ಈಗ ಅವ್ರು US ಗೆ ಹೋಗಕ್ ನಿಮ್ದೇನ್ ಪ್ರಾಬ್ಲಮ್?
ಅಲ್ಲ ನಮ್ದೇನ್ ಅಬ್ಜೆಕ್ಷನ್.
ಮತ್ತೆ ನೀವು ಜೊತೆಗೆ ಹೋಗ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ಫ್ರೈಡೆ ಹಾಕೊಡ್ತೀನಿ.
ಅಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟ್ರ್ ಇದೆ ಅದರಲ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ ಟೇಕ್ಸ್ ಅಪ್ ದಟ್ ಮ್ಯಾಟರ್.
We'll see. I won't take up any matter, sir. Only this.
Please.
If he files an affidavit, I will permit him to travel. Yes.
In fact, the effect of relaxation of the condition is passport in my favor. The passport and inform passport inform voting power illa.
Who has impounded the passport? Court has impounded.
ಅಲ್ಲೇ ಇದು ಮಾಡುದು.
Illegal. Court cannot impound passport.
That's what they said.
Friday man. But your affidavit, ವಾಪಸ್ ಬರ್ಬೇಕಲ್ಲ. Friday in the fresh matters list. You need not come, sir.
Please.
P
138 proceedings.
P1 is a company balance.
All right.
P2 and P3 are the present directors.
All right.
R1, R2 were the past directors, my lord.
ಯಾವುದು?
R1 and R2.
All right.
But R1, my lord, and he resigned on 1/1/2019.
R1.
Respondent number
The
one.
complainant.
ಆಯ್ತು, ಕಂಪ್ಲೇನೆಂಟ್. ಸರಿ.
And the R2 has resigned on 14/12/2019.
All right.
And this entire case, my lord, the lordship may kindly take the page number 68. 68, full and final settlement agreement, my lords.
Full and
Full and final settlement agreement.
page 68.
Page number 68, annexure C.
All right.
my lords.
Hmm.
This, my lords, the first petitioner company is not the authorized signatory. He has not signed this.
ಇದ್ಯಾರು? ಭೂಶ್ರೀ ಚಿಟ್ಸ್ ಯಾರು?
Pusri Chips company is a chit fund company
All right.
where all the four were the directors. And Pusri Chips have not signed this document. And my lords, the third petitioner also has not signed this document.
So,
And my lords may kindly take to, yes, my lord, that's all.
That's
Yeah,
all.
but I'm not liable simply because the company is not.
Ten.
Company is not the authorized signatory. Lordship, may kindly go to page number 75. Lordship,
full and
really-
final, 1 minute.
Yes. Full and final settlement, annexure, see page number 75, last page, very clear. Pusri Private Limited has not signed. The first party has not signed, and the fourth party, my lord, who is the third petitioner hearing, the director, he has not signed. Lordship, may kindly take to the annexure D, next one, page number 77. So it's stated 5/2/2020. My lord, this has been signed by the second respondent director. Then he resigned on 14/12/2019, my lord.
All this is a matter of evidence.
Allude, my lord. And third Third petition, my lord, I'm not even authorized signatory. There are absolutely no allegations against me.
Yes, cross-examine me on all these points.
What stage is it?
My lords,
No.
evidence is completed.
Ah.
Once the evidence is completed, my lords, the petitioner before your lordship should make out another application seeking for further cross-examination. I resisted their application. Despite that, my lords, the application was allowed. My lords, I have not preferred a challenge to that application for this reason, my lords.
Oh, why have you come now?
Challenging these proceedings, my lords, which were instituted in,
proceedings.
please, in 2021. From 2021 until this day, my lords, he participates in the trial. And my lords, all these contentions that my lords, the petitioners are raising today before your lordships have all been, my lords, cross-examined by the petitioners themselves when I stepped into the witness box as a complainant witness.
Lords,
I'm sure my learned friend will not very well.
lords, this petition was filed during 2021, my lord.
Hmm.
During COVID.
Second one, ಯಾವ್ದು 23 ಇದೆ?
What?
Connected matter ಕೊಡಿ madam.
4 different checks under this agreement, my lords. 2 checks under the first proceedings, 2 checks under the second proceeding.
All that
Both
is a
these
matter,
proceedings-
sir, whether you are in charge of the affairs or not there, ಎಲ್ಲ matter of evidence unless there is clinching document here.
Because it's, my lords. See, when a company is not the signatory of the
ಅದೆಲ್ಲ ಅಲ್ಲಿ,
agreement,
and not at this stage.
And these checks belong to the company. May I request my lords to kindly turn to my lords page number 77
Of which petition?
of the first petition itself. 77,
23 ಇದೆ ಇರೋದು. Both you have filed in 2023.
23. They do not move the petition at all.
It's all right, yes.
My lords, may I request my lords to kindly turn to page number 77, my lords.
ಅದೇ ಅದನ್ನೇ ಓದಿದ್ದು.
The checks, my lord. These are the checks belonging to the company. Proceeding under the assumption, my lords, the grounds that are urged by the petitioners before your lordships have some semblance of truth. My lord, that becomes a matter of their defense, which defense they have already taken before the trial court. Because, my lords, my only apprehension, why I am making the submission is this, my lords. The respondent number 1 before your lordships, my lords, was,
If I signed that.
That is the defense that they'll have-
Evidence that has been shown, that is accused about 1.60 lakh rupees, not even one document, not even 1 rupee has been given.
ಅದೆಲ್ಲ ಅಲ್ಲಿ. All matter. I have to, after complete cross examination, not.
For your lordship. It was because of the 3 reasons, my lord. One was it was COVID, and it was where there was effort for mediation. That was the reason why it is delaying me coming before your lordship.
That's all right, whatever it is. But a lot of events have happened there, which I cannot now say is not correct. We'll close it? Yes. The petitioners in both these petitions the parties to the list in both these petitions are common. It is therefore the two are tagged and considered by this common order. The petitioner and others are the accused. The respondent, complainant. Two yaru, second.
2 is the
Accused
companion,
number 3.
companion accused of the
Why
petition.
do you do it? Yes. The first respondent is the complainant. Transaction between the complainant and the petitioner company leads to issuance of certain checks by the petitioner, allegedly certain checks by the petitioners in favor of the complainant. Those having been dishonored leads the complainant to the concerned court invoking section 200 of the CRPC for offences punishable under section 138 of the Negotiable Instruments Act. The petitioner, Negotiable Instruments Act. The proceedings before the concerned court have gone on since 2019.
2020, my lords.
Since 2020 and is said to be at an advanced stage. At that juncture, the petitioner is before this court calling in question the proceedings in its entirety, proceedings in CC 16308 of 2020 in its entirety. The learned counsel appearing for the petitioner would contend that the accused 1, 2, 4 have nothing, accused 2 and 4 have nothing to do with the transaction, as the offense 1 and 4, the transaction arises out of a full and final settlement that was drawn between the first petitioner company and the complainant, to which the accused 1 and 4 are not the signatories. Therefore, against accused 1 and 4, the proceedings are to be quashed. The resign agidya date
2019 is the complainant.
Check. ಇದು ಸೈನ್ ಆಗಿದೆ ಯಾವತ್ತು ಸೆಟಲ್ಮೆಂಟ್?
My lords, the settlement, my lords, is on 4/9/2019.
4/9?
2019. My lords would get the
Oh,
settlement.
they were there in the company.
Please, my lord.
Ah, yes.
I was not there. I was the additional director. My lords, there are more facts, my lords, which may not germane for
So,
consideration of the
The
petition.
learned counsel for the, counsel for the petitioner further submits that the full, the agreement for full and final settlement was arrived at on 4/9/2019. And the petitioner accused number one, four?
Case number 1 is a company.
Accused number 4 in particular was not in the company at all. The learned counsel appearing for the respondent complainant would vehemently refute these submissions to contend that the proceedings before the concerned court are at an advanced stage, and the petitioner on all these points has been cross-examined by the complainant, and at this stage the court
Respondent
should.
number one.
Huh?
Respondent number one.
A respondent complainant,
A respondent number has been cross-examined by the petitioner.
so and so, cross-examined by the petitioners. Another, sorry. Who is cross-examined in that? On all these, learned counsel would submit that on all these grounds, the complainant, respondent complainant has been extensively cross-examined. The matter was set at the stage of arguments, and at that stage, the subject petition is preferred, seeking quashment of the entire proceedings. In the light of the submission of the learned counsel appearing for the respondent and a perusal at the record, since the proceedings before the concerned court are at an advanced stage, and the cross-examination of the complainant having happened at the hands of the petitioners to a large extent on all the grounds that are urged in the present petition, leaving open to the petitioners to urge all these grounds at the time of arguments as well before the concerned court, I deem it appropriate not to interfere with the proceedings before the concerned court, as all the grounds that are now projected before the court would require evidence which has already been concluded before the concerned court.
May I make one
But-
request, my lord, with my lord's leave? My lords, the respondent number one, the amounts that are involved, my lords, the respondent number one had accumulated by selling books, my lords, to the lawyers,
right.
law student. May I
All right.
request my lords to direct the trial magistrate for a time-bound disposal in this
That
matter?
we'll see. ನಿಮಗೂ ಒಳ್ಳೆದೇ ಅದು.
Mugdobro.
Yes. In the light of the issue of the year 2020, the concerned court shall endeavor to conclude the proceedings within 6 months from the date of receipt of the 6 months ಯಾಕ್ ಬೇಕಾದಕ್ಕೆ?
3 months.
ಎಲ್ಲ ಆಗೋಗಿದೆ.
Argo-
3 months from the date of receipt of the copy. ಆಯ್ತು, 4 months from the date of receipt of the copy of the order, if not earlier. All contentions of both the parties that are projected in these petitions, projected in before this court shall remain open to be urged before the concerned court at the appropriate time.
I'm very grateful.
Yes.
Hold on.
Five.
Proclamation. Why?
82.
Oh, ಇದು
Stricter
bail.
sense it is not been complied.
ಅಲ್ಲ, ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
Allowed, but they will levied 2 lakh rupees fine, but your lordship sees section 82.
They should be able to pay ಅಲ್ಲ. And bailಗೆ.
Allala, but your lordship sees section 82. There are procedure for issuance of proclamation.
That is what the order is contrary to that.
Yes, not followed any of them, especially subsection 2.
The petitioner is before this court. Will dispose it then. Before this court, calling in question an order dated, one moment, 21/11/2023, passed in SC 974 of 2023, issuing a proclamation against the petitioner. The petitioner, witness,
Like he is accused.
accused.
Accused number 6.
The petitioner is accused number 6 in a crime which is pending before the concerned court in SC, in a criminal case, in a sessions case in SC 552 of 2023. Split up charge sheet.
Split up charge.
Close amount.
Allah, but that main case is still.
Anyway, yes, so split, which is on a split up charge for offences punishable under so and so, para 3 allide, madam. The issue that has driven the petitioner to this court in the subject petition is that that a proclamation being issued against the petitioner 2 lakhs ಏನಕ್ಕೆ?
That is a fine they've levied for non-appearance.
I think, madam. The issue, it is an admitted fact that a split up charge sheet was drawn against the petitioner on account of his non-appearance before the concerned court. And an application was filed on behalf of the petitioner to recall the said order of proclamation, that comes to be rejected. And the petitioner is sentenced to pay rupees 2 lakhs and is now back into the judicial custody. It is this that is called in question by the petitioner before this court. The learned counsel appearing for the petitioner would submit that the order of proclamation passed by the concerned court is in complete contravention of section 82 of the CRPC. The learned additional SPP would also accept it. We'll say that.
Yes.
Learned additional SPP would also accept the fact that the procedure stipulated under section 82 of the CRPC has been given a go by the concerned court while issuing a proclamation against the petitioner accused number 6, who is said to have not appeared during the process of the trial. Section 82 of the CRPC reads as follows. The section 82 depicts certain procedure prior to issuance of proclamation. A perusal at the order impugned would clearly indicate that none of the procedure that is stipulated in subsection 2 of section 82 is even been followed to its semblance in the case at hand. The order of the concerned court dated 21/11/2023 reads as follows.
Your Lordship, may I have to record this 7/9/2029.
7/9, huh?
Yes,
That page.
just before the previous page, my lord. Page 12. Issue proclamation against accused number 5.
Reads as follows. The orders that led to issuance of proclamation reads as follows. Page 13. Amale 27/11 order. That is page 18. The perusal at the orders would clearly indicate that section 82, as observed here and above, is not followed by the concerned court. Solely on the score that the procedure stipulated under section 82 is not followed, the petition deserves to succeed. The order dated 21/11/2023 passed and so stands quashed. However, liberty is reserved to the concerned court to initiate proceedings in the event of necessity.
He has to file a fresh application for bail. And now the bail application also been
The
rejected.
proclamation agovidella, correct.
ಹೌದು.
The petitioner is at liberty to file in the light of the quashment of the proceeding, quashment of the orders quoted here and above. The petitioner would now be at liberty to file an application seeking his enlargement on bail. And the concerned court shall consider the same and pass necessary orders in accordance with law without any further delay. Yes. Next. Covered ಇದು.
No, it may not be, my lord, because
Covered ಅಲ್ಲ ಇದು. ಅದರಲ್ಲಿ 188 ಇತ್ತು, 188 ಇಲ್ಲ ಇದರಲ್ಲಿ. No, it's not covered at all.
307 is offense.
307 ಇದೆ.
Yes.
Correct.
There was no 307.
There is no material for
No, that we'll see. Covered ಅಂತೂ ಅಲ್ಲ. Learned additional notice ಆಗಿದೆಯಾ? ಇಲ್ಲ. Learned additional SPP is directed to accept notice for the respondents to go through the papers and make his submissions, post the matter for admission on 28th August. Yes, next. One 38.
We permitted to withdraw 7.1 please. Since the trial court has already dismissed the
7.1. What ground is there in 7?
there is no dispute in issuance of the check.
Yes.
But issuance of the check was given to and purchase of a property, two property which is owned by the present petitioner and the children.
Wait, yes. So petitioner to serve 7.1 is withdrawn. petitioner to serve set of papers upon the counsel who represents the respondent in the trial proceedings and file an acknowledgement by Friday. List the matter on Tuesday in the fresh matters list. Yes. Next date, yavat? No problem, right?
No.
Yes.
Since the notice is not served on, because there is no representation by the advocate nor the party before the trial.
Yaru ilva? Then
None
sir,
of them are appearing before the trial court. hence-
appearing, we'll see, yes. Next. Guidelines idya ilva?
The guidelines is what the Union of India is formed. Same guidelines we are following.
You have followed,
Yes, sir.
you have adopted rather.
You adopted the same guide.
So then nothing has happened.
No, it is happening in accordance with the guidelines. sir.
Happening ಅಲ್ಲ ಇಲ್ಲೇನ್ ಆಗಿಲ್ವಲ್ಲ ಅದು?
ಇದ್ರಲ್ಲೂ ಆಗಿದೆ.
ಏ,
They've issued-
ಹೇಳಿ.
They've issued a notice.
Ah.
Here, my lord, issue is not that the alleged, the kid petitioners are not being prosecuted as sex determination. Rule 8, Rule 9 and Rule 12 prescribe certain procedure to be followed while establishing the diagnostic centers. The rules also mandate that you should have a act book kept there. Rules also should mandate that displaying all the required rules and regulations. And case here, my lord, he has not followed any of those things.
ರಿಜಿಸ್ಟರ್ ತರಕ್ ಹೇಳಿದೆ.
Registry illa.
ಸೀಸ್ ಮಾಡಿದ್ದೀರಾ?
Your lordship, see the notice which we have issued, page
ಪೇಜ್?
page 30, my lord. 31 is the,
ಕರೆಕ್ಟ್.
17, my lord. Page 31. OB.
ಸ್ಕ್ಯಾನಿಂಗ್ ಮಾಡಿಸ್ಕೊಂಡು ರಿಜಿಸ್ಟರ್ ಪುಸ್ತಕ ಇಟ್ಟಿರುವುದಿಲ್ಲ.
ಇರುವುದಿಲ್ಲ.
ಹಾ.
They have not kept the register and then form F ಅನ್ನು ನಿಯಮಿತವಾಗಿ ನಿರ್ವಹಿಸಿರುವುದಿಲ್ಲ. ಆಮೇಲೆ ನಿಯಮ 17 ಉಪನಿಯಮ 2ರಂತೆ ಸ್ಕ್ಯಾನಿಂಗ್ ಕೊಠಡಿಯಲ್ಲಿ PC ಮತ್ತು
Where is Caesar Panchnama?
Caesar Panchnama is
9?
1919. Next see.
ಏನ್ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ?
ಅಲ್ಟ್ರಾಸೌಂಡ್ ಸ್ಕ್ಯಾನಿಂಗ್ ಮಿಷಿನ್ ಮತ್ತೆ ಫಾರ್ಮ್ F
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ.
No, my lordship, it is not right.
ರಿಜಿಸ್ಟರ್ ಎಲ್ಲಿದೆ?
My lordship, it is with them. Okay, I'll demonstrate my lordship. My lordship may peruse page number 20, 21. 20, 21. They've seized all these other materials. They've not declared in the Panchnama, my lordship. It is there in the complaint. It is forthcoming in the complaint by the respondent. They have not mentioned it in the Panchnama. It is an impropriety on their side. They have seized my bills. They have seized all my registers, my lordship. They have not made a note of that in the Sthala Panchnama. They have even taken the images, my lordship. 22 are the images. 23 is also on the other bills. They have taken my patient.
Where is the
registers.
complaint?
The complaint is in page number
10.
10, my lord. And the allegations against me are in page number 30.
ಇದು ಪ್ಯಾರಾ 9 ಬನ್ನಿ, ಪೇಜ್ 12 ಅಲ್ಲಿ.
Yes.
On inspection of the machine, it was found no images and patient
that is-
details were found. And it was not stored any media, English ಬಿಡಿ.
No ಅನ್ನೋದು ಮಿಸ್ಟೇಕ್ ಆಗಿ ಬಂದಿದೆ. Mood an amendment to change that there is
ಏನು?
images were found.
ಹಾ?
And no ಅನ್ನೋದು by oversight the no has been inserted.
ಯಾವ ಓವರ್ಸೈಟ್? ಎಲ್ಲ ಸೀಸ್ ಮಾಡಿದಿರಾ, ನೋ ಅಂತ ಹೆಂಗಾಗತ್ ಮತ್ತೆ?
ಅಲ್ಲಲ್ಲ, no ಅಲ್ಲ, ಇತ್ತು ಅಂತಾನೆ. We have moved an amendment, my lord, to say that
ಯಾವಾಗ? ಆಫ್ಟರ್ ದ ರಿಟ್ ಪೆಟಿಷನ್.
One other submission. my
If it is after the writ petition, yes.
is moved, my lord, on 16/7. It is
16?
After writ petition.
One other submission, my lordship.
ಹಾ.
A Form A is the application for buying an ultrasound machine, my lordship. Once a Form A is filed, before issual of Form B, they come to my premises, they inspect my records, they see if the book is kept there, they see if that sex determination board is put there to ensure that the guidelines are, followed by the applicant, and then only they issue the license, my lordship. So there is no impropriety in that.
No, not what we have issued licenses, but whether, as on today, when we inspected, whether he is following all these things.
No, have you followed everything in its entirety prior to conduct of search or whatever?
Page 21, my lordship, of the guidelines, my lordship. That is my only contention, my lordship.
Now come to page 20. Guidelines ನೋಡಿದ್ದೀರಾ? ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, ma'am, I've seen the guidelines.
Guidelines for filing criminal petition.
Yes, ma'am.
ಹಾ. ಶೋಕಾಸ್ ನೋಟಿಸ್ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
That is the show cause notice, madam.
No, no, that is
ಅಲ್ಲಲ್ಲ,
suspend. Showcase notice ಅಲ್ಲ ಅದು.
notice, page 30. ma'am.
Notice of closure.
ಅಲ್ಲ, that notice, my lord, asking him to explain, otherwise we will be closed within 7 days. That is the notice which.
ಯಾವುದು?
That page 30, my lord, annexure I.
The same day of the seizure, my lordship. Page number 30.
When was it seized?
The same day, my lordship, 8/12/2023, the same day they have given me a nominal notice, my lordship. It's a en masse notice, my lordship. It is not particular, it's just
No,
a.
en masse notice asking various violations, tick mark those violations and asking me the explanation.
ಏನ್
It
ಮಾಡಕ್ಕೆ?
is not given explanation.
ಏನ್ ಮಾಡಕ್ಕೆ?
After the seizure, after my records are taken, how can I explain, my lordship? They've seized all my records. They are asking me for images. Typically now to give the images, I'll have to break the seal and give it to them.
ಇದ್ರಲ್ಲಿ ಶೋಕಾಸ್ ಅಂತ ಹೇಳಿದೀರಾ? 30
ಏಳು
page
ದಿವಸ
30.
ಒಳಗಡೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಮೇಡಮ್ ಪೇಜ್ 31 ಮೇಲ್ ಕಾಣಿಸಿ ಎಲ್ಲಾ ನ್ಯೂನತೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ PCPND ಕಾಯ್ದೆಯಂತೆ ತಮಗೆ ಕ್ಲೀನಿಂಗ್ ಯಾಕೆ ಮಾಡಬಾರದು ಎಂಬುದಾಗಿ 7 ದಿನಗಳು ಉತ್ತರ ನೀಡಲು ಆದೇಶಿಸಲಾಗಿದೆ.
Now your whole case revolves around 5 patients' signature not found on Form F.
That is one Form F. That
ಅಷ್ಟೇ,
is one.
ಬೇರೆ ಏನಿಲ್ಲ.
Also the act book is not kept. Number 12, my lord, serial number 12. Serial number 15, empalment ಮಾಡಿಕೊಂಡಿರುವ ವೈದ್ಯರ ಹೆಸರು ಅರ್ಹತಾ ಪತ್ರಗಳನ್ನು ಪ್ರದರ್ಶಿಸಿರುವುದಿಲ್ಲ. Page 31 ಅಲ್ಲಿ.
Why don't you do all that?
My lordship, it's already done, my lordship. It's
Where?
already been there, my lordship.
Where?
It's in the premises, my lordship. Only after inspection of these was my license granted, my lordship. These are the prerequisites for granting the
Where,
license in Form B.
under what provision license is granted?
My lordship, I peruse ink page. Ink page 39, my lordship. It granted under the rule 6 and 8, my lordship. At the time of the
1-3 is it?
39, my
39.
lordship.
3-9.
39 is the page number, my lordship. The rule is 6, my lordship. Already there, my lordship. Everything is there. Inspection is done of the premises, my lordship. Only after the inspection is done is the license issued, my lordship. The license is subject to issue of all this, presence of all this, my lordship.
Where do you get that?
My lordship. 39 is my license, my lordship.
True, but these should be the requisites ಅಂತ ಎಲ್ಲಿದೆ?
That's my lordship.
ರೂಲ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ರೂಲ್ ಅಲ್ಲಿ ಇದೆ.
It's the rule, my lordship.
ಮೇಡಮ್ P&DT ರೂಲ್ ಕೊಡಿ. Rule 6,
Eight, my lordship. 6, 8.
certificate of registration. Model number, portable machine.
6B very clearly stipulates, my lordship. An inspection of this is done and only then my license is issued, my lordship. That is my contention. They have
No,
already
no.
done the inspection and then issue the license, my lordship.
No doubt that at the time of issuing this thing, all these things were done. Whether we continue to hold, display all these things in the place is an issue.
No, because why I am asking this is, in every case, these are cyclo-styled orders passed by you, notices issued by you. ಎಲ್ಲದಕ್ಕೂ ಒಂದೇ.
ಅದನ್ನೇ
ಇದೆ, these 17 clauses ಏನ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ, ಅದು they are cyclo-styled in every case.
those are the things which require to be maintained by.
No, required to be, ಎಲ್ಲರೂ ಅದ್ maintain ಮಾಡಿರಲ್ವಾ?
ಅಲ್ಲ, ಯಾರ್ಯಾರು ಮಾಡಿಲ್ಲ ಅದಕ್ಕೆ ಟಿಕ್ ಮಾರ್ಕ್ ಇದರಲ್ಲಿ ಟಿಕ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ. ಓನ್ಲಿ ಟಿಕ್ ಮಾರ್ಕ್. Page 31 ಅಲ್ಲಿ fellowship says the tick mark on the left
Anyway,
side.
we'll answer it.
On those which are violated have been tick marked. This is 23 are required to be followed. Wherever there are violation, they have been tick marked.
Anyway, henceforth, all these guidelines will be strictly followed.
Yes.
That we will.
In this case, my lord, the issue is that non-maintaining of these things. And
Signatures.
Form F, which he himself produced, says that there is
Scanning
no
machine
signature.
ಕೊಟ್ಟಿದಾರಲ್ಲ?
My lordship, no, my lordship, it has not been opened by them and they have also blocked my username and password, my lordship. Without my username and password, I will not be able to generate Form F, my lordship. You have already made a service on the same day, my lordship.
Like, been told
I
that.
passed an order that
Yes.
You untie the scanning image in accordance with law, handed over, yes, sir?
I don't know when he gave the requisition.
We sent it on WhatsApp on the very same day and as of yesterday, we've given a certified copy also, my lordship.
Check it.
Then we will, I'll check.
Heard the learned counsel appearing for the petitioner and the learned additional SPP. Reserved, the petitioner submits that despite the order dated 26/7/2024, the scanning unit of the petitioner is not permitted to be run in a manner that it has to be, as the username and password to run the scanning machine has been blocked. The learned additional SPP submits in the light of the interim order, appropriate action would be taken to comply with the said order. The submission is placed on record. Reserved. Madam, ಇದು ಇವತ್ತೇ ಕಳಿಸು.
9.
Huh?
Posco.
Huh?
Posco.
Huh? Pokso. ಏನ್ ಪೋಸ್ಕೊಳ್ಳೋದು?
Sorry.
Huh. Yes.
16, less than 16.
Less than 16 last time.
Victim is now presently 17 years.
Presently, sir,
Yes.
at the time of the incident.
16
I said
years.
state will take care, don't worry.
Infant baby has been born, my lord, 3 months old,
So you project the baby, the wife, and you want to come out.
my lord. The fact is that they got eloped, my lord. Eloped and got married. Subsequently, she got pregnant and complaint was lodged by doctor.
No, this is less than 16, sir. I think you're 15 years and 6 months.
Yes.
At the time of the incident.
Yes, my lord.
Pregnant by.
Huh?
I am, that since, when she.
You were what?
21, but she is
So,
less than 16.
It's a case of love.
Yes. It is yellow, my lord, but only issue is that less than 16 and then she's pregnant, the only thing.
All cases of love.
That's.
How to redeem it now? Ultimately won't succeed in the
They
trial.
won't say.
Impossible.
In a voluntary statement also, in
Ah.
164 statement also, she says that
They were in
he
love.
eloped and only problem is pregnancy
The
and she
problem
is-
is,
and
problem
she
is pregnancy.
and she is less than 16 years.
No, now she is of course,
But at the time
at the
of,
time of incident, yes, she was less than 16. How do you redeem it now?
Now she is, the victim is also.
ಇವಾಗಲ್ಲ sir, time of the incident.
The victim is also now residing with the petition number 1.
Obviously, why? ಅದೇನ್ ಸ್ಪೆಷಲ್ ಮೆನ್ಷನ್ ಮಾಡ್ತಾ ಇದೀರಾ ಅದನ್ನು?
they will have to go through the trial, but I've seen that, my lord, that the birth certificate has not been produced. He studied up to second standard. Probably there they can take a benefit in the trial court. Your lordship
Where
can fix the time
before the trial court,
for trial court. Fix the time frame, my lord, can be disposed of less than.
16 years ಕಷ್ಟ. Acquit ಅಂತೂ ಆಗದ್ ಹೌದು.
Out.
Should we permit all that?
The only issue.
No, because other cases were 17 years, 11
Yes,
months,
yes.
17 years, 8 months.
Yes. Even 16 plus we would have done, my lord, but the only issue less than 16. Though he is
Yes.
21-year-old.
Let me check, try to do something day after tomorrow,
Please,
not day after Friday.
please.
Friday in the fresh matters list, yes.
My lords,
Yes. Flex,
allegations are under section.
flex banners, destruction,
Yes, my lords.
Jagdish,
My lords, in the complaint also,
427 31T. Why did you destroy?
I have not destroyed my.
Who
lords.
else has done it?
My lords, I don't know, my lords.
You don't know.
My
Then
lords,
it has to
in
go
the-
for trial.
The complaint
has
is
to go
also
for
very
trial.
vague.
You don't know on the trial.
My lords, complaint is very vague, my lords. That there is no explanation as to how they got, how they are giving my identity because the alleged incident happened on
One
17.
additional SPP, 2 emergent notice in the meantime. Yes. Next. Notice ಆಗಿತ್ತು. ಇಲ್ಲ.
But 498A, the
Yes,
entire family has been robbed.
Correctly.
Lord, the
No
allegations.
doubt about it. Go to page 39, sir.
164.
Go to page 39, sir, and go to 164 state.
Please. So far as the mother-in-law and the father-in-law is concerned, Lord, the allegations, Lord, after filing the divorce petition filed by the husband,
Maybe.
Lord, there is no specific date, Lord, there is when they are harassed. The
Date ಹಾಕ್ಬೇಕು. I was harassed at, on this day, at this time,
very vague
minutes,
allegations,
seconds.
very vague allegations, Lord. And furthermore, the last accused number 4 and 5, who are the friends of accused number 1. They accompanied the accused number 1 for when the day of mediation was held in the court. In
4
that,
and 5 we will see. What do you have against 4 and
4
5?
and 5, there are
They were-
eyewitness statements saying that they were.
We are
indulging
present
in-
along.
Itself.
Please.
They were indulging in helping the accused number 1 in thing. Only
Their
that is there.
friend
I'll bow down
leave
to
it.
that to you all.
Others,
2 and 3 and also they have not.
discharge.
Mother-in-law.
No, no.
Father-in-law.
Mother-in-law, other-in-law,
Ah.
ಎರಡು ಇಲ್ಲ ಇಲ್ಲಿ.
For
They
so
have,
far as
uh,
husband is concerned, Lord, I'll not press the petition.
No, no, you can't press the petition, mother-in-law, father-in-law also. Clear allegations.
My lords, and one more.
See page 39, sir.
Well drafted complaint.
No, no. Well drafted summary of the charge sheet.
That is
Complaint ಆಗಿದ್ರೆ ಬೇರೆ.
in how she narrates the complaint and 164 the what she narrates.
So what? Good that at least one is saying correctly. ಎಲ್ಲದ್ರಲ್ಲೂ ವೇಗೆ.
Page
4 and 5 ಇರೋದು ಲಾಸ್ಟ್ ಪೇಜ್ 40 ಅಷ್ಟೇ.
Please.
That I will take. Insofar as others, you want me to give a finding, I'll give, or you file a discharge.
Lord, 4 is, the accused number 3 is concerned.
No,
Lord,
no.
kindly see complaint allegations.
2 and 3,
She
I will not.
deserted the husband in the year 2021. Thereafter, there is no their domestic relationship.
No, no. Sir. I'll answer, no problem. 4 and 5 we will quash.
Please.
Yes. The petitioner is before this court. Petitioners accused 1 to 5 are before this court, calling in question proceedings in CC 810 of 2024. Heard so and so. Before embarking upon the consideration of the issue on its merit, I deem it appropriate to notice the relationship between the petitioner and the petitioners and the complainant. The second respondent is the complainant, wife of the first petitioner, accused number 1. Accused number 2 and 3 are Phil and Mill. Accused number 4 and 5 are said to be the friends of accused number 1, the husband. The first petitioner and the complainant get married on 26/11/2020. It transpires that the relationship between the accused number 1 and the complainant flounders. And on floundering of such relationship, several proceedings are instituted, both by the wife against the husband or husband against the wife, as the case would be. The issue in the list concerns a complaint being registered by the wife on 25/11/2023, alleging harassment and torture from all the petitioners on the score of demand of dowry. It then becomes a crime in crime number 152 of 2023 for the following offences, FIR. The police conduct investigation and have filed a charge sheet against all the 5. Filing of the charge sheet is what has driven the petitioners to this court and the subject petition. The learned counsel appearing for the petitioner would vehemently contend that there is nothing that would meet the ingredients of Section 498A, 323, 504, 506, or 354 against the petitioners, particularly accused number 2 to 5. He would submit if at all there are allegations, it is only against the husband. He would submit that proceedings qua other accused be quashed, as it would become an abuse of the process of the law to permit continuance of trial against those accused. Per contra, the learned counsel Adit Chandan Gowda appearing for the complainant would refute the submission to contend that that allegations against the husband, father-in-law and mother-in-law are clearly narrated in the complaint and the summary of the charge sheet after the investigation. He would therefore submit that it is a matter of trial for all the petitioners to come out clean. He would, however, submit that insofar as accused number 4 and 5 are concerned, they are friends of the accused number 1, but have helped the accused number 1 in meting out such torture. He would therefore justify the action of drawing up the charge sheet against those accused as well. The learned additional SPP would take this court through the statement of the accused under Section 154, statement of the complainant under Section 164 of the CRPC to demonstrate that the narration in the complaint is clear with the events that have led to registration of the complaint and the investigation leading to registration of the crime, registration of the, filing of the charge sheet. He would seek dismissal of the petition. The afore narrated facts are not in dispute. The relationship between the two, beginning on 26/11/2020 and its floundering later, is a matter of record. The complainant registers a complaint on.
But so far as 2 and 3 is on merits, it not. I'll withdraw it. I'll see.
ಮತ್ತೆ ಯಾಕೆ ಹೇಳಿದ್ರಿ ಮತ್ತಿಷ್ಟು?
So far as 4 and 5.
4 and 5 ಅಷ್ಟೇ. ಅಲ್ಲಿ ಮೇಲೆ ಬರ್ಕೊಳ್ಳಿ. The learned counsel for the petitioner submits that the insofar as accused number ಇದೆಲ್ಲ ಇದಾದ್ಮೇಲೆ ಯಾವುದು narration or submissions ಆದ್ಮೇಲೆ I have given my ಮುಂಚೆ. The learned counsel for the petitioner at this juncture submits that he would not press the petition insofar as accused number 1, 2 and 3, the husband, mother-in-law and father-in-law, and would avail of such remedy as is available in law. In that light, who would remain in the area of accused is accused number 4 and 5, who are said to be the friends of accused number 1, the husband. To consider the case of the accused 4 and 5, it is necessary to notice the summary of the charge sheet. The summary of the charge sheet, as obtaining in column number 17, reads as follows. In the entire summary, what is narrated is only allegations against accused number 1, 2 and 3. Insofar as accused number 4 and 5 are concerned, the only allegation is that they have abetted or helped the accused number 1 to mete out such torture against the wife, the complainant. This would not meet the ingredients of whatever is alleged against the accused numbers 4 and 5. Therefore, permitting further trial against these accused would undoubtedly become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons, the following order. The criminal petition, insofar as accused number, the CC so-and-so, insofar as accused number 4 and 5 are concerned, stands quashed.
Liberty.
Huh?
Liberty.
In the light of the submission made by the petitioner, liberty is reserved to accused number 1, 2 and 3 to avail of such remedy as is available in law. Appropriate. Yes. Before the appropriate court, appropriate stage, appropriate proceeding. Yes. Next.
Listen.
Petition. Vehicle release. Madam, ಇದು
It has to be only that. Reason for rejection is that he has not gone before special court.
No, that is incorrect. The other judgments, right? I've allowed.
So one more judgment, recent
ಕೊಡಿ.
Madras High Court.
ಅಲ್ಲ ಮಡ್ರಾಸ್ ಹೈಕೋರ್ಟ್ ನಮ್ದೇ ಇದೆ. ಕೊಟ್ಟಿದ್ದೀವಿ. ಇದು ಆಮೇಲೆ ಇನ್ನೊಂದಿದೆ. 2 ಎಸ್ ಇಬ್ರು ಇದಾರಲ್ಲ ಇಲ್ಲೇ. 2 allowed. ಮಾದೇವಲ್ಲಿ 2 ಆಗಿದ್ದೀನಿ. ಎಸ್. No bank guarantee, indemnity. Next.
13.
The respondent police have registered the case against the petitioner for the offence punishment of section 420, 464, 465, 466, 68,
Wait.
71.
1 minute, sir. What has happened to the procedure? Investigation ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ. 3 ವರ್ಷ. 420 ಎಲ್ಲದರಲ್ಲೂ ಇರುತ್ತೆ ಸರ್.
Some land records which have been forged. The original.
What is the stage of the investigation? How long do you take now? Either I will state now.
No, the place is the court my lord which says that the original record, pages in original records have been changed. And now we are.
Final report ಮಾಡಿ ಅದನ್ನ. ಕಳಿಸಿಲ್ವಾ ಇನ್ನು?
ಕಳಿಸಿದ್ದಾರೆ.
Offence of the year 2016, my lord. Offence of the year 2016.
When did you send it to FSL, sir?
Friday, my lord.
I'm innocent, my lord.
The learned additional SPP submits that though the crime was registered on 9/4/2021, the police have not been able to file the final report in the light of certain land documents being tampered. It is ununderstandable as to how tampering of land documents is being unearthed for 3 long years by the investigation. Therefore, list the matter on Friday in the fresh matters list. Instructions be sought as to when a final report would be filed, failing which this court would be constrained to grant an interim order of stay of all further investigation. Next, yes.
D.
Charge frame agide.
Yes, yes, madam. Charges from in a connected cases, my lord, the accused has been appeared and he has been sentenced to, he has pleaded guilty, my lord. There is a case and counter claim, counter case in respect of the very same incident, my lord.
Adu close ಆಗಿದೆಯಾ?
As close, he has pleaded guilty, my lord. He has pleaded a sentence to
ನೋಡಿ,
pay
that is
400
there,
rupees,
and we'll see.
2,000 rupees fine. He has paid it. That's the reason, my lord, the continuation of which would amount to, my lord.
No, wait, get instructions, what he's saying. The learned additional SP, learned counsel for the petitioner submits that the issue in the list is a case and a counter case. In the counter case, the accused has pleaded guilty and the proceedings are closed.
Yes.
And therefore, the petitioner submits that these proceedings also should be obliterated. The learned additional SP to secure instructions with this regard. List the matter on 13th in the fresh matters list.
Stays.
No. Charge frame ಆದ್ಮೇಲೆ stay ಇಲ್ಲ. ಅದು ಬರ್ಲಿ ಆ ತರ ಇದೆ ಅಂದ್ರೆ ಡೆಫಿನೆಟ್ ಆಗಿ ಕೊಡ್ತೀನಿ.
Yes.
15.
Worship 409 and 420. Worship allegation at page 22. Worship the commissioner gives a complaint against the erstwhile commissioner. Only allegation is that, my lordship, there was no layout approval obtained by the worship commissioner. In fact, my lordship, the sites were situated in a Gram Panchayat.
The investigation papers.
Worship, in the Gram Panchayat, sites were formed and khatas were issued by the Gram Panchayat, your lordship. We have only taken over the, my lordship, sites to the municipality. Worship, till date, we have not issued the khatas, your lordship.
All a matter of trial.
Worship, the allegation,
Evidence rather.
kindly see page 22, my lordship, for a moment.
Not a case for interference. ಇಲ್ಲ ಅವತ್ತೇ ಸ್ಟೇ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದು ಅಪ್ರೂವಲ್ ತಗೊಂಡಿಲ್ಲ, ಲೇಔಟ್ ಅಪ್ರೂವಲ್ ಅಂತ. ನಾನ್ ತಗೊಳಕ್ ಬರೋದಿಲ್ಲ, ಅವ್ರು ಒರಿಜಿನಲ್ ಓನರ್ ತಗೋಬೇಕಾಗಿತ್ತು ಅದನ್ನ.
ಆಗ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ.
Because I was working 2021, your lordship. I am not working there.
No problem.
ಅದು ಜನವರಿನಲ್ಲಿ ಹ್ಯಾಂಡ್ ಓವರ್ ತಗೊಂಡಿದ್ದಾರೆ. I have taken charge in the month of April 20.
PDO ತಾನೆ.
ಅಲ್ಲ, commissioner of municipality.
Commissioner.
Commissioner.
The previous commissioner has registered the crime.
No. The present commissioner registered a.
Sorry, you are the previous commissioner. Present commissioner has registered against you.
Please, your lordship.
Yes. Noted, yes.
Worship, because kindly see page 22 for a moment. That is the allegation only, my lordship. Because I cannot obtain a, my lordship, layout approval plan being a commissioner.
ಅದೆಲ್ಲ ಆಗ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ.
Because it was the sites for already there, my lordship, in the.
Investigation ಆಗ್ಲಿ. Not a case for interference now.
I produced the khatas also, my lordship. The Gram Panchayat standing in the name of the respective owners. It is only allegation and there is an inordinate delay, my lordship.
Inordinate delay ಯಾಕೆ ಅಂದ್ರೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಕಮಿಷನರ್ ಬಂದು ಗೊತ್ತಾಗಿದೆ ನೀವು ಮಾಡಿರೋದೆಲ್ಲ.
ಅದು 21 ಅಲ್ಲಿ ಆಗಿದೆ.
ವಾಟ್ ಎವರ್ ಸರ್. ಅದಕ್ಕೆ inordinate delay ಇದೆ.
ಅಲ್ಲ, ನಾವು ಖಾತಾಸ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. Till date, my lordship, we have not issued the khatas.
No sir.
We have not issued any khatas, my lord. The allegation is we have issued the khatas.
Not a case for interference.
Kindly see the
ಅದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ.
records ಅಲ್ಲೂ.
Commissioner is the complainant, sir. Why would he just like that complain, not to save his skin?
Direction issued by the deputy commissioner, the complaint was issued.
No. Whatever.
That is the reason.
Whatever. On fellow public servants, they will not do unless there is something that would touch upon the office.
ಅಲ್ಲ, ಖಾತಾ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ, my lordship, I will agree, my lordship, it is an allegation.
Investigation.
Khata is not yet issued, your lordship, by the municipality. That is the case.
You come after the final report is filed in case it is a charge sheet.
Just for next week, your lordship.
List after 2 weeks. Pendency of this petition will not come in the way of investigation being conducted into the offense against the petitioner. Yes. A vehicle allowed. ಅದೆರಡು ಸೇಮ್ ಮೇಡಮ್.
Case of defamation is filed for a complaint having been given to the Bar Council. The complaint does not disclose that there is any element of publicity. The complaint, my lords, your lords.
Page 56.
Yes, my lords. That is the complaint which I given to the Bar Council. Lords, the only statement which is made at page 66, para 4.
66, para 4.
That's it.
Yes.
And there is no publicity as such. This is a complaint which I'm entitled to give to the bar council. Bar council ultimately gives him a notice and drops the complaint. The proceedings are closed. Page 12 is the PCR which is filed by them. PCR never indicates, my lords, that there is any element of publicity beyond the complaint which I have given. Giving of a complaint, my lords, to a statutory authority cannot lead to an offense of defamation because it lacks in the element of publicity. The intendment is to harm the reputation or to the imputation should be such that it is likely to harm the reputation. These two ingredients, my lords, will be conspicuously absent when the publicity is lacking.
No, according to him, the very complaint registered against the respondent before the bar council is now it's held to be untrue.
It's held to be untrue, my lords. Now the bar council doesn't say whether it is true or untrue. It will not go into those
That is
allegations.
true.
It says that it doesn't amount to a misconduct and the proceedings are dropped. Now, where is any question of defamation until and unless the element of publicity is demonstrated?
Yes, sir.
Running page 16 for a moment.
1-6.
1-6.
Yes, sir.
Fourth line, my lords, in para A. The first line in para A. Public.
Para?
Para A, my lords, sub para A in public. It is not in one place, my lords, alone. Bar council was just a strip, my lords. Court corridors, village.
When, where, everything is very vague. There is no
Lords,
question of.
For an advocate, my lords, the only one thing what he may earn in the first 2 decades, my lords, is goodwill and reputation. That is sought to be turned.
No, Ravi Shankar, sir.
Lords, I will just say this. Whatever is now said here, it is completely
this-
vague. Lords, may kindly see
this
what is
is-
said in para
if
16.
this is pardoned,
Yes.
then these things will galore.
Lords, I would say this, my lords. What, when, how, where it is stated. Lords, may kindly.
Matter of trial.
16. Lords, it will become a matter of trial if the details is otherwise forthcoming in the complaint because it's a private complaint. Lords, I can understand if it is an FIR which is required to be registered, an investigation has to be gone into. Even, Lords, after the sworn statement is recorded and the orders are passed.
The
if your
court
lords
will hold
to see,
inquiry.
that is done. Lords, kindly have a look at page 26. There is no finding given.
What is done?
Lords, now the cognizance is taken and summons is issued.
Cognizance is taken.
Lords, there is a civil dispute which is going on.
Maybe,
The
sir.
lawyer is also, my lords, one of the respondents or the defendants to the trial in the suit.
Maybe.
Lords, now, if the court is looking into one aspect of the matter that I had given a bar council, the complaint to the bar council, and what is stated is at page number 67, the other part also cannot be ignored, my lords, for the fact that as a lawyer, he will be in a position, my lords, to.
ಇದೆಲ್ಲ ಎಲ್ಲಿ ಆಗಿರೋದು ಪೇಜ್ 16 ಅಲ್ಲಿ
ಅದೆಲ್ಲ ಏನು ಇಲ್ಲ, ಎಲ್ಲಾಗಿದೆ, ಏನಾಗಿದೆ, ಎಲ್ಲರೂ ಹೇಳ್ಬೇಕಲ್ಲ.
minutes.
Everywhere, my lords, it is
No,
not
no,
in one place.
Where is it
Where?
said?
Not said. I have stated it is publicly being stated. Publicly being
Where?
stated. My lords, court hatra bandag ಹೇಳ್ತಾರೆ. Then, my lords,
ಇಲ್ಲ,
this is,
ಇಲ್ಲ.
I'm not so. It went to the extent of, my lords, me being, my lords, my lords, I was ousted of my senior's chamber. I have stated that. My lords, it has gone to this level. My lords, it is the integrity of as me being an advocate which was put into test there. Saying, my lords, I know XYZ. This is, my lords, unpardonable there. And that is why, my lords, this cannot.
Where are these statements made is what is.
My lords, one strip of it is before the bar council. One strip of it is before the bar council. My lords, ಊರಲ್ಲಿ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲಿ ಯಾರು ಮುಂದೆ ಹೇಳಿದ್ದಾರೆ ಏನು?
My lords, for one moment, my lords, the bar council complaint itself for a moment.
ಹ್ಮ್.
My lords, ಊರಲ್ಲೆಲ್ಲ ಹೇಳ್ಕೊಂಡು ಇವರೇ ತಿರುಗಾಡ್ತಾರೆ ಅಂತ ಅವರೇ ಹೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ ಆಯ್ತು ಅದು that is the complaint of
Please, my lords.
your complaint to the bar council.
ಅವ್ರು
No, no,
ಊರಲ್ಲಿ
but
ಹೇಳ್ಕೊಂಡು
not
ಅವ್ರು
my
ಓಡಾಡ್ತಾ ಇದಾರೆ ಅಂತ
complaint.
ಹೇಳಿರೋದೇ ಹೊರತಾಗಿ ನಾನು ಓಡಾಡಿದೀನಿ ಅಂತಲ್ಲ. ಅವ್ರು ಓಡಾಡ್ತಾರೆ ಊರಲ್ಲಿ ಹೇಳ್ಕೊಂಡು ನನಗೆ
ಅವರೇ ಹೇಳಿದ್ದಾರೆ ಊರಲ್ಲೆಲ್ಲ ಇವನು ಹೇಳ್ಕೊಂಡು ಓಡಾಡ್ತಾ ಇದ್ದಾನೆ. Lords,
ಅವ್ರು-
this is something, lords, where one thing, lords, these are per se defamatory statements. Now, lords, how much of loss of reputation, lords, will have to be proved, lords, on the by the other side during the course of a trial.
Yes, sir.
ಅದು ಲಾಸ್ ಆಫ್
And
ರೆಪ್ಯುಟೇಷನ್
lords,
ಯಾವಾಗ
one more
ಆಗತ್ತೆ?
thing, one more thing,
Enara-
lords, even his children are advocates.
ರವಿಶಂಕರ್ ಸರ್,
ಪ್ಲೀಸ್ ಮಿಲೋಡ್ಸ್.
ನಿಮ್ಮದೇ ಕಂಪ್ಲೇಂಟ್ ಪ್ಯಾರಾ 4 ಅಲ್ಲಿ
ಹೌದು.
ಬಾರ್ ಕೌನ್ಸಿಲ್ಗೆ
ಹಾ.
ಇದನ್ನು ಓದ್ಬೇಕಾ ಹೇಳಿ ಓದೋಣ. ಪೇಜ್
Bar-
66 ಅಲ್ಲಿ
ಮಿಲೋಡ್ಸ್ ಪ್ಯಾರಾ 4.
ಹಲವು ವರ್ಷಗಳಿಂದ
Milods, I have read this portion. if this is a complaint which is given to the bar council, notes the ingredients of section 499 is that there should be number one, imputation. Number two, there is a publicity, and there is an intention to harm the
This
reputation.
is a public document.
Notes, this is not a public document. If they produce anything to show that a complaint given to the bar council is a public document, then certainly it is correct, Milords. It is purely private. Nobody can apply this complaint and take it. Bar council will not give these copies. Milords, it is purely kept personal. When a complaint is given to a statutory authority, it will not lead to defamation.
Let's see.
This is the point. Or there is, if that is how it's to be considered. And second thing, Milords, if your lordship were to see, the statements which is made is that he is publicly making the statements. The most important part, if your lordship were to take section 499, Lords, it specifically requires makes or publishes the imputation concerning person intending to harm or knowing or reason to believe that such imputation will harm the reputation of such person in said case, except in cases which is exempted. Now, the reason why I am submitting is the requirement under 499 is essentially what is done publicly, and there is a harming of the reputation. Not 4 ingredients. Imputation is made.
This statement undoubtedly harms the reputation. There is no doubt about it.
Now, if he has made the statement, that's the
This
reason
is
why I
whether
said.
before raising this in the complaint before the bar council would bring down his reputation, we will answer it. Yes.
May I just say this, Milords? Number one, making an imputation. If a statement of the kind is made, and if that is complained before the bar council, there cannot be a situation that it is going, because it is not something which I am alleging against him.
That is allegation only, sir.
No. Lordships may kindly see, what is that which is said? I am saying this is what he is telling, not what I am telling.
That is why now the complaint is what you have told.
Lords, that's
As
what I said.
simple as
Lords.
that.
It is not, if the complaint, if I make an imputation against him, I say this is what he is claiming for himself. Therefore, these are the kind of cases where disciplinary proceedings is to be initiated. The disciplinary committee says that no, it's not a case of misconduct. We will not accept this, and it is closed it. Now, where is any publicity in this is the question.
Exactly. That is
Not
what
the
that's what
reason
I'll
why.
answer.
Now, so far as the publicity is concerned, Milords, now this is a private complaint. In the inquiry, materials will have to be placed to show that the order reflects the publicity as such. Lordships may kindly
That
see
is
page
what
26.
Bar council's complaint, whether it is public document or it is not a
Lordships may have-
publicity, that we will see.
Day after tomorrow or any other day, Milords, I'll submit documents to show that the moment I have a right to file a complaint before a statutory authority, giving of a complaint does not involve the provisions.
No
As long as those proceedings are kept in camera. Now, those are the proceedings which is not held in the open court.
See, you give me a give me
Lordships.
something to say, otherwise we'll answer it.
Very well, Milords.
Yes. Friday,
Very well.
Friday fresh.
One
matters.
litmus test, not even he can answer day after tomorrow. Not just imagine a case where this gentleman, not tomorrow may be considered for some tribunal, may not be some other judgeship, not for some tribunal. Not will not the IB ask for such right?
ಏನು ತುಂಬಾ ಆಸೆಲಿದ್ದಾರೆ tribunal ಹಾಕಿ.
Milords, Allah,
Friday, no,
ಇದು
Friday.
Test for a lawyer, any professional. Milords.
Friday.
he is scathed clean of the allegations
Milords,
that he
even
will have
Milords, his-
more. he
His
is
children
scathed
are
clean.
also lawyers there. Milords, the petitioner's children are also lawyers. It is not that, Milords, they don't know the ramifications of saying so.
We'll see.
They stay in a glass house and do this. This is what they have.
Whether there is an offense or not, that is the only question.
ಅಷ್ಟೇ.
Milords. Other ramifications we can consider it outside.
Glass house
not-
ಅಲ್ಲಿ ಆಮೇಲೆ ನೋಡೋಣ.
Glass house ಆಮೇಲೆ.
Yes.
One
Glass
thing I
house-
know is that the people
Sir,
in glass house should not
Glass
undress
house
themselves.
ಪೂರ್ತಿ ಹೇಳಿ.
Ah.
Glass ಮಾತ್ರ ಹೇಳ್ಬೇಡಿ. ಅಷ್ಟೇ.
No, the only thing which I know is that the people who are living in glass houses should not undress
yes.
themselves.
Friday. That will continue. Friday fresh matters.
15. 14%.
Petition number 1 now. 1 and 3. ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ? 1 ಯಾರು? 2 ಯಾರು? 2 ಇವರೇನಾ? ಹ್ಮ್ 498 ಏನಾ?
Charge sheet has been filed.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? ಚಾಲೆಂಜ್ ಮಾಡಿ, ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದ್ದಾರೆ, ಚಾಲೆಂಜ್ ಮಾಡಿ. ಅವಾಗ ಪ್ರಾಪರ್ಲಿ You either instruct him or you appear. Charge sheet ಲಿಪ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. Yes, number and CC number.
I'll get the number.
Get the number.
Yes.
Tomorrow?
Tomorrow.
List tomorrow in the fresh matters list. Yes.
Day after tomorrow.
Day after tomorrow, the special bench matters.
Friday.
Friday is fresh matters list. Next.
90.
ಬರೀ ಆ information ಅಷ್ಟೇ.
Yes.
Correct. ಏನು? ಇದಿಷ್ಟೇ ಕೊಡ್ಬಾರ್ದ?
ಅಲ್ಲ.
ತೊಗೊಳ್ಳಿ.
ಕೊಟ್ಟಿದ್ದಾರೆ ತಮ್ಮ.
ಸ್ಪೀಕರ್ ಸರ್. ಇಲ್ಲಿ ಅಡಿಷನಲ್ SPP ಅವರು ವೆಹಮೆಂಟ್ ಅಪೋಸಿಷನ್ ಅದಕ್ಕೆ.
ಅದಕ್ಕೆ
ಸ್ಪೀಕರ್ ಮೇಲೆ ಹೇಳಿದ್ದಾರೆ.
No, but he can't be speaking, my lord.
Yes, sir. We'll have it after 2 weeks. List after 3 weeks. In the meantime, additional SPP 1, emergent notice 2.
20.
Correct. Brother, father-in-law ಅಲ್ವಾ ಅದು? Brother. Page 39. ಏನು ಸೆಟಲ್ಮೆಂಟಾ? ಬ್ರದರ್ ಮೇಲೆ ಏನಿಲ್ಲ ಬಿಡಿ. ಹಾ, ಇದು ಯಾವಾಗಿಂದ ಇದೆಲ್ಲ? ಇದೆಲ್ಲ ಮುಂಚೆ ಆಗಿದ್ದ? ಯಾವ್ದ್ರ ನಂತರ ಆಗಿದ್ದು? ಎಲ್ಲಿ ಸೈನ್ ಮಾಡಿದ್ದು? ಯಾರ ಸಮ್ಮುಖದಲ್ಲಿ? ಮನೆಯಲ್ಲಿಯಾ? ಅದಕ್ಕೆ ನೋ ಸ್ಯಾಂಕ್ಟಿಟಿ. Yes.
Even reading that itself, my lord, makes out.
Page 39. Accused number 2, nothing. Accused number 1 and 3, everything. But ನೀವೇ ಓದಿ. ಅಲ್ಲ 3 ಅಲ್ಲ, ಯಾರದು? ಮದರ್ ಇನ್ ಲಾ ಯಾರು? A2. ಎಸ್. A3 ಏನ್ ತೊಂದ್ರೆ? A3 ಏನ್ ತೊಂದ್ರೆ? ನೋ ಸರ್.
ಅವರು ಮನೆ ಕಟ್ಟಬೇಕು ಅದ ಎಲಿಗೇಷನ್ ಮಾಡ್ತಾಳೆ. ಇನ್ಫ್ಯಾಕ್ಟ್
ಒಂದ್ ನಿಮಿಷ. 3ನೇ ಆರೋಪಿ ಚಾಸನ ಎಳೆದಾಡಿ, 2ನೇ ಆರೋಪಿ ಸೋನ್ಸ್. ಎಸ್ ಸರ್, ಎಲ್ಲರ ಮೇಲೆ ಇದೆ. ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಓದ್ತಾ ಇದೀನಿ, ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲ.
ಸೆಟಲ್ಮೆಂಟ್ ಆದ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್
ಆದ್ಮೇಲೆ ಕರೆಕ್ಟ್ ಆಗಿ ಬಂದಿದೆ. No. Looking at this, how will you expect an interim order? ಇಲ್ಲಿ ಏನಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಡಿ ನೀವು page 39 ಅಲ್ಲಿ. You get the complainant before this court and say she is not willing to pursue, then we'll see. If she comes and says that settle ಮಾಡ್ಕೊಂತೀನಿ, fine. Otherwise, I am not going. This is not a matter to be interfered at all. ಇಲ್ಲ, ಅದು A3. No. Page 39 ಬನ್ನಿ. ಒತ್ತಡ ಹೇರುವುದಲ್ಲದೆ 3ನೇ ಆರೋಪಿ ಬಟ್ಟೆಯನ್ನು ಎಳೆದಾಡಿ ಮಾನಹಾನಿಗೆ ಪ್ರಯತ್ನಿಸಿದ್ದು. 354 is also there, sir. Yes, sir. ಅಲ್ಲ, ಹೇಳಿದ್ಮೇಲೆ ನಾವೇನ್ ಮಾಡಕ? If the wife comes and says, yes, I am ready to settle it, fine. ಅಷ್ಟೇ, ನೋಟಿಸ್ ಮಾಡಿ. 1 additional SPP, 2 emergent notice. Pendency of this petition will not come in the way of further proceedings before the concerned court. Yes.
21.
306. ಇಲ್ಲ ಇರಲಿಲ್ಲ. ಹೌದು ಮೇಡಮ್, ಹೌದು 19 ಅಷ್ಟೇ. ಹಾ ಗೊತ್ತು.
My lord, in this charge sheet is filed, my lord, NCC number 5297 of 24.
Pending for about 4 weeks, whether they wanted to produce the.
ಪರವಾಗಿಲ್ಲ, ಚಾಲೆಂಜ್ ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಮಾಡಿ. ಇಟ್ ಈಸ್ ಬೆಟರ್ ನಾವು ಸಿ ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ 306 ಸ್ಟೇ ಮಾಡೋಗಿಂತ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನಿದೆ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಮಾಡೋದು. ಇಟ್ಸ್ ಬೆಟರ್ ಆಲ್ವೇಸ್. ವಾಟ್ ಸಬ್ಮಿಷನ್? ಅದು ಕರೆಕ್ಟ್, ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ, ಲಿಬರ್ಟಿ. ಎಸ್. ನೀವೊಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ, ಅದೇನಾಗಿದೆ? ಇದು ಆಗಿದೆ. ಅದು ತಗೊಂಡ್ಬನ್ನಿ, ಎಲ್ಲ ಕ್ವಾಶ್ ಮಾಡೋಣ. ಎಸ್. one HCGP, 2 emergent notice. There shall be an interim order of stay of further proceedings in CC 1314 of 2023 till the next date of hearing, lest the matter on 20th in the fresh matters list. ಅಷ್ಟೊತ್ತಿಗೆ ಅದು ಬರುತ್ತೆ. Yes. MTP.
Yes, my lord.
Medical termination of pregnancy.
My lord, yes, my lord. My lord, in this.
ಎಷ್ಟು ಇನ್ಸ್ಟೆನ್ಸಸ್ ಮಾಡಿದ್ದೀರಾ?
Husband.
Oh, this is that clinic. Yes, yes, sir. Statement of the wife.
Yes, my lord.
And she subjected herself. Wife subjected herself before at the hands of an unauthorized person at an unauthorized place. That husband has been arrested.
Without your consent ಮಾಡಿದಾರ ಅದನ್ನ?
Very much within my instinct to-
You were also there.
It was within my right to give a consent for my wife to undergo abortion.
My lord, that was done not in the hospital, my lord. It was in the house of accused number 1. That
Yes,
is the,
ಅದು ಕರೆಕ್ಟ್, ಅಲ್ಲೇ ಮಾಡಿದ್. ಇದು ದಟ್ ಮಂಡ್ಯ ಡಿಸ್ಟ್ರಿಕ್ಟ್.
Mandya district.
Yes. These things are happening in the houses only.
She's been treated as victim. My wife has been treated as victim. But she subjected herself at the hands of an unauthorized person.
Wife is treated as a victim, you are victimized.
Yep.
Yes.
But now, before
ಕೊಡಿ ಅದು, ಇದು ಕೊಡಿ.
Lord, I'll secure. My lord, in this matter, charge sheet is ready, my lord. They are submitted for scrutiny. That is what my instructions.
ಇವ್ರ ಮೇಲೆ ಹಾಕ್ಬಿಡಿ, ಬೇರೆಯವ್ರ ಮೇಲೆ ಹಾಕಿ.
Well, I'll secure the statement of the wife of the
You
petitioner.
secure it, I am not
Please.
allow ಮಾಡ್ತಾ ಇಲ್ಲ. Yes. List the matter on 21st in the fresh matters list. The further proceedings where the petitioner shall remain stayed. The learned counsel for the petition, learned HCGP submits that charge sheet is ready to be filed against this petitioner as well. ಅದೇನ್ ಬೇಡಬಿಡಿ, ಸ್ಟೇಡ್ ಅಂತ ಮಾಡಿ ಸಾಕು. ಮಿಕ್ಕಿದವ್ರದ್ದು ಹಾಕ್ಬಿಟ್ಟು place the report. Yes, next. You are out of the VC. Yes.
That's may remember, this is with regard to whether a translated copy.
I remember everything, sir.
Yes.
Tell me.
Now, I would like to bring my lordship.
You have to, your interim order is on the basis of Justice Oak's judgment.
Yes.
You have to bring your case within the corners of Justice Oak's judgment. Otherwise, I am going to dismiss it straight away. Yes.
In fact, my lord, a writ petition was filed before the Honorable Supreme Court seeking the quashing of a subsequent FIR that it was registered in the state of Karnataka. It is pending. In that interim order, my lord, I had ventilated, if I may take my lord.
ಕೊಡಿ ಅದು.
The fact that the Honorable Apex Court had directed.
We'll file a copy of the charge sheet with English translation of the charge sheet if required. Will be made and filed. That is before the court, sir.
Yes, I had essentially submitted before the court that as a counsel, I am not acquainted with the said language.
Why? Where are you enrolled?
But yeah, my enrollment has no bearing whatsoever with regard to my efficient, my.
Kannada ಬರಲ್ವಾ?
No, my lord, I have filed an affidavit. Let me file an affidavit.
That you don't know Kannada.
Read it right. My lord, I'll take my lord.
ಮಾತಾಡಕ್ ಬರುತ್ತಾ?
ಮಾತಾಡಕ್ಕೆ.
Lord, let him file an affidavit that he has not defended a charge sheet. All his practicing years.
You have not? You have not defended any accused?
I take my lordship, this is,
Which is in Kannada. If he has defended a trial which is in Kannada, charge sheet is in Kannada.
but I take my lordship to the affidavit before I answer my letter.
If you are aware, that is enough, fellow. What is this Velan?
I
Not,
with regard to the fact,
Uh.
I am unable to read it right. I have even annexed my 10th standard, 12th standard, my law school degree, etc. I take my lordship to page 2. Lord, as a ward of a central government employee who was crisscrossed across the country, I was a product of a KV. My second language happens to be Hindi. I take my lordship to page 2.
Kendriya Vidyalaya?
Yes,
Ah.
I did my law from National Law University, Punjab.
No, 1 minute. SPP ಅವರೇ.
Yes, Lord.
Now, what is the problem in providing?
We will provide, my Lord. Fair trial.
Essay ಆಗೋಯ್ತಲ್ಲ?
Fair trial, of course, my Lord, we will provide.
Over, he'll provide. Your case is over.
No, I cannot object to that. That's the mandate of Article 21, a fair trial.
Finish.
Yes.
That's all.
Then I would only want to know that if he has defended any trial which was in
Paravailla,
Kannada.
let's not get into the nitty-gritty of it. Velan has filed an affidavit. We'll take it that
Yes,
he is not aware of.
He has not said that, that portion.
That's all right.
I could have appeared with the battery of block.
We will punish.
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. You have told, you'll furnish it, we'll record it, close it.
Yes.
Yes.
Only confining it to this case, my Lord, then.
Yeah, of course, this will open Pandora's box
Yes, yes,
otherwise.
other-
Yes.
only to
Not
delay the
attending
proceedings.
circumstance, my lord, which has been pleaded even before the Supreme Court is that there was an informal
I will-
bar association.
I will record both.
Yes, sir.
Yes.
Just to bring it to my lordship's notice, a resolution passed by the bar stating the members of the bar will not appear for the accused.
I know, sir. The background I know.
Yes, ma'am. In consequent to the same, it had come to a person who was otherwise not practicing them.
Yes, sir. No problem. Leave it. Yes. Yes, consider it, he will give it. Why argument? Oh, you're Velan.
Yes, ma'am.
Yes.
But there are two other judgments, one by
Consider, wouldn't sir? Yes. The petitioners are before this court calling in question an order dated 3/7/2023, passed in special case number 794 of 2023, which is registered for offences punishable under so and so. They heard so and so. What has driven the petitioners to this court in the subject petition is required to be narrated without going into the backdrop of what has driven these petitioners into the web of proceedings. The petitioners file an application under section 207 of the CRPC seeking translated copies of the charge sheet so filed, which was in the vernacular. Vernacular in the case at hand was Kannada. The petitioners do not understand or read or know to read or write Kannada language. The council, the matter was then moved on the score that the apex court in the case of CBI versus so and so 2023 SCC online SC page 1069 had directed that that if the accused or accused facing trial or the counsel who is defending those accused would not know English, I would not know the language which is in which the charge sheet is, then the translation must be furnished. Placing reliance upon the said judgment, this court had granted an interim order of stay. The learned counsel appearing for the petitioner, N. Velan, would submit that he himself is not aware of, he himself is not conversant with reading and writing in Kannada. He only is, he can only speak Kannada. In the light of, he has filed an affidavit as well to that effect before the court. The learned SPP1 would submit that they would supply the translated copies as is demanded under section 207 of the CRPC before the concerned court. In that light, a deeper delving into the matter with regard to whether this would be necessary for a fair trial under Article 21 of the Constitution of India need not be and is not gone into, as a one-off situation is projected before the court and a one-off solution is given by the SPP 1. In the peculiar facts of this case, the petition stands disposed, directing the state to provide translated copies of charge sheet,
Yes.
translated copies of the charge sheet and materials appended to the charge sheet to the Nimaga
In English.
in English language, charge sheet and the charge sheet material which are in the vernacular in English language to the petitioner, to the counsel for the petitioner.
One other interesting thing is when the Honorable Apex Court transferred the trial of the late Chief Minister of Tamil Nadu, Madam Jayalalitha to Karnataka, the entire records were
I know, I
translated
translated, yes.
in English. In fact, the translation was not proper, hence they had to redo it again. And the state is objecting to a little settings.
It's all right. They're entitled to object, it's all right. So what? Ordered accordingly, Konege, madam, ordered accordingly.
Fine.
Petitioner is the.
CC of 2020, what stage, sir? Charge sheet gottu, sir. Charge sheet challenge madradu. Charge sheet challenge madradu. Yes, sir. Framing ಆಗಿದೆಯಾ? Yes.
Charges not framed.
Yes, sir.
Petitioner is the manager at the restaurant number 2 bank manager. Month of December 2006, he sanctioned OD loans to 6 customers by obtaining valid security and mortgaging the properties.
If there is valid security, why proceedings are initiated?
Sir, in the complaint, they stated that the mortgage property has been sold by the
Borrower,
borrowers without informing the bank. That is the allegation made in
One-
the complaint.
HCGP 2 emergent notice. The petitioner, a retired employee of the Indian bank, is knocking at the doors of this court.
What a judgment passed by this honorable court in OA filed by foreign bank manager, especially by this
Sorry.
bench.
Nimda,
Yes, ma'am. I have filed OA for recovery of.
to hand over original title deeds.
Yes. In favor of the petitioner, court judgment has been passed by this court, this bench.
This has become final? ಹೆಂಗ್ ಮಾಡಿ ಹಾಗಾದ್ರೆ 1 HCGP 2 emergent notice. The petitioner is, you are an employee or borrower? You are the borrower. Why did you approach this court in this?
They have filed OA against me for recovery of the amount.
Oh, this, correct. Recovery of the amount because of the loan documents illa anta. Yes. The petitioner, a former employee in the cadre of manager of the Indian bank, is knocking at the doors of this court in the subject petition against a complaint registered by the second respondent on the score that the loans that are granted by the petitioner had all become sticky without any adequate security to fall back upon. It is germane to notice that this very petitioner had called in question an action of the bank in going against the residential property of the petitioner to recover the loan. This is set at naught by an order of this court dated 21st April 2023. In the light of the reasons so rendered therein, the subject proceeding also cannot be permitted to be continued. As the allegation is against the borrower appears to have sold the property during the subsistence of the mortgage without informing or taking permission of the bank. This cannot be held against the petitioner, albeit prima facie. 1, 2, till the disposal of the
6 charge sheet has been filed, my lords.
6 charge sheets.
Yes.
I think ಒಂದು ಆಯ್ತಲ್ಲ, ಇನ್ಯಾವುದಿದೆ?
6 charge sheet, separate CC numbers.
ಎಲ್ಲಿದೆ? ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಎಲ್ಲ? ಎಲ್ಲಿದೆ? FR ಇದೆಯಾ?
CC ಆಗಿದೆ ಸುಮ್ಮನೆ ಒಂದು FR.
ಇಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ನಾವು ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಆಗಿದೆಯಾ? ನಂಬರ್ ಕೊಡಿ ಅಲ್ಲ. ಎಸ್ 1 HCGP 2 emergent notice. Split. Accused number? ಎಲ್ಲಿ ಅಕ್ವಿಟ್ ಆದ್ರು? ಪೇಜ್ ಅಕ್ವಿಟಲ್ ಆರ್ಡರ್ ಕೊಡಿ.
Page starts from page number 115, Manoj.
115.
My lord, before the trial court, my lord, 3, 4, 7, 8, 9, 11, 13, 14 and 16 were.
115 is court division bench orders.
Division bench ಅಲ್ಲಿ.
All accused were convicted in the trial court.
ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಹೌದು. ಕನ್ವಿಕ್ಟ್ ಆಗಿದ್ರೆ ರಿವರ್ಸ್ ಆಗಿದೆಯಾ? ಓಕೆ. The yes.
Yes, my lord. That is 3, 4, 7, 8, 9.
3, 4.
3, 4, 7, 8, 9, 11, 13, 14 and 16, my lord. They were convicted, my lord, by the trial court. And they preferred an appeal.
Remaining accused acquitted.
Acquitted. But appeal ali even.
Ellaru acquitted.
Except accused number 1.
Accused number 1. You are accused number 6.
Accused number 6.
Yen 399 402 na? 149? 307.
307, 326, 324 and 307.
Only against A1.
So your role is akin to who, which accused?
That's all other accused. 3 to.
He stands on par with.
On par with
3
whom?
to 16.
3 to
But you
16.
could get that at ink page number 156 ಅಲ್ಲಿ, paragraph number 37, there is a finding given by the coordinate bench.
155.
37 ಅಲ್ಲಿ.
Para 37.
Please, my lord.
Not satisfied, 3 to 16. Yes.
3 to 16.
Cover I. The petitioner is before this court seeking the following bada. Calling in question proceedings in SC 37 of 2024 hyphen a split up case arising out of SC 90 of 2005. The petitioner is accused number 6. He, along with others, get embroiled in a crime number 4 of 2004 for the following offenses. Synopsis ಅಲ್ಲಿ box number 2 tick ಮಾಡಿದೆ. The police, after investigation, file a charge sheet and the matter was tried before the Court of Session in SC 37 of 2004. On 31st October 2012, the Court of Session convicts all the accused therein for the aforequoted offenses. The said conviction was called in question by the accused. Ellarnu convict madidra illa?
Trial court ಅಲ್ಲಿ conviction ಆಗಿದೆ.
All of them. Filed an appeal before this court in Criminal Appeal 241 of 2018. The said criminal appeal comes to be dismissed by a division bench in terms of its order dated 4th April 2024, whereby all the accused are acquitted except accused 1 and 2, except accused number 1. The finding rendered by the division bench would undoubtedly inure to the benefit of the petitioner, as the division bench clearly holds that the ingredients that are necessary for the offense to become punishable under section 149 of the IPC is not satisfied against accused 3 to 16. The petitioner is accused number 6. Therefore, the reasons so rendered by the division bench and the finding would clearly inure to the benefit of the petitioner. Though in the normal circumstance, the petitioner should be directed to undergo the same. You were filed it before the division bench, isn't it? In the normal circumstance, better. In the light of the acquittal of accused 3 to 16, accused so and so. The reason so rendered by the division bench reads as follows. Para 21 in the end org hakbidi. The reason so rendered by the division bench to acquit accused 3 to 16 would undoubtedly inure to the benefit of the petitioner, as he is accused number 6 and on par with accused number 3 to 16. In that light, without permitting further proceedings to continue against the petitioner, the petition deserves to succeed. The view of mine in this regard, Hakpate. We will send it early, right? 2 days. We'll release it in 2 days, sir. A direction connect to the jail authorities. 311. Voxo, 8 years. Age of the victim. But cross examination agilla.
Cross examination.
Adralla acquit ಆಗ್ತಾರ ಆಮೇಲೆ. After conviction.
Please, ma'am.
ಜಗದೀಶ್ ಮೊನ್ನೆ ಹೇಳ್ತಾ ಇರಲ್ಲ. Cross examination ಆಗಿಲ್ಲ. Then adralla acquit ಆಗ್ಬಿಡುತ್ತೆ. The petitioner is before this court calling in question an order dated 4/5/2024 by which the concerned court rejects the application filed by the petitioner under section 311 of the CRPC, seeking recalling of PW 1 and 2 in special case 60 of 2019 registered for offences so and so. The heard so and so. Facts in brief germane are as follows. A crime comes to be registered in crime number 6 of 2017 against the petitioner for offences punishable under so and so. Synopsis and secretary. The police, after investigation, filed a charge sheet against the petitioner for the following offences. Adu second item. The issue in the list does not concern the merit of the matter before the concerned court. The petitioner files an application under section 311 of the CRPC seeking recall of PW 1 and 2 for cross-examination. This comes to be dismissed by the impugned order dated 4/5/2024. The learned counsel for the petitioner submits that no doubt the petitioner was given certain opportunity to cross-examine PW 1 and 2 and he has lost the opportunity. But it cannot be a case where the petitioner is not permitted to cross-examine the victim or the mother of the victim at all. He would submit if one opportunity is granted. He would complete the cross-examination on the day fixed by the concerned court. The learned HCGP would, however, refute the submission to contend that not one but 3 opportunities were granted to cross-examine PW 1 and 2 and the applications of the kind were also allowed on costs. Therefore, he would submit that if cross-examination is to be permitted, it should be with costs. I have given my source. Therefore, narrated facts are not in dispute. The petitioner is facing trial for an offence which can lead him to imprisonment beyond 10 years, as it is an offence for the offence punishable under section 376, 4, 8, and 12 of the POCSO Act. No doubt the perusal at the order impugned would indicate that the petitioner was given opportunity to cross-examine PW 1 and 2, but he has lost the said opportunity by being negligent about his rights of negligent about the fact of cross-examination of PW 1 and 2. But the fact remains, today, the petitioner has not cross-examined PW 1 and 2 at all. It cannot be a case of no cross-examination of the witnesses in the light of the offence being heinous and the offence being heinous and having dire consequences. The purport of section 311, purport of section 311 need not detain this court for long or delve deep into the matter. The apex court in the case of Varsha Garg versus so-and-so, 2022 SCC online SC page 986 para 31 to 40 has held as follows. In the light of the fact that the petitioner has not cross-examined PW 1 and 2 at all, the petitioner deserves an opportunity to be granted to cross-examine the witnesses, PW 1 and 2. But that cannot become a ruse to drag the proceeding before the concerned court. In that light, I deem it appropriate to pass the following order. Allowed, quashed, The petitioner is permitted to cross-examine PW 1 and 2. PW 1 and 2. The cross-examination of the victim shall happen strictly in consonance with the act, with the questions being put through the court and not directly by the petitioner to the victim, as the age of the victim is now 9 years old. The concerned court shall, the petitioner shall not have any further opportunity of filing an application of the kind that is now answered by this court. This is the last straw of opportunity to the petitioner. The concerned court shall regulate its procedure to conclude the cross-examination on the day or another, or grant one more date for such cross-examination and regulate its procedure.
Past, my lord. Because 4,000 is already pending, my lord, which the trial court has
Adhan,
imposed.
this shall be the cross-examination shall be permitted only after the petitioner complies with the default in payment of costs for earlier applications.
Please.
Namadu beda.
Please.
Split,
Please, my lord.
huh? 402. Where is the order? The petitioner is before this court. Your accused number? The petitioner, accused number 2, is before this court, calling in question proceedings in CC 1520/2020, registered for offences punishable under 399 and 402 of the IPC. Heard sounds. The petitioner, along with others, get embroiled in a crime for it being registered on 31/3/2017 for offences punishable under section 399 402 of the IPC. The petitioner at the relevant point in time was not available for trial, and therefore a split charge sheet is drawn against him. The concerned court, in terms of its judgment dated 12/1/2023, acquits 1, 3, and 4. The person, the only accused remaining in the case at hand is accused number 2, the petitioner. The petitioner is accused, no, remaining better. The petitioner is accused number 2. The order passed by the concerned court to acquit accused 1, 3, and 4 is as follows. Page para 16, page 79 till the end. There 79, 82. The offense is the offense alleged is the ones punishable under section 399 402 of the IPC. If the prosecution has failed in production of material incriminating to link the offense to the petitioners, to the accused 1, 3, and 4, the same would inure to the benefit of accused number 2 as well. Permitting further trial against this petitioner would only be a waste of judicial time, which is too precious today for permitting further trial to be conducted for the in the case of the petitioner only to be acquitted. For the aforesaid view of mine. Yes, next.
29.
311. Yes, sir. Yesterday, where were you? Hello, Madada.
There are admitted in the signature in the cross-examination.
Admitted signature.
Exhibit P1.
What is the next date, sir? 3/8. Saturday. Yes, list on Friday. In the fresh matters list. Next.
For the petitioner, my lord.
7A88, BB Patil is directed to accept notice for the respondent's petition to serve set of papers upon the aforesaid council. List on 88.
I may be permitted to submit some more documents of the domestic.
Wow. Registry file madi. Let's get into the file. 319 application. Sukhpal Singh Khaira, para 42. ಮೊನ್ನೆ ಒಂದು ಬರ್ದಿದ್ದೀನಿ ಕೊಡಿ 23 ಅಲ್ಲ about last week I pronounced one of an advocate who was sought to be brought back. ಇದು 304A, sir.
304, this is the 304A.
Who are you, contractor?
I'm a contractor, it was principal contractor is, it's a government GO issued to one SRB minus, SRB Power Private, Power Private Limited. They subcontract some work to me minus. I have subcontracted to one, Elmex Solutions.
You can't help, sir. The link in the chain of events will take everybody in its sweep.
Myself and, subcontractor has been, read as additional accused witness.
Pinyar bek nimge.
Principal
Whomever you want, I will direct. Tell me.
Yes, because even the SRB Power Private Limited, they are the principal, contractors. My lords, the complaint
Sir,
is not-
principal contractor had leased a subcontracted to you. Who was responsible at the site?
My lords, it is, the person who I entrusted the work, my lords. it's
Ah,
the
who is
subcontractor.
that?
Elmec, Solutions.
He is not, they are not accused?
They are, now they are facing the panels, they are also made accused number 2 in this, additional accused number 2.
But you being the contractor, very difficult to get over.
This is what the observation made by the trial court, my lord, in page number 22, paragraph number 21.
ಇದು ನಿಮ್ಗೆ applicable ಆಗಲ್ಲ.
Just because here.
Their own supervisor, my lord, he says without obtaining the permission, we were carrying out the work. On that point, my lord, after the examination of PW1, my lord, this application came to be filed by the prosecution.
Your lords, your lordship says that referred these cases when somebody,
Ambalaldi, but I know, sir. Rash and negligent act.
plus, owner of the.
That, sir, owner, architect, ಇದೆಲ್ಲ ಬರಲ್ಲ. But you are the contractor.
Here.
ಏನ್ transformer?
Please, my
That's what, because it was the beginning
high tension wire, my lord.
work of the, because it was on Sunday, they were used to work, my lords, that's why, it was fell on the crane fell on the high tension wire, my lords,
No, sir. Difficult.
and,
Contract ಆದ್ರೆ difficult.
This is, my lords, the contractor and subcontractor paid compensation also. In recorded,
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
8 lakhs. In recorded.
No, we'll issue notice now. One,
Complaint is already, this is, my lords, his evidence is also not like.
oh, he succumbed to the injuries, is it?
Allah, he is, sir,
Complaint also is no more now. State will defend its action. We'll see. List on 20th. Next date yavat?
warrant issue ಮಾಡ್ತಾರೆ. 9/9 ಗೆ.
They never appear, my lord. 4 dates, my lord, they
You
never appear.
appear
Warrant
before,
has been
appear
issued.
before the court. Yes, we'll take it and tell the matter is pending here.
Here, lodgement bail, it's all the.
Bail ತಗೊಂಡಿಲ್ವಾ? Bail ತಗೊಳ್ಳಿ first. Bail ತಗೊಳ್ಳಿ first, yes. List the matter on 20th in the fresh matters list. No, the learned counsel of the petitioner submits that he would secure bail and then make his submissions in the case at hand. In the event an application seeking bail is filed before the concerned court, the same shall be considered in accordance with law. ಅಷ್ಟೇ same day, ಅಷ್ಟೇ ಸಾಕು. Yes.
32.
Petitioner is the owner of the vehicle.
Bank guarantee.
Division court may reduce to 2,50,000.
Bank guarantee ಎಲ್ಲಿಂದ ಕೊಡಕ?
No, the 2.5 lakhs ಇದು 1 lakh ಮಾಡಿದ್ದಾರೆ revision.
Bank guarantee. ಅದು ಇಲ್ಲ, indemnity ಕೊಡ್ತಾರೆ. Yes. 1 ಲಕ್ಷನೂ ಆಗಲ್ವಾ? ಯಾಕೆ?
Other condition.
What vehicle ಏನು?
Apply other conditions.
Vehicle ಏನು?
Bus man, it's a private bus man. Now.
ಬಸ್ಸಾ? ಬಸ್ ಏನ್ ಕೊಡಕ್ ನಿಮ್ಗೆ? Accident ಆದ್ಮೇಲೆ ಲಾಸ್ ಆಯ್ತಾ?
Since 5 months.
The petitioner is before this court seeking the following prayer. The petitioner, the vehicle of the petitioner, which is said to be a four-wheeler, a bus, is the subject matter of proceedings before the concerned court for an offence under section 279 and 337 of the IPC. The release of the bus was sought by filing necessary application before the concerned court, which is permitted, but with a condition that he would furnish, the petitioner would furnish a bank guarantee of rupees 2.5 lakhs. It is later said to have been modified for furnishing of a bank guarantee of rupees 1 lakh for release of the vehicle. The seeking bank guarantee would be more onerous than the relief that is granted by the court. Therefore, that portion of the order that directs furnishing of bank guarantee stands quashed. The petitioner shall abide by every other condition that is stipulated in the order impugned, ordered accordingly. Yes, next.
33.
Magistrate passes the order. I am not a offender, I am the accused. In 138 proceedings, the magistrate passes the order for issue the FLW for not pay the compensation of 10%.
143A. Compensation ಯಾವ್ದ್ರಲ್ಲಿ?
138.
ಅದು 133 ಕಾಂಪನ್ಸೇಷನ್ ಯಾಕೆ 143 ಅಲ್ಲಿ ಆಗಿರೋ ಕಾಂಪನ್ಸೇಷನ್ ಅದನ್ನೇ ಕೇಳ್ತಿರೋದು. ಎಸ್ ಅಂಡರ್ 143A2 he has passed this order that recovery ಯಾವಾಗ ಡೆಪಾಸಿಟ್ ಮಾಡಿ
It is in matter, it is in defense evidence.
so what sir deposit here ಎಷ್ಟು ಅಮೌಂಟ್ ಚೆಕ್ ಅಮೌಂಟ್ ಏನು
Issued the 420.
ಚೆಕ್ ಅಮೌಂಟ್ ಏನು ಸರ್
That is 10 lakh. Here, my lord, the 421, it's very clear that, my lord.
one emergent notice to the respondent. The order that directs deposit of 10% to the petition, 10% of the amount. FLW ಇದೆ?
It is order in page number 66, my lord.
So it's emergent notice to the respondent. A fine levy warrant hanging on the head of the petitioner shall remain stayed till the next date of hearing. Yes.
34.
Your Lordship, appearing for the petitioner, I seek a week's time, Your Lordship.
Next week at the request.
Sir,
Stay ಇದೆಯಾ? ಏನಿದೆ?
34, my lord. ಇದರಲ್ಲಿ ಸ್ಪೆಷಲ್ PP ವೀರಣ್ಣ ತಿಗಡಿ represent.
Yes.
Notify him.
List next week, next date ಕೊಡಿ madam. At the request of the council appearing for the petitioner. Next. 13 avara ಬೇಡ. Next 20th. 21st. List on 21st. In extension time. GM. Petitioner ಈಗ ನೀವು.
For the respondent.
In extension of time?
They had, as Your Lordship may kindly see that.
Not paid?
Not even a single.
Not a rupee?
Not a rupee, my lord. 23-24ರಲ್ಲಿ 20% ಕಟ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
One ನಿಮಿಷ. This court
Page number 4.
disposes the petition, subject petition in terms of its order dated 21st February 2024 by observing as follows, page 4 and 5 of the order, madam. The learned counsel for the respondent Neeraj Damodar submits that not even a rupee is paid to the bank after the order dated 21st February 2024. The petitioners have now preferred an application application seeking extension of time in the light of no bona fides being projected by these petitioners by making any payment. The application would not no order on the application that would be in favor of the petitioners can be passed. The application is thus rejected. Yes.
36.
Application IA 1 of 24 is thus rejected. ನಿಮ್ದೇನು extension of time? ಇದರಲ್ಲೂ ಕೊಟ್ಟಿಲ್ವ ದುಡ್ಡು? They have not paid any amount?
No. No, madam. They have not
Disposal
paid
and-
and the possession has also been given to the auction bidders.
No representation on behalf of the petitioner. List after 4 weeks. Pendency of the application will not come in the way of any proceeding on the issue. Interim order.
The possession have been given to the auction bidders.
ಒಂದು ನಿಮಿಷ ಕೊಡಿ. Within 8 weeks. There is no representation on behalf of the petitioner.
For petitioner.
ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ದುಡ್ಡು?
How the action has been conducted.
ಅವರು ಕೊಟ್ಟು ಆಗಿದೆಯಂತೆಲ್ಲ. The learned counsel appearing for the respondent bank submits that the auction is over and the property is already handed over to the auction purchaser. In that light, the present application would not survive for any consideration. It is disposed as become unnecessary, as having become unnecessary. Next.
37. For notice for the second time, it is as against the complainant itself, lordship. In the complainant, he has given the same address. And we have already issued.
We
notice.
don't know, madam. Yes. It report, you take out steps once more, yes.
But we have not that state.
No, no, if it is not been granted, it's not been granted.
The police officials,
Hmm.
as the respondents herein are the police officials.
Hmm.
And the dispute mainly is with regard to specific performance of an agreement. Wherein the complainant. has-
Atrocities Act idea?
ಇಲ್ಲ,
Illa,
Huh?
lordship.
the 406 and 420.
Section lordship, but
I
it's with regard to an agreement.
We'll see.
where once
List,
we-
list on Monday in the fresh matters list. Wait, ಅವರೇ ಮಾಡ್ಲಿ. Yes. We'll list it on Monday. You read and come.
Lordship,
ಏನಾಗುತ್ತೆ ಮಂಡೇ ಅವರಿಗೆ?
Address your lordship.
ಅದಾಯ್ತು, ಅದೆಲ್ಲ ಹೇಳಾಗಿದೆ. Yes. List on Monday in the fresh matters list. We'll consider it, yes.
58.
ನೀವು ಇದು ಫೇಸ್ಬುಕ್, ಇನ್ಸ್ಟಾಗ್ರಾಮ್ ಇರಲೇನಾ ಬರೋದು? ಹಾ?
Complainant, my lord,
354 AD.
50 years age.
So?
She has been, my lord, arrested in a blackmail case, my lord. She was in custody. Can you see the documents? And later, my lord, she was in custody and my lord, the entire team was not arrested.
ಟೀಮ್
Our team,
ಅವ್ರ ಟೀಮೇ ಇದೆಯಾ?
the kind of honey trap, my lord, they used to blackmail the youngsters, my lord.
Through Facebook and Instagram.
They do not collect some ransom and want to blackmail them. And in one of such cases, he was arrested. Not after the arrest, my lord, this complaint has been filed against this advocate. Petitioner is an advocate.
You're an advocate. Why did you accept a friend request?
The allegation is not only, my lord, against the complainant. It says, my lord, some other ನನ್ನನ್ನು ಮತ್ತು ಇತರ ಹೆಂಗಸರನ್ನು ಯಾವಾಗಲೂ ಈಗ ಸರ್ಕಲ್ ಬಳಿ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಮುಂತಾದ ಕಡೆ ಹಿಂಬಾಲಿಸುತ್ತಾ ಚಲನ ಓನ್ಲಿ ಮಿಲಾಡ್ ಚಾರ್ಜ್ ಶೀಟ್
ನೀವು ಕೋರ್ಟ್ ಬಿಟ್ಟು ಅದೇ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ನೋ ರಿಕವರಿ, ದೇರ್ ಇಸ್ ನೋ ಮಿಲಾಡ್ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಎವಿಡೆನ್ಸ್, ಅಟ್ ಲೀಸ್ಟ್ ಫೇಸ್ಬುಕ್ ಪೇಜ್, ನಥಿಂಗ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಹ್ಯಾಸ್ ಬೀನ್ ಫೈಲ್ಡ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಿಟ್ರಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ನಾವು ಎಂಟೈರ್ ಚಾರ್ಜ್ ಶೀಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ, ಏನೂ ಇಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್.
ಎಲ್ಲಿದೆ? ಹಾಕಿದ್ದೀರಾ?
ಪೇಜ್ 22 to 38 ಅಷ್ಟೇ ಇರುತ್ತೆ. No seizure, nothing.
ಇದರಲ್ಲಿ ನೋಡಿ ಏನೂ ಇಲ್ಲ. Yes, sir.
The fact that the involvement in the other crimes and not that he has been arrested.
Other crimes ಕೊಡಿ ಇಲ್ಲಿ. ಇದಾಯ್ತು.
138 from.
ಒಂದು ನಿಮಿಷ. Crime number 13.
But in the FIR, my lord, her name was initially registered as Jyoti. And her name is, my lord, she used to change the name while dealing with all this kind of thing. And real name is Padmaja.
ಇದು ಕರೆಕ್ಟಾ?
They corrected it. Charge sheet, my lord, page 2.
ಇದರಲ್ಲಿ ಯಾರು ಇದು?
Jyoti, accused number 3.
ಅಲ್ಲ, ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು?
Complainant is one of the victims who was not alleged to be trapped. His name is Praveen Kumar. Crime number 13, page 2.
ಏನಿದು ಪೇಜ್ 14?
Page 14, this was published in the newspapers.
ಹನಿ ಟ್ರ್ಯಾಪ್.
Honey trap ಆಗಿದೆ ಅಂತ ಅವ್ರ ಫೋಟೋ ಇದೆ. This was, my lord, the newspaper report from Vijayawani. Then, my lord, the web channels like Suvarna News at page 16. And, my lord, there is one more aspect, my lord, in the report. But at page 19, this is also dangerous. Page 19.
ಈಗ ನಿಮ್ಮ ಮೇಲೆ ಏನು?
Tracking.
ಸ್ಟಾಕಿಂಗ್.
ಕೋರ್ಟ್ ಹತ್ರ, ಸರ್ಕಲ್ ಹತ್ರ, ಸಾರ್ವಜನಿಕ ಸ್ಥಳ, ನೋ ಟೈಮ್, ನೋ ಪ್ಲೇಸ್, ನೋ ಡೇಟ್, ನೋ CCTV ಫುಟೇಜ್, ನೋ ಸೀಜರ್ ಆಫ್ ಎನಿ.
ಎಲ್ಲಾ ಕಡೆ ಹಿಂಬಾಲಿಸ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ದೀರಾ?
ಅದೇ ಒಂದು ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾರೆ. And moreover, he was a spokesperson of a
ಅದಾಯ್ತು,
political party.
ಗೊತ್ತಾಯ್ತು.
ಲ್ಯಾಪ್ಟಾಪ್ has been seized. ಲ್ಯಾಪ್ಟಾಪ್ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ.
Laptop ಅವ್ರು.
ಆಮೇಲೆ
ಯಾರ್ ಲ್ಯಾಪ್ಟಾಪ್? ಅದೆಲ್ಲ ನೋಡಕ್ ಹೋಗ್ಬೇಡಿ.
My lord, senior Counsel said, ಏನು ಸೀಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಲ್ಯಾಪ್ಟಾಪ್ ಒಂದು ಮಾಡಿದ್ದಾರೆ.
ಹೌದು. ಪೆನ್ ಡ್ರೈವ್ ಸೀಸ್ ಮಾಡಿದ್ದೀರಾ? ಇಲ್ಲ.
ವಿದ್ಯುನ್ಮಾನ ಯಂತ್ರಗಳಲ್ಲಿ ಫೋಟೋ, ವಿಡಿಯೋ 15 ವರ್ಷದಲ್ಲಿದ್ದ ಗಣಕಯಂತ್ರ ದೈನಂದಿನ ಚಟುವಟಿಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ಸಂಗ್ರಹಿಸಿದವರ ಮಾಹಿತಿ ಆಗಿರುತ್ತದೆ. ಆ ಕಂಪ್ಯೂಟರ್ ಎಲ್ಲ ಫೋಟೋ ತೆಗೆದು ಆಮೇಲೆ ನೋಡಿ ರಿಕವರಿ ಮಾಡಿದ್ದಾರೆ. ಅದರದ್ದು ಫೋಟೋಸ್ ಇರೋ ಲ್ಯಾಪ್ಟಾಪ್.
Heard the learned senior counsel Arun Shyam appearing for the petitioner. The offense alleged against the petitioner, sole accused. The petitioner is an accused in CC 2440 of 2023. The second respondent is the complainant. A complaint comes to be registered against this petitioner, a practicing advocate, that he has been stalking the complainant and therefore the offense under section 354D has sprung. Apart from section 354A, which deals with sexual harassment, inter alia. The learned senior counsel submits that a complaint is the complaint, which is as vague as vagueness could be, is registered against this petitioner, that during the court hours he was stalking, following the complainant everywhere in the city of Bangalore.
ಅಲ್ಲ, ಇದು ತೀರ್ಥಹಳ್ಳಿ.
Everywhere in Tirthalli.
And 1 year ಇಂದ ಕಳೆದ 1 ವರ್ಷದಿಂದ.
For the last 1 year. The learned counsel, senior counsel would submit that the second respondent complainant indulges in honey trapping people. He would place on record certain crimes registered against the complainant. One in crime number 13 of 2022 registered by another victim like the petitioner. The police have filed a charge sheet against the present complainant in the said crime, and the trial is on for those offenses of blackmail, extortion, the offenses of extortion, cheating, inter alia. The police have conducted investigation and filed a charge sheet even. Column number 17, the summary of the charge sheet reads as follows. It is as vague as the complaint itself. There is no investigation worth the name conducted by the investigating officer, and for the sake of filing a charge sheet, the charge sheet appears to have been filed, albeit prima facie. Therefore, there shall be an interim order of stay of all further proceedings qua the petitioner till the disposal of the petition. 1 HCGP 2 emergent notice.
Grateful, obliged.
39.
Lords, appearing for the petitioner, my lords, kindly seek a short passover, my lords.
Short passover?
Passover means.
Short passover.
Passover.
An hour miss ಮಾಡ್ಬಿಟ್ಟೆ. Yes.
40.
40. Defreeze bank account.
Yes, my lord. My lords, I'm ready to take up any conditions imposed by this honorable court.
No, not, yes, comment.
My lord, 40 lakhs, my lord, has been transferred to the account of the petitioner, my lord.
Mark a lien on that. The account al duddu.
My lords, it's hardly 2-3 lakhs and problem.
2-3 lakhs.
My lords, problem is that's an overdraft account, my lords.
ODL.
And it has been already classified as NPA during pendency of these proceedings, my lords. And now bank is trying to initiate the money recovery against me, my lords. And moreover.
Specialist paper, ನಿಮಗೆ ಹೇಳಿದ್ನ.
Money has been gone to.
Then we'll take it tomorrow.
Yes.
Just look into it and list tomorrow in the fresh matters list. Next.
41.
Non-furnishing of PF.
13%.
ಯಾಕೆ PF ಕಟ್ಟಿಲ್ಲ R2ಗೆ?
My lord, the accused need not be heard at this stage.
ಏನು prayer ನಿಮ್ದು?
Reinvestigation. I had
Oh.
filed an application before the.
All right. Yes, sir. Tell me. ಏನ್ ಪರವಾಗಿಲ್ಲ ಹೇಳಿ.
Swami, High Court, Supreme Court has passed an order saying that at this stage, the accused need not be heard.
No problem. Tell me, sir.
My lord, I have filed the charge sheet along with the memo.
What is the case for reinvestigation? Tell me, sir.
My lord, firstly, spot majorally, I have never seen the investigation officer. Spot major yaro beror torsidare. One by the name Ramurthy. I have attached the charge sheet as well. Thereafter, planted eyewitness, 2 eyewitnesses are there. One is the accused friend, another one.
What is the allegation?
Allegation atrocity act. I'll come to the third point. My lord, I had recorded video of abuse, abusing my caste also. The IO has never met me. He has never sought those things. Even before that, he has filed a charge sheet before the trial court. But before filing charge sheet before the trial court, he has filed an application before the CCH 71, which is at.
Yes, look into it.
My lord, it is
Notice to the second respondent at this wait, sir. Notice to the second respondent at this juncture need not be issued. The learned additional SPP is directed to go through the papers and make submissions with regard to the allegation of the petitioner that the investigating officer has conducted a shoddy investigation and has not even recorded the statement of the petitioner, nor taken the CCTV footages which clearly indicate hurling of abuses by the accused against the petitioner. The learned additional SPP will secure instructions and make his submissions. List the matter on 21st.
One point. Idralli Sullu Jati, he says that he has given information to the IO.
Dismiss madidina.
Allah, sir.
21st, come on 21st. Yes.
The notice, my lord, section 91 of the CPC. It is allegation that, my lord.
ಅದೇ ಇದು jewelry ಇದು.
Jewelry purchase ಮಾಡಿದಾರಂತ.
No ground. Anything else, sir?
ಇಲ್ಲ, ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ.
We will dismiss it. Yes.
ಅದರಲ್ಲಿ
ಏನು ಗ್ರೌಂಡ್ ಇಲ್ಲ.
ಇಲ್ಲ, ಆದ್ರೆ ಅಕ್ಯೂಸ್ಡ್ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ರಲ್ಲಿ ನಾನು ಇಲ್ಲೇ ಮಾರಿದ್ದೀನಿ, ಇವರಿಗೆ ಮಾರಿದ್ದೀನಿ.
That's a matter of trial, sir.
ಅಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟೇ ಕೊಟ್ಟಿಲ್ಲ. ಇವರು ಪೊಲೀಸರು ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ಭವಾನಿ ಜ್ಯುವೆಲ್ಲರ್ಸ್ ಡೈರೆಕ್ಟ್ ಆಗಿ ಬಂದು ಇದೇ ಭವಾನಿ ಜ್ಯುವೆಲ್ಲರ್ಸ್ ಅಲ್ಲಿ ನೀನು ಮಾರಿದ್ದು ಅಂತಕೊಂಡು ಹೇಳಿ ಅಕ್ಯೂಸ್ಡ್ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಇವರೇ ತೋರಿಸ್ತಾರೆ ಪೊಲೀಸರೇ.
ಈಗ ಏನು why you come before the court?
ಅಲ್ಲಿ
91 application is rejected.
Result is issued, my lord, to appear for investigation based on the statement given by the accused.
The complaint
They are not appeared, my lord.
Notice dated 91 notice to appear before the investigating officer.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅವರು.
Heard the learned counsel appearing for the petitioner. Petitioner notice ಕೊಟ್ಟಿದ್ದಕ್ಕೆ writ petition ನಾ?
ಸ್ವಾಮಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾಗ ಅಷ್ಟಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಹೇಳ್ತಿರೋದು ಬರೀ ನೋಟಿಸ್ ಅಷ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ ನನಗೆ. ಕೊಟ್ಟಿದ್ದಾಗಿದ್ರೆ ನಾನೇ ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದೆ. ಇವರು ಡೈರೆಕ್ಟ್ ಆಗಿ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ವಿಥೌಟ್ ನೋಟಿಸ್ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ಜ್ಯುವೆಲರಿ ಶಾಪಿಗೆ ಬಂದ್ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದ್ದಾರೆ. ಇದು ಐ ಆಮ್ ಗ್ರೀವೆನ್ಸ್. ಡೈರೆಕ್ಟ್ ಆಗಿ ನೋಟಿಸ್.
1 minute. If 91 notice you don't respond, they will only come.
ನಾನು ರೆಸ್ಪಾನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅಲ್ಲಿ ಮೆಟೀರಿಯಲ್ ಇಲ್ಲ.
When do you appear before the investigating officer?
Sir, before ಇದ್ರಲ್ಲೇ ಶಾಪ್ ಅಲ್ಲೇ ಬಂದಿದ್ದು, ಶಾಪ್ ಅಲ್ಲೇ ಬಂದು ಅಲ್ಲೇ ಸ್ಪಾಟಿಗೆ
Now when do you appear before the investigating officer?
ಸ್ವಾಮಿ ನಾನ್ ಹೇಳ್ತಿರೋದು ಪೊಲೀಸರು ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ಅವತ್ತೇ ಬಂದು ಅವತ್ತೇ ನಾನ್ ಡಿಮಾಂಡ್ ಮಾಡಿದಲ್ಲಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದು ನನಗೆ. ಬಿಫೋರ್ ಏನಪ್ಪಾ ನೋಟಿಸ್ ಕೊಟ್ಟು ಅವ್ರು ನನ್ನ ಹತ್ರ ಬಂದಿಲ್ಲ.
ಈಗೇನ್ ಇನ್ನೇನ್ ಬೇಕು?
ಸರ್ ನಾನು ಹೇಳ್ತಿರೋದು
what do you want now in this case?
ಸರ್ ನಾನು ಹೇಳ್ತಿರೋದೇನು ಅಂತ
what do you want now in this case?
ಅಲ್ಲಿ ಬಂದಿದೆ ತಪ್ಪು ಅಂತ ನಾನು ಹೇಳ್ತಿರೋದು ಇವಾಗ.
ನೋಡೋಣ. Yes. Learned additional learned HCGP to file statement of objections if any in the next 4 weeks. List after 4 weeks. Yes, next.
ಡೇಟ್ ಕೊಡಿ ಸ್ವಾಮಿ.
Move ಮಾಡಿ. Yes, next.
Appointment of special public prosecutor was called in.
This matter last time
was quashed. But now the thing is remuneration has to be paid by the complainant. That is squarely, my lord, covered, my lord.
No, that is true. I have stated on that ground only.
Yes, my lord. And then another aspect is, my lord, he has filed a transfer petition for the complainant. Earlier, my lord, the complainant's advocate becomes the special public prosecutor.
Yes, sir.
Now special public prosecutor becomes the complainant's advocate.
ಯಾಕೆ ಬೇರೆ ಯಾರು ಸಿಗದೇ ಇಲ್ವಾ? ಏನ್ ಪ್ರಾಬ್ಲಮ್ ನಿಮ್ಗೆ? You will never allow the trial to conclude only because of your overindulgence.
23 witnesses have been examined.
So what, sir? It cuts at the root of the matter, sir.
Lapse of nearly 2
Maybe
years.
it cuts at the root of the matter.
After lapse of 2 years, this petition is filed. Only one submission. I'm not disputing legal position, my lord, as such.
Nothing.
So my actual submission is, my lord, at least for some time, my lord, at least 1.5 months, to pursue, my lord, to appoint a special prosecutor by the government. Till then, my lord, trial may be stayed. It's, till then, trial may be stayed, my lord. Otherwise, my lord.
No, this
it's
is the
in the
agenda.
murder in
Trial
the
already
daylight.
stay ಇದೆಯಲ್ಲ?
Trial is going.
Trial is stay
The
illa.
lordship made it clear.
Here is a
They-
case, my lord,
regular
where
prosecution.
So let the trial go on.
Court PP.
where accused.
That is the agenda, my lord. They want to stall the
No,
trial.
my
Earlier
lord.
also they have
No,
taken
that
stay
is
of
not
the
my agenda. That is not my agenda. Kindly, my lord,
Trial will go on, sir.
kindly, my lord.
You will not function as special SPP. Whoever is appointed, trial will go on.
Kindly, my lord, for a moment. I'll
sir.
place the record, my lord, that how trial is conducted and what happened, my lord, earlier to appointment of a prosecutor. I'll place the records, the
You
evidence, my
place
lord, which have
anything,
been
sir. You place anything.
kindly tomorrow, my lord.
Not
I'll-
tomorrow, sir.
I have secured, my lord. I'll
List
mark.
the matter on 20th in the fresh matters list. The learned counsel Kashinath JD appearing for respondent number 4 submits that he has to place certain documents on record.
Kindly one
The
submission.
interim
I
order
I have
subsisting.
received, my lord. I'll just mark it and submit, my lord, the evidence.
Interim
which
order
is-
subsisting shall continue till the next date of.
Kindly one submission, one submission, my lords. Only one submission.
Yes, sir.
One submission. Here is a case, my lord, where out of 130 witnesses, my lord, 25 witnesses are examined.
Parvalla.
23 witnesses have been
What
hostile.
were you doing while the examination was on?
23 witnesses have been
Lord, the
hostile.
moment,
All right,
the
sir.
moment
It
he
goes.
filed a transfer
Kindly,
petition, we
it
kept
Those
goes.
witnesses, my
the
lord,
course of action.
after cross-examination, they supported the prosecution case.
See. Yes.
The moment they filed, my lord, the transfer petition, my lord, I got the cause of action.
No, my lord,
Challenge.
transfer
ಯಾವ
petition
transfer
is-
petition? Sir, 23 witnesses
Ah.
examine ಆಗೋವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ?
ಅವಾಗ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಬಟ್ ಲೇಟರ್ ಮೈ ಲಾರ್ಡ್ ಹಿ ಬೀಂಗ್ ದ ಪ್ರಾಸಿಕ್ಯೂಟರ್
When, my
takes
lord, the
brief
20th
for the
ಬೇಡ.
complainant.
List on 12th ಅಂತ ಮಾಡಿ. 12th and the fresh matters list. Next.
Four.
Post immediate. ಬಂದಿದೆ.
Yesterday I issued copy.
Learned counsel so and so undertakes to enter appearance for the second respondent registry to print the name of so and so as appearing for the second respondent.
Pass over, my lord.
Why?
Seniors held up paper.
ಏನಿದು?
306.
ಇಲ್ಲ, there is a stay order.
Stay ಇದೆಯಲ್ಲ?
Stay ಇದೆ.
ಮತ್ತೆ ಯಾಕೆ pass over? This is not correct. Yes. List the matter after 4 weeks, objections if any by then. Next. Interim order subsisting shall continue till the next date of hearing.
The investigation papers were asked by the government.
Husband is the complainant.
Husband's mother is the complainant, my lord.
Mother, yes.
The issue rose because both the children are in the custody of the husband. It happened because of a complaint that's already.
One HCGP, 2 emergent notice returnable by the 28th of August. Further FIR,
FIR.
further investigation query this petitioners till the next date of hearing shall remain stayed.
Much of it.
Next.
46.
Accident of somebody, my lord.
So
I am the
list after
passenger.
2 weeks, interim order subsisting shall continue to the next date of hearing.
Let's make, seek for a date.
No, yes, next.
47.
Kindly have it on tomorrow, my lord, for reporting settlement, my lord.
ಇಲ್ವಾ ಈಗ?
Station, ನಾಳೆ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿ.
Friday ತಗೊಳ್ಳ?
Yes, ma'am.
List on Friday, 2:30 PM to report settlement.
But the ex parte order was passed. my lord.
125.
Yes.
ಎಷ್ಟಿದೆ maintenance due?
My lord, what happened is, my lord, while remanding the, my lord, matter, the session judge said, my lord, 2 lakhs per month ಕೊಡ್ಬೇಕು. That is the difficulty, my lord. Now, my lord, with
Page.
Page 31. Admittedly, ex parte order, my lord, and matter was remanded in appeal.
1 minute. Now, first order ಎಲ್ಲಿದೆ?
So that page 65.
Oh, the Sessions Court directs 2 lakhs to be paid.
Yes, my lord.
What maintenance are you paying earlier?
No, my lord, the fresh matter, my lord, the court has passed an ex parte order against which appeal was filed.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರ ಅಲ್ಲಿ?
3 lakhs they ordered. No, 3 lakhs, my lord, the trial court ordered, my lord. Now session court set aside.
Where is that order?
My lord, at page 55, my lord, order on IE. On the same day, my lord, when the petition was filed, this order was passed without hearing the petition. We challenged it in the appeal. There was an interim order.
Now it is.
She, my lord, undertakes to join me back. For some time, she stayed with me again.
Heard the learned senior counsel Arun Sham appearing for the petitioner. The petitioner is the husband, the respondent, his wife. The relationship between the two turning sore has led to certain proceedings, one of which is directing payment of maintenance, seeking payment of maintenance in the DV case, in the so and so. The concerned court directs payment of maintenance at rupees 3 lakhs per month without hearing the petitioner, as a interim measure. This is challenged before the first appellate court, by the Court of Session in Criminal Appeal 206 of 2023. The concerned court directs payment, concerned court remits the matter back to the hands of the Court of Session remits the matter back to the hands of the trial court, directing reconsideration of the issue. While so doing, directs payment of 2 lakhs per month till the disposal of the petition. The order challenged has not inured to the benefit of the petitioner, but he is placed worse off. The learned senior counsel submits that his income is?
My lord, the average 10 lakhs per annum.
Per month?
Per annum.
Per annum.
I have produced the
learned
IT
senior
returns
counsel
also.
submits that the petitioner's income is 10 lakhs per annum.
Average, my lord, it is all 3 years, my lord, IT
ಏನು
returns.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
Annexure J, my lord.
Assets and liabilities ಅಲ್ಲಿ ಏನು ಹಾಕಿಲ್ವಾ?
Not
Not produced that before the court illa.
ಅಲ್ಲೂ produce ಮಾಡಿರ್ಲಿಲ್ಲ.
So and so. In that light, but something you have to pay.
Lord, around 25,000 or 30,000 affordable because my
ಮಕ್ಕಳಿದಾರಾ?
ಇಬ್ರು ಮಕ್ಕಳಿದ್ದಾರೆ. ಒಬ್ಳು ಮೇಜರ್, ಒಬ್ಬ ಹುಡುಗ he is studying.
Yes, 50,000.
30,000.
50,000 till
He
the
told me, Lord, in
disposal.
fact, 25,000. I not said 30,000. You have to
Make it,
10,
yes.
10,000.
List, they said orders of directing payment of 3 lakhs or 2 lakhs as the case would be by the concerned court or the first appellate court shall remain stayed, subject to the condition that the petitioner would pay the wife and the family rupees 40,000 during the pendency of the petition before the concerned court till the next date of hearing. Emergent notice to the respondent returnable by 3rd September, 5th September. List the matter on 5th in the fresh matters list. Read.
Orders 49.
Withdrawal. Post immediately after service of notice upon the respondent. Interim order idea? Yes, next.
Interim stay ಇದೆ.
Idea. Idra continue.
51.
Lord, in 51, I appear for the petitioner's counsel. Lord, there is an interim order in our favor, but we've also moved an application for defreezing. Lord, I'll just take a minute and explain what has happened.
Kindly pass over the matter, respond number 2 years.
I know 130 at Passover will hear
Please.
it.
Much over.
Orders ಕರೆದ್ಬಿಡಿ. ಇದು ಹಿಯರ್ ಮಾಡದ್ Passover. Office objections to grant 52. This court on 22/7/2024 had passed the following order. Even today, there is no representation on behalf of the petitioner. In the light of the order dated 22/7/2024, the petition stands dismissed for non-prosecution.
53.
Two weeks to comply with. Huh? Same order. Next.
54.
Post immediately after service of notice upon the second respondent, interim order, yeah?
Interim order.
Interim order subsisting shall continue till the next date of hearing.
This is a case of counter, case and counter case, my lord. After a hearing, my lord, the date was given today, my lord, for
Second respondent bandilwal. Sarvagli. Interim order subsisting shall continue till the next date of hearing.
He's the counsel. my lord. That's it.
Notice.
ನೀವು ತಗೊಂತೀರಾ ಅದ್ರಲ್ಲಿ?
Instructions ಕೊಟ್ಟಿಲ್ಲ.
ಇದೆಯಾ? I will vacate the interim order in your case. ಅವ್ರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀರಾ? ರತ್ನಮ್ಮ ಇದ್ಯಾರು ಬೇರೆ? ಇದು ಶಶಿಕಲಾ ಯಾರು?
My lord, first case is mine, my lord. Suma
First
and
case is yours, sir. Who is the complainant there?
My lord, Ratnam.
Toli.
Point 1 ನಲ್ಲಿ ನಾವು.
Learned counsel, so and so, ಯಾರು appear ಆಗ್ತಾರೆ complaint petition is directed to accept notice for the respondent complainant, second respondent complainant. ಇದು ಶಶಿಕಲಾ ಯಾರು?
I'll appear in his.
Learned counsel Gautam Dev Ullal is directed to accept notice for the second respondent in 54.1. Post these matters on, we'll close it on Tuesday in the fresh matters list. Interim order subsisting shall continue till the next date of hearing.
Please oblige.
55.
Needful 2 weeks time is granted. Do the needful. Interim order subsisting shall continue till the next date of hearing.
56.
Post immediately after service of notice upon the first respondent. Interim order, yeah?
Interim order.
Continue, yes.
57.
Here for deputy.
Needful to be done in the next 2 weeks. Interim order, yeah? Interim order subsisting shall continue till the next date.
Interim order has to be done. Interim order ಕೊಟ್ಟಿಲ್ಲ.
Huh?
15, there is no interim order.
No interim order.
ಕೊಟ್ಟಿಲ್ಲ sir, because they have not filed the charge sheet ಅಂತ last occasion said.
57 alla.
57. So far,
Interim
charge sheet-
protection granted shall continue till the next date of hearing. Yes, next.
58.
These under the Wildlife Protection Act. The R2 state and Matpuna.
ಮತ್ತೆ ಕಾರ್ಟುಗ್ ನೋಟಿಸ್ ಆಗಿದೆ.
Inspector, sub-inspector.
Yes.
Your lordship may recall to your lordship's memory, in utter disregard to section 51 of the act, a sub-inspector of police would go and file a complaint.
ಅಷ್ಟೇ ಮಾಡಿರ್ಬೇಕಲ್ಲ.
Stay ಆಗಿದೆ.
ಹಾ.
ಅಲ್ಲ ಮುಗಿಸ್ಬಿಡ್ಬೋದು ಅಂತ ಅಷ್ಟೇ. ಇದೇನು ಅದೊಂದು subject to your lordship's time and convenience. Last time your lordship in fact.
Detailed order.
ಹೌದು detailed order ಆಗಿದೆ. In good humor my lord has put it, case ನಿಮ್ಗೆ ಅನುಕೂಲ but property ಅವರಿಗೆ ಅಂತ. A star tortoise. Lord may recall to lordship memory,
Yes, sir.
3 tortoise. ಇದು ಎರಡು issue. After he takes cognizance, my lord, he can't order investigation. That is
Oh,
number 1.
ಇದು
Section 51.
complaint is by the PSI, admittedly without jurisdiction.
The PSI, there is a jurisdiction, there is a notification,
There is jurisdiction.
there is a notification.
Central government.
And
Central government.
Wildlife Protection
Wildlife
Act.
Protection Act.
ಹೌದು central
ಆಯ್ತು,
government
ಕೊಡಿ.
ಮಾಡ್ಬೇಕು.
ಕೊಡ್ಲಿ.
ಕೊಡ್ಲಿ.
Heard the learned senior counsel CV Nagesh appearing.
ಇಲ್ಲ ಅದೊಂದೇ ಅಲ್ಲ ಪಾಯಿಂಟ್ ಬೇಕಾದಷ್ಟಿದೆ.
ಅಲ್ಲ ಗೊತ್ತು.
ಅಲ್ಲ ಕಾಗ್ನಿಸನ್ಸ್ ತಗೊಂಡ್ಮೇಲೆ ಕ್ಯಾನ್ ಯು ಆರ್ಡರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್? My lord, kindly have a look at the order, my lord.
No, no, I've stayed it. Let him come up with the notification. ಒಂದೊಂದಾಗಿ.
ಅದು central
That
government
also.
notification.
The judgment.
No, that also I have quoted in the order.
ಅಲ್ಲ ಅದು ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಅವ್ರು ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಸೆಕ್ಷನ್ 51 ಅಲ್ಲಿ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್.
ಅದು ಯಾರ್ದು ಕೊಡ್ತಾರೆ ಅವ್ರು ಕೊಡ್ಲಿ.
ಕೊಡ್ಲಿ.
Learned senior counsel CV Nagesh appearing for the petitioner. The learned additional SPP submits that he would secure instructions, the records and make his submissions to refute all the grounds urged in the petition. List the matter on 21st. Interim order subsisting shall continue till the next date of hearing. Yes.
Please.
Post immediately after service of notice upon the second respondent, interim order subsisting shall continue till the next date of hearing. Sir.
My lord, serial number 41 stay, it is for 1ನೇ ತಾರೀಕಿಗೆ charges frame.
ಏನಿದೆ ರವಿಕುಮಾರ್ ಅಲ್ಲಿ?
Interim prayer ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
Charges framing ಇದೆಯಾ?
ಆಗುತ್ತೆ ಸ್ವಾಮಿ. So until next date of hearing.
The further proceedings before the concerned court shall remain stayed till the next date of hearing.
My lord, let it be posted on the website so that I can kindly.
It will not be, sir. ಮಾಡ್ತೀವಿ ಬಿಡಿ, ಎಲ್ಲದನ್ನು ಹೇಳ್ತಾ ಇದ್ದೀರಾ. Yes.
My lord, 59, my lord, interim order may be
Extended. ಬೇಡವಾ interim order?
ಬೇಕು.
Extend ಆಗಿದೆ.
ಅಪೀಲ್ ನಂಬರ್ 84 ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ, ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿದ್ವಿ ಸಿಕ್ಕಿಲ್ಲ.
ಅದು ಯಾರು ಕೊಡಂಗಿರಿ ಕೊಡು. Any mentioning? Yes, madam.
Serial number 66,
there are three club matters. 60
Connected matters.
Yeah, connected matters. 66.1 and 2, your lordship, are infructuous, as the wife who is the respondent has already been.
This is that resolution professional?
No, your lordship, it's a matrimonial dispute. 60
Yes, Purnima madam.
Yes, yes. Your lordship, the matter for 66, I haven't received the wakalat yet, as the respondent is situated in the US and she has to give it. In 61,
You have no objection for adjournment?
No objection.
a date may be fixed.
2
Lord,
weeks,
I
but
may be permitted to file my synopsis of facts. in
whatever you
point
want to
format.
file, madam. Yes. We'll take it on 20th.
Please, Lord.
Yes.
Pledge.
62. ಏನ್ ಬೇಕು? ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಾ? 22 ವೇಟ್ ಮಾಡಿ. ಸಿ.
ಹೌದು ಕಾಪಿ ಇಲ್ಲ ಟರ್ಮಿನೆನ್ಸ್ ಇಲ್ಲೇ ಇಟ್ಟಿರಲ್ಲ ಕಾಪಿ ಸರ್ ಹಾ ಆಫ್ಟರ್ ಲಂಚ್ ಅವ್ರ್ಯಾರ ಬಂದಿದ್ರಲ್ಲ ಅಡ್ವೊಕೇಟ್ ಟೈಮ್ ತಗೋತೀನಿ ಯಾವ್ದ್ರಿ ಇದು ಇವತ್ತಿದ್ಯಾ ನಿನ್ನೆ ಇತ್ತಲ್ಲ ಅಲ್ಲ ರೀ ಇದ್ರಲ್ಲಿ ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ನೀವು ಕೇಳ್ತಾ ಇರೋ ಅಕ್ಯೂಸ್ ನ ಅರೆಸ್ಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಆಗ್ತಿದೆ ಅಂತ ಹೇಳಿ ನಿಮ್ ಸೀನಿಯರ್ ಆಯ್ತಾ ಬನ್ನಿ 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 ಅವ್ರಿಗೆ ಕೇಳ್ಬಿಡ್ರಿ ಮೇಡಮ್ ಗೊತ್ತಿರುತ್ತೆ 64 ಇಲ್ಲ ಆಗಿಲ್ಲ
ಮೇಡಮ್
ಇಲ್ಲ ರೀ ಆಗಿಲ್ಲ 64 ತಗೋತೀರಾ ಮತ್ತೆ ಅವ್ರಿಗೆ ಯಾಕೆ ಕೇಳ್ತೀರಿ ಬಂದ್ ಕುತ್ಕೊಂಡಾಗ ಮೂವ್ ಮಾಡಿ ಇಲ್ಲ ಅವ್ರ ಹೆಂಗ್ ಕೊಡ್ತಾರ ಅಡ್ಜರ್ನ್ಮೆಂಟ್
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ವಾ 83 ನಾ
ಸೀರಿಯಲ್ ನಂಬರ್ 53 ಏನಾಯ್ತು ಸರ್?
ಲಿಸ್ಟ್ ಎಲ್ಲ ಚೇಂಜ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಬೆಳಿಗ್ಗೆ 72 ಇದೆ.
7 ಅನ್ನು ಹುಡುಕ್ತಾ ಇದೀನಿ ಬರ್ಕೊಟ್ಟಿರ್ತೀನಿ ಒಂದ್ ನಿಮಿಷ
78 ರಾಜೇಂದ್ರ ರೆಡ್ಡಿ
ಮತ್ತೆ ಇದು 72 70 ಈ ಸೇಮ್ ಇದೇ ತರ ಕೂಗ್ತಾ ಇರೋದು.
ಹೌದು
ಮತ್ತೆ ಅದು ಬೇರೆ ಮೊಬೈಲ್ ಅಲ್ಲಿ ಬೇರೆ ಬರ್ತಾ ಇದೆ.
ಅದೇ ಬರುತ್ತೆ ನೋಡಿ ನೀವು ಬೇರೆ ಕೋರ್ಟ್ ನೋಡಿದೀರಾ ಅನ್ಸುತ್ತೆ.
ಇಲ್ಲ ಸರ್ ಇಲ್ಲೇ ಇದೆ.
ಆಯ್ತಾಯ್ತು
ಹೂವಾ
ಐದು ಬೇಕಾ? ಅದು ಅದಾಕದಾ? ಆಮೇಲೆ ಮತ್ತೆ ಜನ ಹುಡ್ತಾರೆ ಅದನ್ನ ಸೇರ್ಕೊಡಂಗೆ
ಅದು ಡಾನ್ಸ್ ಆಗಲ್ವಾ?
That's what of
ನಾನೇ ತೆಗ್ಸಿದ್ದು ನಾನೇ
ಓಲ್ಡಿದೆ.
ತುಂಬಾ ಲೋ ಇತ್ತು ಬಟ್ ಚಾನ್ಸ್ ಆಗುತ್ತೆ ಕೊಟ್ಟಿದ್ದೆಲ್ಲ ಕಳ್ಸಿ
ಅಲ್ಲ ಅವರು ಎಲ್ಲ ಅಲ್ಲಿ ಜಾಗ ಇದ್ರೆ ಅಲ್ಲೇ ಹೋಗೋಣ. ನಡಿ ನಮಸ್ತೆ ಮೇಡಮ್.
ಇಲ್ಲಿ ಅವ್ರನ್ನ ದಿನ
My lord, one submission with respect to serial number 66, my lord, an adjournment was sought for by the respondent counsel. Nano date to tappa keliskonbite, my lord, it was 20th, an earlier date may be granted.
Interim order ಇದೆಯಾ?
Interim order then.
20th. As a
IO
last
may be
chance.
extended. Please, my lord,
Interim order will be extended.
please. My lord.
Memo is missing. Memo goes missing. ನಾಳೆ FR ಮಿಸ್ ಆದ್ರೇನು ಇದ್ರೇನು ಸ್ಕ್ರೂಟಿನಿಗೆ ಮಾತ್ರ ಹೋಗೋದು ಅದು. Again goes for scrutiny. ಅದು ನಾಳೆ ಹಾಕಕ್ಕೆ ಸ್ಕ್ರೂಟಿನಿ ಆದ್ರೆ.
Submission. The serial number 50 ಅಲ್ಲಿ I am appearing for responding.
50 ಅಲ್ಲ
50.
50 ಆಗೋಯ್ತಲ್ಲ, 50 ಆಗೋಗಿದೆಯಲ್ಲ. ಪೋಸ್ಟ್ ಆಫೀಸ್ ಸರ್ವಿಸ್ ಇದೆಯಾ ಅವ್ರ ಹೆಸರು ತೊಳಿ. ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಸೊ ಸೈನ್ ಆಗ್ಬಿಟ್ಟಿದ್ರೆ ಆಗಲ್ಲ. Learned counsel so undertakes to enter appearance for Allah submits that is entered appearance for the second respondent, registered to print the name of so and so as appearing for the second respondent. List 2 weeks bit on date code. Wait, very there. Wait, sir. Overbreed. Saka.
Petitioner in this case, my lord.
Substitute arbitrator.
My
Oh,
lord,
this matter, yes, sir.
the application will not be maintainable, my lord, but there are two provisions which the Kolkata High Court has emphasized on, my lord. My lord, provision 23 subclause 4, it simply speaks about the timelines under the Arbitration Act, my lord. There's no limitation as such, but my lord, I have filed the necessary citation, my lord. The lordship may kindly go through the gist
So
of
you can at
citation.
any point in time file the claim statement?
No, my lord, the act does not prescribe the limitation for filing, my lord.
We'll see, yes.
And there is a timeline, my lord, and the file is closed under Rule 10 subclause 7 of the Arbitration Conciliation Rules, my lord.
We'll answer all that, yes, Friday. Yes, next.
My lord, I have written submission, my lord.
Kodi, ಏನಿದೆ ಕೊಡಿ.
Yes, my lord. I filed the gist of citation.
All Friday.
Obliged.
Offenses under 341 and 323.
Why is it an orders?
But it's in the hearing on I, first time it's coming, fresh matter, my lords. Dispensation was sought and hence it's in the. Annexure B is the FIR, my lords. Annexure A is a complaint at page 12. Wrongful restraint and hurt. Averments of complaint, not your lordship's court. C.
Why did you do this?
It's what had happened, lords. None of this has happened, lords.
Ah.
It's a scuffle between lords. All petitions were all in early 20s. Respondent 2 also is in his late 20s. my
Early
lords.
20s.
Early petitioners all, my lords.
Huh?
But all the petitioners were also in their early
20s.
Yes.
Car is I-20.
Yes.
Yes.
No, it was registered in the name of their aunt. They were all going for dinner, my lords. What has happened is respondent number 2 continuously honks and abuses in filthy language, my lords. These people step down and sit and stand to talk, my lords. And then the next morning, this complaint is filed.
You have
my
not
lords.
complained?
No, my lords, I did not because
Why did you not?
small altercation, not small scuffle to say on the road, which happens my lords, day in and day out, my lords. Because nothing of this sort happened. And if your lordship see, my lords, even the complaint at page 11, the handwritten,
Yes.
averments of 341, my lords, is not, he adds it later, my lords. The handwriting also is different, where he says car stopped me. Is a handwritten in different handwriting and added subsequent as an afterthought. Is, and even 323 minutes, next page, what he says is I was advised X-ray. Now he does not say what's the nature of.
That will see.
Yes.
This road rage, troubling people going in the car, by two-wheelers, all this should stop.
Yes, here.
It should stop, then the such thing should not be entertained.
Yes, but this is not resulted in physical injury as such.
that's
This is
all
just
right.
verbal altercation that has taken place, which
Whatever.
we see, Milords. In fact, petition number 3 sat in his car. He's not even got down, Milords, is what I'm told, Milords. He never even stepped out of the car.
In
during
too far,
this.
too many countries or too near too many countries, such things will not happen.
Lordships may see perusal of complaints, Milords.
There should be some corrective action.
Yes, Milords. I understand, Milords, but the ingredients of both the offenses, Milords, and even
You should have
34.
registered a crime if something has happened to you.
We thought best leave it at that as a small incident or altercation on the road, Milords. That's why otherwise,
What is
Milords.
narrated is not a small incident. Anyway, you have traumatized them. That's the allegation.
But if Lordship see the first allegation, Lord, so far as 341 is concerned,
Let the investigation go on.
Lords, insofar even petition number 3
If
is
you
concerned.
people think no end to yourselves and indulge in such things,
It was not so, Milords, as it is told.
let the investigation come.
Your Lordship could summon the investigation papers, Milords.
I will, yes.
Yes.
Get the papers, sir. Learned HCGP is directed to accept notice, secure the investigation papers and place it before the court. On its perusal, if needed, notice would be issued to the complainant. List the matter on 21st August in the fresh matters list.
Could it be listed earlier, Milord? Because the chances charge sheet could be filed a little
Let's
slightly
see.
earlier.
Let's see. Yes, anyway, I have summoned the papers, charge sheet won't be filed.
Please.
You have secured bail, right?
Yes, Milords.
No.
Yes.
Yes,
ಏನ್ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ ಯಾಕೆ? You saw time?
no, I'm ready, my lordship pointed out. Finish.
Ah.
Matter pertains to a civil case which is filed by the father-in-law against the son-in-law, claiming the suit property. And the suit is still pending. He files complaints before Hunsur police station and others. Three times NCR agide. Ultimately files another case in HSR police station, which is on 29/5/2020, Annexure B. As per the reports, Manoj, the following the complaint, 155(2) has not been followed as per last time.
What
when
is
it
the
was
offense?
point-
504? 507, all non-cognizable. ಕೊಡಿ. ಇದೆಯಾ? ಎಲ್ಲಿದೆ ಕೊಡಿ. Intimation is here. Last time I saw this.
Yes, that is, there is no detailed order.
Where is the entire order sheet? ಕೊಡಿ.
Copy.
ಮೇಡಮ್ ನಾನು ಯಾವ್ದ್ರ ಜೊತೆ ಹೋಗಿದ್ಯಾ? ಇಲ್ಲೇ ಇದೆಯಾ? ಇಲ್ಲೇ ಇದೆ. Nothing wrong, sir. 155 complied. Next.
Civil cases are pending between the father-in-law and the son-in-law. Father-in-law is the complainant.
All right.
He contends that the property was purchased in the in the name of the son-in-law because of 79A and B. And he contends that he made contributions.
Father-in-law, son-in-law, sit
Yes.
and settle it. 504, 506 ಅಲ್ಲಿ ಏನ್ ಟ್ರಯಲ್ ಮಾಡ್ತೀರಾ? Sit and settle, sir. Your civil suit also will be settled. Yes. ನೀವು son-in-law ಅಲ್ವಾ?
Yes, madam. In fact,
Don't settle the matter like you're dealing with another son-in-law. He is your father-in-law.
please.
And more so because of personal vengeance, he has often sending messages by using vulgar languages.
Why?
And not only that.
He tried to spoil my life with my wife. So I have now.
Spoil your life with
Yes,
your wife.
He filed a petition and
Sir.
it was settled.
1 minute.
Reunion has taken
One
place.
minute, sir. How can the father-in-law spoil your life with your wife?
Spoiled the mind of the daughter. She went to the extent of filing a divorce case. Now we have settled,
because of the father-in-law.
now we have settled among, because of this property.
Petitioner has filed a divorce petition, not
But
by
it is
the.
closed,
my lord.
that is also closed.
Petitioner has
We have
filed. a
settled and we are reunion agi, we are living together. There is no
divorce.
question of
He
any
himself
divorce.
has filed divorce petition, not by me, not by
That your
the,
father-in-law, how can you file divorce petition, sir?
not by my client daughter has filed.
Matter
He is
requires
the
settlement,
respondent
Andre, if they are
before the lawyer.
genuine in their efforts, we will work out a solution.
Work out, sir. The best solution is to arrive at a solution. Is there a 506, 504 lane? ಇದರಲ್ಲಿ ಏನ್ ಟ್ರಯಲ್ ಮಾಡ್ತಾರೆ? Father-in-law, mother, son-in-law.
He claims to be 76 years old in the petition, in the complaint. This right
ಅಷ್ಟ್ ಇಲ್ವಾ?
ಅಲ್ಲ ಅಷ್ಟೇ ಇದೆ.
ಮತ್ತೇನ್
Then
problem?
why at this stage against the son-in-law property ಅವ್ರು ನಾವೇ ಕಾಂಟ್ರಿಬ್ಯೂಟ್ ಮಾಡಿ ನಾವೇ ತಗೊಂಡಿರೋದು ಸ್ವಾಮಿ ಅದನ್ನ.
Swami, entire
Civil case
amount
pending
is
ಇದೆ.
paid by the father-in-law, not even single NP. That fact they knows, even though the
Civil
fact was
issue.
suppressed. Even though they are bringing civil matter before this court. my
ಬರೀ
lord.
ಮೆಸೇಜಸ್
Even
ಮೇಲೆ
entire
ಕಂಪ್ಲೇಂಟ್
sale
ಇಲ್ಲ.
message
What
amount
I am
paid
trying
by
to
the
point out is
Respondent two
ಇಬ್ರು
and his son.
ನೀವು father-in-law, son-in-law ಇಲ್ಲಿ ತೋರಿಸ್ಬೇಡಿ. Wait.
only messages ಇದ್ರೆ ಒಂಥರ.
ಇನ್ನೇನ್ ತರ?
He relates it to the complaint relating to the property issue. Property civil issues pending, he claims that payments are
No.
made.
I just will
Best
still
thing
attract
is-
504, 507.
Both in-laws sit and decide.
Any date, interim order may be extended.
Lest the matter, the issue lies between the son-in-law and the father-in-law. Father-in-law is the complainant, son-in-law is the accused. The subject matter of the dispute is a particular property. The allegation is that the son-in-law, as the father-in-law, who has sent messages?
Son-in-law.
Son-in-law has sent messages which are derogatory in nature to the father-in-law, who is now said to be 82 years old, and the petitioner himself 50 years old. Therefore, the petitioner and the the petitioner and the complainant sit together, have a dialogue, and resolve the dispute.
Even last occasion,
Resolve the dispute by the next date of hearing. Ilder, I will permit trial 506, 504.
Bad, interim stay there. Continue.
Interim stay ಇದೆ, ಅದನ್ನ
It will
vacate ಮಾಡಿ I will
prejudice-
permit.
ಇದೇ ತರ
Prejudice
ಲೋಕ
the-
ನಾವು ರೆಡಿ ಇದೀವಿ ಸ್ವಾಮಿ. Last time ಬಂದಿಲ್ಲ ಲೋಕ ಅದಾಲತ್ಗೆ.
It will prejudice the settlement.
ಯಾವಾಗ ಹೋಗ್ತೀವಿ? Your son is here, your client is
He
here.
is in Madikeri.
My client is here.
He is from Madikeri.
He is aged about 84. Kindly.
Why
say.
have you got him?
Because he want to come here. I don't want to come. I am never instructed. In spite of that, he came, my lord.
We will attend to the settlement. Short date is gone.
You'll attend ಅಲ್ಲ.
We will appear.
Participate in the
If
settlement.
it's Lok Adalat, we'll ask him to appear.
No ಲೋಕ್ ಅದಾಲತ್, straight away. ಎಲ್ಲಿ mediation center ಅಲ್ಲಿ?
ಇಲ್ಲ ಬೆಂಗಳೂರಿನಲ್ಲಿ.
ಎಲ್ಲಿರೋದ್ ನೀವು?
Madikeri.
ಬೆಂಗಳೂರಿಗೆ ಬನ್ನಿ. Yes. Before the parties to appear before the Karnataka mediation center on ಯಾವತ್?
Yeah, in
Any short date, my
Saturdays.
lord.
Saturday? This Saturday?
ಅಲ್ಲ 2 weeks ಅಲ್ಲಿ ಹಾಕೊಳ್ಳಿ ಮುಗಿಸ್ಬಿಡು.
Next Saturday is the second Saturday, ಅದಿರಲ್ಲ. Will, you come this Saturday?
Ready, sir.
Friday or Thursday.
Weekdays ಇದ್ರು ಪರವಾಗಿಲ್ಲ ಅಂತ.
ಆಯ್ತು, Friday. List on, appear before the Karnataka mediation center
Next
on the
Friday.
5th of August, sorry, on
8th.
9th of August.
9th.
List the matter on 13th in the fresh matters list.
Even now also often he is sending messages. Even now also.
Why, ಬೇರೆ ಯಾರು ಮೆಸೇಜ್ ಕಳಿಸ್ತಿಲ್ಲ, ಇವ್ರಿಗೆ ಕಳಿಸ್ತೀರಾ?
False
We have,
submission ಅಂತ.
we have a documents with proof.
ಆಯ್ತು, ಮೆಸೇಜ್ ಸ್ಟಾಪ್ ಮಾಡಿ ಫಸ್ಟ್.
ಆಯ್ತು.
You can send a message of settlement, no
Yes.
problem.
Interim order.
Interim order stands extended till the 13th of
if-
August.
For the petition. But in this matter, well, the respondent, second respondent had initiated criminal proceedings by private complaint, my lord. The allegation that he was acting as a real estate, agent to sell the property of the first accused, who is the petitioner, my lord. The
Interim order
allegation.
ಇದೆಯಾ?
Interim order ಇದೆ.
ಏನ್ ಪ್ರಿಯಾಂಕಾ ನಾಟ್ ಫಾಲೋಡ್ ಅಂತನ?
ಪ್ರಿಯಾಂಕಾ ಸಿಂಪಲ್ ಆಗಿ ಹಾಕಿದ್ದಾರೆ. ಐ ವಿಲ್ ನಾಟ್ ಪ್ರೆಸ್ ಆನ್ ಪ್ರಿಯಾಂಕಾ.
Then interim order ತಗೋಬೇಕಾದ್ರೆ ಪ್ರಿಯಾಂಕಾ ಪ್ರೆಸ್ ಮಾಡಿದೆ.
ಅದು because last time I submitted on that because the affidavit is very casual. There is absolutely no references.
ನೀವ್ ಯಾರು ಸರ್?
ರವಿ ಅಂತ ಸರ್.
ಅಲ್ಲ, ನೀವು ಕಂಪ್ಲೇನೆಂಟಾ? he is here.
Please, Minos.
ಎಂಗೇಜ್ ಕೇಳಿ, ಎಂಗೇಜ್ ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡ್ತಾರೆ.
Higher engagement.
ಲಾಯರ್ ಬಂದು ಗೌರ್ಮೆಂಟ್ ಇದಾಗಿದ್ದಾರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಗೌರ್ಮೆಂಟ್ ಏನಾಗಿದ್ದಾರೆ?
ಆಫೀಸರ್ ಆಗಿದ್ದಾರೆ.
Yes, Jagdish.
You want to engage somebody else?
The respondent has appeared in person, seeks leave the court to engage any other counsel in the light of the counsel on record being appointed as government advocate.
ಇಲ್ಲ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತೀನಿ ಸರ್ ಈಗ.
ಅಲ್ಲಪ್ಪ ಇವ್ರೇನಾಗಿದೆ?
ನಾನು ಸರ್ ಇವರು ಲಾ ಆಫೀಸರ್ ಆಗಿದ್ದಾರೆ.
HCGP as High Court government pleader. 2 weeks' time is thus granted. Needful to be done by then, interim order subsisting shall continue till the next date of hearing. Yes.
Lordship, respondent 2 to 4, Lordship. Senior's colleague father expired, Lordship. Raised for
Senior's
short
colleagues
of.
Charges have been.
A date may be.
Charge frame ಆಗಿದೆಯಾ?
ಹೌದು.
But 2022 stay ಇದೆಯಾ?
Entry ಮಾಡಿದ್ವಿ.
ಹಂಗಾರೆ ಅಲ್ಲೇ ಮಾಡ್ಕೊ.
With liberty to file discharge application. I have not
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇತ್ತು ಅಂತ ಅದು ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ಪೆಂಡಿಂಗ್ ಇತ್ತಲ್ಲ.
With that liberty it may be.
Now how will you file discharge after framing charges? Discharge, you would have said no objection to frame charge, ಅದಕ್ಕೆ ಮಾಡಿರೋದು.
One opportunity can make, if it is given, we will avail me.
ಅಲ್ಲ, because petition is pending here. I will answer the petition on merit itself. ಬೇಡ. Yes, sir, what do you want?
Short tomorrow, my lords.
Short tomorrow?
Short accommodation, my lord, short tomorrow.
List on Tuesday in the fresh matters list. We'll dispose it on that day. Because after framing of charges, I can't permit discharge application. 65.
For a short accommodation, my lords. The 7A matter, section 7.
8th ಹಾಕೋಣ. List on 8th.
Wait for minutes.
8th ಅಲ್ಲ ಮೇಡಮ್, 7A ಹಾಕಿರೋದು. 7th 8th. List on 8. Vacating stay.
My lords, I filed IA for vacating stay, my lords. My lords.
Your phone rang yesterday or today?
I apologize for that, my lord.
When, yesterday or today?
Yesterday, my lord.
Yesterday, okay.
Yesterday, my lords, I had changed the mobile, so I could not operate it.
Because it rang, you changed the mobile.
No, my lord. Music player was on in long back, so I just opened the phone and it rang.
So it was yesterday.
Yes, my lord. I apologize for that.
No problem.
Great.
Yesterday's apology today accepted.
My lords, I'm sorry, I could not.
Sorry. There's an interim order in this, my lords. I think.
On time?
No, my lords, I'm ready.
You're ready? Yes, sir. You're not ready?
I'm ready, my lords. I can go on it.
This discussion about phone rang yesterday.
Thank you, please.
Contractual matter.
Yes, my lord.
Let's,
A contractual matter, my lord.
I request my lordships to go to page 10, my lord.
So let him finish, sir. Amale, yes. Yes, sir. Come on.
My lords, the business was in the nature of a sale and return business, my lords, where certain sarees are given to us. If we are able to sell the sarees, my lords, there's a share of profit. But in case we're not able to do it, we return back the sarees to them. That's how the entire agreement is. This agreement, my lords, is at page 45, my lords. 15/11/2019. Page 45, my lords.
15/11?
15/11/2019. My lords would get it as annexure D, my lords.
Page.
Page 45. My lords, at page 46, the third point there, my lords, the merchandise will be supplied on a sale or return basis. My lords would get that portion, my lords.
And para 8.
Yes, my lords, paragraph 8. Then, my lords, 17, paragraph 17 may be noticed at page 48, my lords. In case we have a dispute amongst us, the parties agree that it is Mumbai that would have the jurisdiction. My lords would notice at page 48, paragraph 17.
Subject to Mumbai jurisdiction.
Yes, my lords, and all signed by all the parties concerned.
My lords, thereafter, there's a partnership deed entered into between us. My lords should get the partnership deed at page 386, my lords. 386. G. Even in this, we have similar clauses, my lords. And there's also a clause on arbitration, my lords, a dispute at page 394, my lords.
This is subsequent to the earlier
Yes, my
agreement?
lords, this is subsequent to the earlier one. Page 394, paragraph 17, sole arbitrator to be in Mumbai. My lords, you'd get it at 394 at 17, dispute resolution. And under the miscellaneous clauses, my lords, Indian Partnership Act applies. And my lords, at page 398, 21.10, my lords, Mumbai courts having exclusive jurisdiction over the subject matter arising out of the deed of partnership. My lords would get it at 398. Now, my lords, certain dispute arose. According to them, my lords, certain saris which they had sent across, we neither sold it nor have returned it back, is what their allegation is. And dispute arose between the parties. Now, on the basis of the dispute, my lords, complaint is given, which my lords would get at page 35, my lords, alleging breach of trust and cheating.
Very cheating, math.
Very cheating.
My lords, 406.
406 complaint ಅಲ್ಲಿ, charge sheet only 420.
Only 420.
ಹೌದು, complaint ಅಲ್ಲಿ, ಇದು complaint ಅಲ್ಲಿ 406, 420.
ಅದಿಲ್ವಲ್ಲ ಬಿಡಿ,
ಹೌದು.
406 ಇಲ್ಲ. Yes.
My lords, their entire case is that you have not paid a certain amount and that amounts to cheating us. Now, my lords, when the entire jurisdiction of the matter between the two parties agreed upon them to be at Mumbai, and my lords, having an arbitration clause in that regard, my lords, this entire proceedings.
So why you did not return the saris?
No, my lords, according to us, we have returned it. That's the dispute that has arisen. My lords, such of the saris we were able to sell, my lords, we sold, and what they are entitled to, we have given. Such of the saris which we have not been able to sell, my lords, according to us is returned. But according to them, my lords, it's about 70 lakhs that has not been paid to them is what they say.
1 crore 19 lakh.
My lords, in the complaint, my lords,
Complaint
unsold goods worth of 38 lakh 67,000.
38 lakhs worth saree you did not sell.
ಅವ್ರು ಹೇಳುವ ಪ್ರಕಾರ, my lords. ಅವ್ರು ಹೇಳುವ ಪ್ರಕಾರ.
What sarees are these? 38 lakhs?
Like silk sarees which goes from one place to the shops. If it is sold, well and good. Otherwise, it is to be returned. This is how it is, the whole agreement. My lords, in a matter of this nature, which has an arbitration clause, which the jurisdiction is defined. Now, would the territorial jurisdiction here for this police station, my lords, to even adu baralla. So, and more importantly, my lords, the company is not made a party. Now, if it's a vicarious liability, my lords, and their allegation is against.
Sir, who is the accused?
My lords, accused are individuals. One individual who's made an accused. Company is not made a party. So, my lords, on 3 scores,
Agreement
my
was
lords.
between whom?
Agreement, partnership deed, my lords.
No, agreement.
Company.
Agreement company, partnership company.
My lords, again, kindly notice, my lords, page 380.
Oh, you are in Dubai, is it?
One ನಿಮಿಷ,
I'll come to that.
ಎರಡು ಕೂಡ.
That's the most important thing. My lords, page number 10.
Wait. So, my lords, my respectful submission is, my lords, the 3 contentions that arise for consideration is 1, a dispute which is purely civil in nature, having a commercial element to it. A cloak of criminality has been given to it. Second is, my lords, there's a clause that deals with dispute between the parties having an arbitration clause. And third aspect is, my lords, on the territorial jurisdiction, when the parties themselves have clearly undertaken that it would be only Mumbai that has jurisdiction. My lords, on these aspects, my lords, on these 3 issues, the judgments, my lords, which we'd like to give, my lords.
ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
A set of rulings are there. My lords, commencing with my lord's judgment, my lords, because my lords has dealt with a number of matters where a cloak of criminality being given to a purely civil dispute, and especially when there's an arbitration clause that deals with it. So you don't invoke the arbitration clause, but straight away set the criminal law in motion. My lords, paragraph 13, my lords,
The paragraphs are not indicated in this. The advocate and record.
I'm sorry. My lords, page 8, my lords.
That's all right.
From there on, I'm sorry, I will indicate the paragraphs also.
Yes.
I'll indicate the paragraphs. My lords, all the rulings to that effect, my lords. And more so, my lords, in my respectful submission, especially when territorial jurisdiction, the concerned police station can't get, my lords. When parties have agreed that it has to be in Mumbai.
That is for arbitration, sir.
For any dispute, my lords,
On-
this is in the nature of a dispute that has arisen between the parties
Not
on
you-
settlement of accounts.
Come on, other things, not
Yes.
for setting the criminal law into motion, not jurisdiction. That's for arbitration.
Probably, my lords, if the investigating officer was made aware of these agreements, my lords, he might have even registered 0 FIR, my lords,
Maybe.
to send it to the necessary police station. But that's not what has happened here, my lords. Straight away, a crime is registered, alleging a case of cheating. Well, it's all the rulings running on the same lines, my lords, till the
Yes,
latest
yes.
ones, my lords.
Write the paragraphs and give.
I'll write the paragraphs again.
Put
So, my lords, these would be the 3 points, my lords, calling for interference in this matter.
My lords, my respectful submission would be that, my lords, on page number 17 of my objections, I have produced the copy of the complaint. Page number 17 of the IA for vacating stay document, my lords. Paragraph 1 is just an introduction about me, my lords, where I'm in that, my lords, last but one line is ಇವರು ಸುಮಾರು 7 ವರ್ಷದಿಂದ ಪರಿಚಯವಿದ್ದು ಸುಮಾರು 5 ವರ್ಷದಿಂದ ವ್ಯವಹಾರವನ್ನು ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. My lords, only to point out that there was intention from the inception. My lords, I am selling sarees to him since last 7 years. And in the year, only in the year 2019, he communicates to me over several modes that he is into trouble and he wants some help, which I have not brought on record, my lords. It is just only for the sake of the convenience. Next continuation, my lords. ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ದಿನಾಂಕ 15/11/19 ನಮ್ಮ ಜೊತೆ ವ್ಯವಹಾರ ಒಪ್ಪಂದ ಮಾಡಿಕೊಂಡಿದ್ದು ಸದರಿ ಒಪ್ಪಂದದ ಪ್ರಕಾರ ನಮ್ಮಿಂದ ಸೀರೆಗಳನ್ನು ಖರೀದಿ ಮಾಡಿ ಆ ಸೀರೆಗಳನ್ನು ಮಾರಾಟ ಮಾಡಿದ ಮರುದಿನ ನಮ್ಮಿಂದ ಖರೀದಿ ಮಾಡಿದ ಸೀರೆಗಳ ಹಣವನ್ನು ಪಾವತಿ ಮಾಡುವಂತೆ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಕೊಂಡಿರ್ತಾರೆ. My lords, at the same juncture, my lords, another document which I have produced before my lordships, there is document on behalf of the respondent number 2. In that I have produced, there is another proceeding going on against the same petitioner before NCLT. In that, corporate debtor has chasing him for some money. During that time, intentionally, petitioner causes me to enter into this agreement, my lord. So there was intention from the inception, very much evident on the face of record.
1 minute. Since when both of you are transacting?
Since 7 years.
7 years in that. Problem ಯಾವಾಗ ಆಗಿದ್ದು?
Problem arose as such in the year 2022 when this FIR was registered.
Problem in the FIR is registered.
Yes, my lord.
Because of the problem.
15/11/2019. 15/11/2019 was the date when the petitioner asked me to enter into an agreement so that he would pay me in installments or something. My lords, intentionally, that jurisdiction of Mumbai, which was not at all there between us since long, now that was brought into the agreement intentionally.
You forget about that. Now you tell me it's a breach of agreement, a commercial transaction between both of you. How will it amount to 420?
Lords, there are 2 submissions, my lord. One is, if there is a intention evident
Exactly.
prior to entering the agreement.
No, it is not only intention. It should be that his intention, with dishonest intention, he lures you into something that you are later affected of.
When he is able to receive crores of sarees before, then why he caused me to enter into the agreement only in the year 2019?
Why did you enter, sir?
My lords, that is because I wanted to continue the business with him because he was
Exactly.
making payments, certain payments.
Correct. So with eyes wide open, rather heart wide open, you have entered into the agreement. And what happens, sir?
My lords, another part of his conduct will be page number 10, my lords, of my I for vacating stay. In that, what happens is, I register a FIR. He was supposed to come and before, my lords, there is a
Sir, you initiate any proceeding, civil proceeding, no problem. How can a criminal officer into motions?
My lords, one thing.
On a breach of agreement or on a commercial transaction having gone wrong, how can you?
Because, my lords, apparently there is intention on his part, my lords, this is more apparent.
Sir, if there was intention to cheat, 7 years, your transaction would not have been with him in the manner that it is. It has gone wrong sometime.
This
I'm
is
not-
first time we went to the police.
First time
to
we
the
went.
FIR. Yes, please, my lords, that is the submission which I can make.
See, if it has gone wrong for the first time in a transaction of, or a relationship of 7 years, how can you set the criminal law into motion? That is why you have all sorts of remedies available.
My lords, I.
Because to arm twist or to get the remedy easier, this can't be the.
My lords, that was
forum.
not the case because, my lords, kindly, my lords may peruse, before that, I would like to draw attention of my lordships to page number 10 of my IA for vacating stay document.
All right.
Conventionally, this court, my lords, would never grant any stay order to the person who is not at all obtained the bail. My lords, he's 1.5 years, his NPW is issued, his police is chasing him and he's sitting in Dubai. Sitting in Dubai and he got the stay order saying that it is covered by Sarabjit Kaur. My lord, Sarabjit Kaur.
1 minute, 1
is
minute.
not at all.
At,
Page number 10 of
1
my.
minute, sir, 1 minute.
Absconding charge sheet was filed.
Absconding charge sheet.
There are several other crimes, my lords, registered against him.
Just 1 moment. Who has filed wakalat? Who has signed the wakalat? Petitioner yaar sign ಮಾಡಿದ್ದಾರೆ?
Sir, the petitioner, he was in Dubai, we had sent on a wakalat.
Where is the wakalat?
Attested. He has gone to the embassy and he has got it.
Huh?
He had taken the wakalat to the embassy and he has signed it.
Embassy?
Yes.
ಅದು ಎಂಬಸಿ ಬಿಲ್ಡಿಂಗ್
ಅಲ್ಲ ಎಂಬಸಿ my lords.
ಇಲ್ಲ ಅದಕ್ಕೆ ಕೇಳಿದ್ದು ಎಂಬಸಿ ಅಂತ. There is nothing here. ಎಲ್ಲಿದೆ ಕೊಡಿ ಮೇಡಮ್, ಇದೆಯಾ ನೋಡಿ. How did he sit in Dubai and sign? And if he is being represented by a GPA, accused cannot be represented.
He has signed the wakalat and sent it to us.
Is it attested in the embassy? That is what wants to other would be.
My another apprehension is
Wait,
that, my
sir.
lords.
First apprehension ಮುಗ್ಸ,
Please,
ಆಮೇಲೆ
please.
second go on. ಯಾವ ಎಂಬಸಿನೂ ಇಲ್ಲ, ಏನಿಲ್ಲ. ಒಂದೇ petitioner ಅಲ್ವಾ ಇರೋದು?
My lords.
ವಕಾಲತ್ತು ಒಂದೇ ಅಲ್ವಾ?
ಅಲ್ಲ affidavit ಅಲ್ಲಿ they've got it
No.
in support of it.
Affidavit ಅಲ್ಲಿ.
What affidavit, sir?
Kindly.
ಅವರು ಅಫಿಡವಿಟ್ ಮೇಲೆ ಇದನ್ನ ಹಾಕೊಡ್ತೀವಿ, ವಕಾಲತ್ ಮೇಲೆ ಪಿಟಿಷನ್ ಮೇಲೆ ಹಾಕೊಡಲ್ಲ ಅಂದದಕ್ಕೆ ಅವರು ಅಫಿಡವಿಟ್ ಮೇಲೆ ಅಷ್ಟೇ ಹಾಕಳಿಸಿದ್ದಾರೆ. They have the embassy people there have refused to put a seal on the wakalat because it is not an application or an affidavit. They specifically told that we will put a seal only on the affidavits. And because of this,
Then you cooperate with the investigation now.
we are ready.
Come to India. Senior is there, wait. Senior is there, ready. Come to India.
Is there any cases made out, my lords?
No, that we'll see. You come to
No,
India,
but,
well,
but so long as my lords is satisfied that it was signed there and for the embassy.
it's an absconding charge sheet filed now. So you come to India and appear before the investigating officer. Then I will consider it. Will accordingly modify the interim order. You can't sit there
Alla,
and
but one. my
make an
lords-
interim order
Alla,
here. on
subject
this
to one
ground.
thing, my lords. My lords may notice here charge sheet has been filed Now, after charge sheet is filed and court has taken cognizance, investigating officer ಮುಂದೆ ಏನಿರಲ್ಲ.
That's all right. ಅದು
court
absconding
ಮುಂದೆ
charge sheet,
ಇರ್ಬೋದು.
absconding charge sheet ಹಾಕಿರೋದು ನಿಮ್ಮ ಮೇಲೆ.
ಹೌದು.
So appear.
I may have to appear.
You want me to direct reinvestigation or further investigation? I will direct.
Further investigation or reinvestigation.
direct.
my lords.
If you want further investigation to be directed, I will direct immediately. Appear. Dubai al kutkond illi, you can't take an interim order without taking bail and producing this affidavit. Wakalat is signed here.
ಅಲ್ಲ, ವಕಾಲತ್, my lords, signed there with an affidavit which was signed, my lords. ಅಲ್ಲಿ sign ಮಾಡಿ, affidavit ಅಲ್ಲಿ they have notarized it there at the embassy. Because that's why, my lords, for identification, it's not identified in the wakalat, my lords.
What application was it, affidavit ke?
No application.
Interim application, IA for stay.
Stay only, nothing, no.
IA for stay affidavit. ನಿಮ್ಮ affidavit ಅಲ್ಲಿ ವಕಾಲತ್ ಬಗ್ಗೆ ಏನೂ ಇಲ್ಲ. Come, take the next flight to Bangalore.
Matter where charge sheet has been filed.
No, this sitting in
Understandable
Dubai
with-
without any indication of you're in Dubai, ಇದು interim application ಗೆ ಮಾತ್ರ affidavit ಹಾಕಿರೋದು ಇದು. ಅದರಲ್ಲಿ that is signed there. ವಕಾಲತ್ ಇಲ್ವೇ ಇಲ್ಲ. ವಕಾಲತ್ is signed here. All the advocates.
No, my lords, wakalat is also signed there. My lords,
No,
it was,
you should have said that in your affidavit or in the application, sir. Nothing is said. Nothing is said. Affidavit ಗೆ there is consulate seal. Consulate of India, Dubai seal ಇದೆ on the affidavit. On wakalat there is nothing. Third July. What date? Consulate seal is on 3rd July.
my lords, we don't have a call. I think it's there.
Illide, 3rd July.
3rd
Wakalat is filed on 3rd July. Affidavit is filed on 3rd July.
3rd July.
Okay, you transmitted it immediately.
My lords, could I make one request, my lords, subject to
Petitioner. Look. Huh? No, petitioner is. What's the name of the petitioner?
my lords, Rahul Jasnani.
Rahul is.
Could I make one request, my lords? Could the matter be taken up tomorrow? Let me just ascertain, my lords, because my lords is expressing that he needs to come here. It can't be a case of him not being here at all. If it's taken up tomorrow, my lords, I'll just make my inquiries and then get back.
Because without him here.
My lords feels at least.
And accused cannot be represented by a GPA or any
But
kind
there's
of.
not a GPA, my lords.
There's
There's not a
nothing.
GPA.
Yes.
So, my lords, let me just ascertain, my lords.
You have a case.
I do understand
You have a
that.
case on merit.
Absolutely, because even the fact, my lords, after this FIR was registered also, transactions have taken place, 5 lakhs has been paid at different installments to
I am
them.
not on the merit of the matter.
But the fact that he
The
was not
majesty
here.
of law cannot be trampled by someone sitting abroad and doing it. That's all.
My lords, throughout, he was not here, my lords. He was not
That
here.
is exactly when he
my
was
lords
not here
feel-
throughout. How did he, send this, sign this?
I will find out, my lords. Can it be had tomorrow, my lords? Let me just find out exactly what happened, how this wakalat is filed. At least to that extent, I can.
Yes, tomorrow in the fresh matter.
Submission, if I can make, my lord.
Ah.
He is attempting to use this as a precedent to get the stay at some other courts. So that is the reason that, my lords, that was.
My lords,
It should be
ultimately,
curtailed.
the merits of this case, my lords.
That will see.
Whether we have merits in this case or not.
You come down up here, we will consider.
Please, by tomorrow, I will be in a position to
Yes.
submit, my lords. And even coming down, my lords, probably I may have to go before the court, my lords, concerned, which is handling the matter.
We'll
So
see
I will-
what is to be done.
I will
direct.
Please.
Yes.
Great.
My lords, this, we put the paragraph number.
Kodi, yes. Merits, definitely you have a case, that's why I granted an interim order, but I did not see that you were sitting in Dubai and taking an interim order. Yes.
Merely sitting. Ultimately, my lords, if there's a case made out. my
No,
lords,
no,
my
no,
lords.
not that.
My
Somebody
lords, they're
sitting
seeing
there
only the
without
contact part
validly,
of it. my lords.
validly signing and filing documents here, sitting there and
That I
dictating.
will
no,
ascertain. My lords,
that
I
will
will, I'll
not.
definitely ascertain that.
You may have 100% case on merits, but we will not entertain such things.
And especially inherent powers, my lords. So that's the reason I'll ascertain and I'll make myself.
Because I'll pass an order tomorrow for further investigation.
If it so warrants, my lords, I will
I
just
will.
look into it, my lords. How,
Problem.
what has
Yes.
happened, how it is
So he will have to come. Yes.
obliged.
Great.
ಇಲ್ಲೇ ತುಂಬಾ ಇದೆ ಲುಕ್ಔಟ್ ಸರ್ಕ್ಯುಲರ್ ಅದು ಇದು.
Idrali probably LOC illa, my lords. Probably he should be in a position to travel.
Correct. Or impounding the passport.
In their petition, so they have stated that they are not coming because this FIR is in place.
In fact, his renewal of passport had become a problem, my lords. We had approached before this honorable court itself in that. Anyway, my lords, I will ascertain the whole sequence correctly. Tomorrow I will submit.
Yes. Tomorrow at 2:30 PM.
And there's an interim order which can.
That will extend. Interim order subsisting shall continue to the next date.
Lordships, I appear for the petitioner.
Yes,
In
Robin.
this case, my lords, the,
Charges have been framed.
my lords, but last time you had asked for the sexual harassment committee report, my lords.
See, what happens is, matter is ಯಾವತ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರುತ್ತೆ ಪೆಟಿಷನ್ ಹಾಕಕ್ ಮುಂಚೆ ಆಗಿದ್ಯಾ?
ಇಲ್ಲ 10/6/2024.
24. Petition is pending here.
Your lordships had asked for the Posh committee report last time.
What happened?
Lordships, he was
What is-
convicted, but.
Convicted?
He was convicted, of course. He was
Held
terminated from
guilty
his
and
job,
held.
Swami. But there are two instances, my lords. One is that she says that he sent certain emails with a certain subject line.
No, what did the committee do, sir?
The
Committee has held you guilty?
Yes. On page number 7, my lords, it says, while the content of
Have you
this.
challenged that finding
Yes,
of
he
the
has
committee?
challenged it.
Where?
City Civil Court only.
But anyway,
But there is
it
one
has
other,
held you guilty.
my lords, there are three things, my lords. There is an email, there is one text which says, I love you, Anta. And then there is a reconciliation also that has happened, my lords.
354D 509.
House Swami, which is not at all applicable, my lords, because this, my lords, the entire text messages were exchanged on May 2018, my lords. September 2018, my lords, a reconciliation happens between the parties. If you look at section 10 clause 4 of the Posh Act, my lords, very clearly says, if a reconciliation happens, then a further inquiry is not maintainable, my lords.
Inquiry is not maintainable under the act. That does not stop criminal law being set into motion.
Correct, Swami. But this
I
criminal
told you on
case,
the
my
last
lords,
occasion also.
criminal case has nothing to do with this, my lord. The criminal case is all about when the inquiry was happening, he threatened her father and had sent messages in May 2018, based on which this FIR is registered, my lords. It is not that.
What are the texts you have sent?
My lords, on page number 7 of the inquiry report, Swami, it says.
What is this?
It says two words, my lords. It
I
says,
love you.
Aste, Swami.
ಆಮೇಲೆ I am full of you.
Illa, Swami. There's nothing of that.
It's here, sir.
No, my lords. On page number 7, fourth paragraph, it really says.
You're a doctor.
Yes, sir. I mean, PhD. He's practicing as a lawyer now.
Practicing is advocate.
ಹೌದು ಸ್ವಾಮಿ, ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಮಾಡ್ತಾರೆ ತೆಲಂಗಾಣ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಅದಕ್ಕೆ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಅಂತ ಹೇಳಿದ್ರಿ?
ಅಲ್ಲಿ ಹೋಗಿ ಮಾಡ್ತಾ ಇದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ಹೇಳಿಲ್ಲ. But apart from these, there is nothing on the record, my lords.
ಎಸ್ ನೋಡಿ ಅಜ್ಜಿ ಕೊಡಿ. ಎರಡೇ ವರ್ಡ್ ಹೇಳಿರೋದು ಅಂತ ಇದ್ದಾರೆ ಚಾಟ್ ಅಲ್ಲಿ.
My lords, I'm only referring to the ICC report, my lords. The ICC report has only said that only these texts were shared, my lords. Apart from this,
Not only to her and also her friends.
ಯಾವ ಸಬ್ಜೆಕ್ಟ್ ಅಲ್ಲಿ PhD ನೀವು?
ಅದು ಕೇಳಿಲ್ಲ ಸ್ವಾಮಿ.
ಕೇಳಲಿಲ್ವಾ? ಯಾರ್ಯಾರಿಗೂ ಕಳಿಸಿದ್ದೀರಾ ಮೆಸೇಜ್?
ಸ್ವಾಮಿ,
ಯಾರ್ಯಾರಿಗೂ ಮೆಸೇಜ್ ಎಲ್ಲ ಕಳಿಸಿದ್ದೀರಾ? What's the name of the complainant?
Ashwini.
Anything else? Anyway, the POSH committee also has held you guilty.
Yes, my lords, but they're only saying that she has not responded, but these messages were sent on this one.
She is represented here.
No, Your.
Served under pension. Notice ಮಾಡಿಲ್ವಾ?
In UN.
Huh?
She's working in UN.
In
UN.
UN. Yes, sir. Not a case for it.
Then I'll withdraw, my lords.
Otherwise, sumne I refer to these chats, then you'll be fixed there. If you want, you can see what your client.
I have not
is.
seen it. I'll take copy.
Jagdish or.
Because I only have 7 days of chat. was
Not
given.
only 7-year child.
7 days of chat were given to me. That is what I had filed as part of the petitions. I have not seen the whole chat.
No, but see the chats. It does amount to 509. ನಿಮ್ ಪ್ರಕಾರ ಎರಡೇ ವರ್ಡ್ ಅಲ್ಲ. I love you, I'm in full of you ಮಾತ್ರ ಅಲ್ಲ. Yes. Sorry. Learned counsel for the petitioner, after arguing the matter at length, seeks leave of this court to withdraw the petition and avail of such remedy as is available in law before the appropriate forum at the appropriate stage. ಇದು ವಾಪಸ್ ಕೊಡಿ ಜಗದೀಶ್ ಸರ್. POSH committee ಬೇಕಾ?
Better.
Don't want?
I have, Lord.
Oh, yes. Let it be in the file.
I can't believe it.
Second respondent.
Conflict of interest, huh? Hello.
I appear for the second respondent.
Oh, yes, sir. ಅದಕ್ಕೆ.
Lords, complaint is under FIR registered under 498A and 304B.
You are A8 and A9.
The disease,
A8 and A9.
yes, the disease, my lords, is the niece
Hmm.
of A9. That's the second petitioner. I am the girl's uncle. That's her father and I are brothers.
Hmm.
And my wife is also implicated.
Hmm.
Now 498, I'll take your lordship to the facts, but
Please.
498A, if your lordship sees, it's only against the husband's relatives. I am the girl's uncle. And the entire complaint is the dowry is against the husband's, the girl's husband's relatives. And I am
Yes.
implicated if your lordship.
ಮುಗಿಸ್ಬಿಡಿ.
Let's please come to 498A for a moment.
That I have seen.
And also, my lords, 304B. Both.
304B.
Yes, my lords, if your lordship kindly come to 304B. Where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death, she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for dowry, such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death.
Times have changed, sir. Yes.
Now, my lords, please see the complaint. Complaint of noted.
Page 25, sir.
Your lordships have got. Even in that, she names only the first petitioner.
No, even then ಏನು? ಅಲ್ಲದೆ ನಮ್ಮ
I'll just read that.
ಅಲ್ಲದೆ ನಮ್ಮ ಸಂಬಂಧಗಳಾದ
ನಮ್ಮ ಸಂಬಂಧಿಕರಾದ ಗೀತಾ ರವೀಂದ್ರ, that is my
ರವೀಂದ್ರನಾಥ್,
lord,
ಶಾಲಿನಿ ಓಂ ಪ್ರಕಾಶ್ ಇತರರು
ಶಾಲಿನಿ
ಸೇರಿಕೊಂಡು
ಓಂ ಪ್ರಕಾಶ್ ಹಾಗೂ ಇತರರು.
ಸ್ವತ್ತಿನ ವಿಚಾರವಾಗಿ ನನ್ನ ಮಗಳಿಗೆ ಆಗಾಗ
ಯಾವ, please see my lord, where they bring that.
ಯಾಕೆ why is 498 in the reverse here?
But there is a.
ಇಲ್ಲಿ,
They are arraigned
my lord,
subject
what
to
happened
my lord,
is,
the FIR.
So?
There is a death note, please, my lord, there are.
ಡೆತ್ ನೋಟ್ ಅಲ್ಲಿ
Death note ಅಲ್ಲಿ there are allegations against.
Against
Mr.
them.
Petitioner. Please, my lord.
ಆಯ್ತು ನೀವು ಮುಗಿಸಿ ಸರ್. ಎಸ್
my lords, death note we have not seen. If they have seen, my lords, I do not know how they get custody of the death note.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ವಾ?
No, the investigation is dead. I am,
It is-
for the past 20 years, my lords, I am in US.
It is called.
Not a full paper, my lord, I have a death note.
ಡೆತ್ ನೋಟ್ ಇದೆಯಾ
ಇದೆ.
ಮೇಡಮ್ ಕೊಡಿ. This is
Investigation stayed in less than 15 days.
enter ಮಾಡ್ರಿ.
Yes,
Investigation against these people.
only against us. Now, my lords, my brother does not file the complaint.
1 minute, 1 minute.
It is only my sister.
Only against these, why did you not investigate into others?
I've not verified, my lord, I'll verify.
This is by the coordinate bench.
Yes.
With detailed interim order is granted, sir. Only against the petitioner, there must be 7 more accused.
Please.
Yes.
That
Why
is
why
against
have
the
you not
husband's
conducted
relative.
investigation against others?
That seems to have done, my lord, I have not verified that, what are the investigation will be. Lordship, may I have it?
Death note.
Death note of- Yeah.
ಇವ್ರ ಮೇಲೆ ಏನಿದೆ?
Page number 17 of the FIR, my lord. the
FIR ಅಲ್ಲ, death
contents
note
is-
ಅಲ್ಲಿ.
It is called out. I don't know, my lord, I have not seen the death note.
Page number?
17, my lord.
That's a complaint will be called out in the
It is-
FIR, my lords. It can't be more than that.
ನಂತರ ಎಲ್ಲರ ಸಮಕ್ಷಮನು, last 6 lines, my lord, of the FIR.
ತಿಳ್ಕೊಳ್ಳಿ, note ನೋಡಿ.
ನಂತರ ಎಲ್ಲರ ಸಮಕ್ಷಮ ನೋಡಲಾಗಿ ನನ್ನ ಮಗಳ ರೂಮ್ ನಲ್ಲಿ ಒಂದು ಡೆತ್ ನೋಟ್ ದೊರಕಿದ್ದು, ಅದರಲ್ಲಿ ನನ್ನ ಮಾವ ಗಿರಿಯಪ್ಪ ಗೌಡ, ಅತ್ತೆ ಸೀತಮ್ಮ, ಮೈದುನ ವಿಜಯ್, ಓರಗಿತ್ತಿ ತಸ್ಮೈ ಹಾಗೂ ಸಂಬಂಧಿಕರಾದ ಗೀತಾ ರವೀಂದ್ರನಾಥ್, ಲಿಪಿ, ಶಾಲಿನಿ ಓಂ ಪ್ರಕಾಶ್ ಹಾಗೂ ಇತರರು ಸೇರಿ. It is the contents of the death note. my lord, it is.
Why
I'll place all the material.
investigation should have gone on against others?
No, I'll place all the material. Friday, my lord.
Friday, but Tuesday ತಗೊಂಡು. Let the heard the learned senior counsel K. N. Panindra appearing for the petitioner and counsel Vandana PL representing the complainant,
Please.
representing the respondent complainant, and the learned additional SPP. Learned additional SPP would submit that there is an interim order operating and therefore the investigation is
No, I'm not sure, my lord.
sure. Okay. The learned additional SPP submits that in the teeth of the interim order, if investigation is moved forward or not, would be, instructions with regard to the stage of investigation would be secured and submissions would be made on the next date of hearing in the teeth of the interim order subsisting in the case at hand. The interim order is granted qua the petitioners accused number 8 and 9. Therefore, the learned additional SPP to secure instructions if investigation has not progressed any further and as to why it has not progressed any further. List on Tuesday Tuesday at 4 PM for further hearing. Yes, ಇದು ತಗೊಳ್ಳಿ. ಇದು ಡೆತ್ ನೋಟಾ? But if there is, your role ಇದ್ರೆ that's a different thing. 498 ಅಂತೂ ಬರೋದೇ ಇಲ್ವಾ? 498 in the reverse we cannot. 304B we will see.
Appearing for respondent. Section 7A.
7A. Okay. 8th, list on 8. Next.
71.
Here for the petitioner's memo. It's a petition filed under 482 for offense punishable under 417, 419, 420, 465. 471 of IPC, my lord. Kindly peruse the complaint at page 14, annexure B, my lord.
71.
Who appears for the respondent?
No notice has been, first
time,
time here. ಅದು ಪೋಸ್ಟ್ ಆಗ್ತಾ ಇತ್ತು ಆದ್ರೆ ರೀಚ್ ಆಗ್ತಾ ಇರ್ಲಿಲ್ಲ.
Let's tomorrow in the fresh matters list, please. Yes. Next.
72.
Here. Your complaint. The copies and everything is given to the respondent advocate, but he has not appeared. But check.
ಯಾವಾಗ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ ಸರ್?
ಅದು
No representation,
No.
we have the petitioner.
7/6 November.
If the service is complete, we want in 138,
138.
we'll give one more chance. List on next Tuesday, could date. Yes, next.
Petitioners, please.
Malats, I appear for the complainant, Malats.
Yes.
Malats, my instructions are that the charge sheet is filed just 2 days back, Malats. I'll ascertain and get back on this if it can be
Again,
taken up next week.
I'll have to make, even in the last occasion, the same submission
I
was
made
made.
the same submission,
I
Malats.
have
but,
ascertained from my client if the charge sheet was filed. And he said, so the charge sheet isn't filed even till.
Anyway, you secure those instructions. In the meantime, we will stay this.
Malats, not stay, Malats, because my colleague is there with the documents. May I please place
What
certain
documents?
documents on? Malats, this is the offense under Chit Funds Act, Malats.
True.
And
Yes.
of course, in the complaint, nothing is elicited much. But however, Malats, the documents may kindly be seen. The page 2, Malats, is a release order wherein I have got back 1.5 lakh from the Malats, the concerned jurisdictional police. So this establishes that there is some substance in the
From
complaint.
his account?
That
is
that
not
is
a
not
pa-
forthcoming from the release order, but it is in the same crime number.
Even,
One minute.
even according to their complaints, our
We'll
notes.
get the investigation papers. Learned additional SPP is direct. Notice agilo nimge?
I did.
Is directed to act. Notice agide.
Notice agade, even.
I've already directed that to get investigation papers.
And accused number 1, 2, and 5 are before my lord's milord. Even to the complaint governments, the amount is transacted to accused number 4. Even
No,
offense-
this 1.5 lakhs yarinda bandiradu? Which was seized, released for interim custody to the petitioner Manjula. Just look into it.
Malats, the next document is a photo of us receiving from the concerned police, Malats.
Yes, we'll see. Let the investigation papers
307
come.
is invoked, milord. 307.
307.
Please, milord. Absolutely, there is no material to attract the provision of 307. Even in the government, it said so. ಕರ್ಕೊಂಡು ಹೋದ್ರು ಕೂರಿಸ್ಕೊಂಡ್ರು ಚಾಕು ತೋರ್ಸಿದ್ರು ಅಂದ್ರು. That is the only allegation.
Malats, this is in connection with all the few other sections of the Chit Funds Act, Malats, read with 506 and 504 of IPC, Malats.
That's okay. Why 307, madam?
Basic ingredients of 304,
Yes.
307 is not full.
Get the.
That's a matter of trying,
The
Malats.
learned, seriously, learned additional SPP is directed to accept notice for the respondent. Agidya?
Agide.
The learned additional SPP is directed to secure the investigation papers and place it before the court by the next date of hearing. For an offense that completely relates to transaction under the Chit Funds Act, as several offenses of Chit Funds Act are invoked, offense of section 307 is also laid in the, is also alleged while registering the crime in crime number 458 of 2023. A perusal at the complaint nowhere indicates a speck of ingredient for the offense of section 307 of the IPC. Therefore, awaiting the investigation papers, the offense under section 307 of the IPC shall remain stayed. Yes.
Yes, my lord, fix a date.
Yes. List on 20th.
Please.
Yes.
74.
And for the petitioner. But this matter is about the Factories Act. But
Factories.
Interim order ಇರ್ಬೇಕಲ್ಲ.
last date, it was not extended.
That is what. Interim order ಇದ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ. What is the ground?
But my ground is, my primary ground is that no appeal, no opportunity to appeal under 107 afforded to me. But I'm a research institute. The respondent comes for an inspection and submits a report saying that I'm a factory. Issues a show cause notice and directly goes on to prosecute me before the learned magistrate. This is in fact, my lord, second round of
What are
litigation.
the offences alleged?
Offense alleged is that I have not registered in the Factories Act.
No. Under what provision of the Factories Act?
92, my lord.
Only 92?
Now only 92.
Appeal is available for 92?
Yes, under 107, my lord.
107 nodi.
107 of the Factories
Factories
Act.
Act.
Please.
Because appeal is provided only on certain provisions,
Please.
not all.
May I read, my lord? The
Any
manager
order-
of a factory on whom an order in writing by an inspector has been served under the provisions of this act, or the occupier of the factory may, within 30 days of the service of the order, appeal against it to the prescribed authority, and such authority may subject to the rules made in this behalf. by
Any
the-
order, is it?
Any order.
I doubt.
Service of the order ಅಂತ ಹೇಳ್ತಾರೆ. That's what it says.
That's what, let me see. Yes, come. There's one judgment I've
My
written.
lord, may I,
That
in fact, I have,
Toyota.
on the very same point, I'm producing 4 judgments of coordinate benches on the very same point.
No, one.
One the cartilage is there, then, in fact, the first 4 judgments are the same. If your lordship turns to annexure, page 16.
Anita Hada and company.
Anita Hada is because the company is not made a party.
Not necessary.
In this judgment number 4, page 16 of my judgment.
No, I'll take this tomorrow. I have rendered a judgment which is SLP against which is dismissed.
Please.
First thing is, company need not be made a party under the.
No, I'm not
Factories
stressing
Act.
on that point at all.
So that is over.
Please,
Anita Hada is not applicable to
please.
Factories Act.
please.
The next is, appeal is provided not on all orders passed.
I
but
agree
on
with
few orders passed.
Please, I'm with that.
Certain provisions are there where orders are passed.
Please.
Then Toyota antonu. Toyota
No,
Kirloskar.
This is a peculiar case, my lord, because where the act does not apply to me.
Anyway,
To
you
say that
haven't-
it applies to me, that is a question.
Why your act does not apply to you?
My lords,
Act does not apply to you?
act does not apply to me at all. I'm registered under Shops and Commercial Establishments Act. I've been given a registration under the Ministry of Scientific Research and
Your therapeutic.
Development. Yes, I'm purely, my lord, nothing is forthcoming in the inspection report as to what I manufacture, what is the product I sell. Something must be shown in the show cause notice.
And show cause notice reaches you after the prosecution
No, no.
or prior? to
I have
that?
show cause notice is issued to me. I reply to it. Straight away, I get a summons from the magistrate.
Yes, sir. We'll consider it.
Please. Tomorrow, my lord.
Yes, tomorrow.
Copy ಕೊಡಿ judgment.
Madam, Toyota ಅಂತ ತೆಗಿಬೇಕು judgment.
$75.
231, man.
230.
230, an officer has,
For what purpose?
lordship has summoned the investigation of.
Which case? ಯಾವ್ದು ಕೊಡಿ madam?
I think the investigation officer has not collected a CCTV.
That Leeladhar ಅವ್ರದ್ದು.
Yes, yes,
Leeladhar's case.
yes.
ಕೊಡಿ. Yes, sir.
Producing additional document.
Yes, additional speech. Who is the IO?
Any,
CCTV footage is not taken? Destroy ಆಗಿದೆಯಾ? ಯಾರು destroy ಮಾಡಿದ್ದಾರೆ? You have the footage, you said?
Pardon, Your Lordship?
See, it is destroyed is what is being said.
My submission before your lordship is, suppose you are assuming for the sake of argument, it may be destroyed. It can be traced out whether these parts are available, because DVD,
Parts ತಗೊಂಡು ಏನ್ ಮಾಡ್ತೀರಾ?
DVD is available. DVD available.
Sir, DVR, the entire thing is destroyed? Where is the indication anywhere in the investigation papers that it is destroyed? ಎಲ್ಲಿದೆ? ಎಲ್ಲಿ ಹೇಳಿದ್ರೆ destroy ಆಗಿದೆ ಅಂತ? Very easy to say it is destroyed. When did you inspect and when did you drop the measure with regard to destruction of the CCTV? ಯಾವಾಗ ಮಾಡಿದ್ರಿ?
Next day ಮಾಡಿದ್ರು.
ಎಲ್ಲಿದೆ? Investigation papers ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
That is why I asked the superior officer to.
ಎಲ್ಲಿದೆ paper? If you have not indicated that you have deliberately said it is destruction of CCTV, we will direct proceedings against you. ಎಲ್ಲಿ ಇಂಡಿಕೇಟ್ ಮಾಡಿದಿರ ಕೊಡಿ. ಏನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದ್ರಿ ಮತ್ತೆ ನೀವು? Is not the CCTV footage the most important evidence? A destroy ಆಗಿದ್ರೆ where have you indicated that it is destroyed? Huh? What's his name?
Krishna Swami.
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
20 years.
20 years. ಎಷ್ಟು ಕೇಸಲ್ಲಿ ಐವೋ ಆಗಿದ್ದೀರಾ? ಸುಮಾರಾಗಿದೆ. CCTV ಬೇಕು ಅಂತ ಗೊತ್ತಾಗಲ್ಲ. ಎಲ್ಲಿಗೆ?
Election transfer ಆಗಿತ್ತು.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಯಾರು ಮಾಡಿದ್ದು ಸರ್? ಇವರಲ್ವಾ?
ನನಗೆ ಒಂದು ತಿಂಗಳಾಗಿದೆ.
Who is that IO?
That is
I
why
asked him, summon him and ಇವ್ರು ಯಾರನ್ನ ಬಂದ್ರೆ?
That is why I asked the superior officer also to be present, because I've seen the paper
Yes.
that is not been indicated, the additional SP present.
Who are you? Additional SP? SP. Who, where is that? Where is the person who investigated? ಎಲ್ಲಿದ್ದಾರೆ ಅವರು?
We are waiting for Quashing, sir.
Waiting for posting. Get him. What's his name?
Suraj.
The what's your Krishna? Name?
TT Krishna.
Circle Inspector. Shri Krishna Circle Inspector and the additional Superintendent of Police, so and so, is present before the court on the direction of them, on the direction issued by this court. The learned additional SPP on verification of the records would submit that it is not Krishna who was it's not the officer Krishna who is the investigating officer, but one Mutturaj. Mutturaj, one Mutturaj, who is now awaiting posting. Therefore, the said investigating officer who has investigated into the crime be present before the court and not substitute his presence with someone else. He shall be present before the court at 2:30 PM on Friday.
My submission, one thing, case registered on section 395, case registered 350. Then accused number 1 went to the police station in the 7:30 PM, lodged a complaint against me. That complaint has been quashed. They are not arrested. That itself shows your lordship bias in investigation.
Barli.
I made a representation to the
Let him
SP.
come, we will direct further investigation if it is needed, yes. At
ಈಗ
2:30.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತಿವಿ ಅಂತ ಒಂದು ನಮಗೊಂದು ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ.
Charge sheet ಹಾಕಿದಾರಾ?
ಇಲ್ಲಿ ಹಾಕಿಲ್ಲ, ಹಾಕ್ತೀವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಒಂದು ಪಾಸ್ ಆನ್ ದಿ ಇವತ್ತು ಈಗ ರಿಜಿಸ್ಟರ್ ಕೋಡ್ ನೋಟ್ಸ್ ಕೊಡಿ ಸಾಹೇಬ್.
ಒಂದು ನಿಮಿಷ. The present IO ಯಾರು?
He is the present type.
Charge sheet ಹಾಕಿದ್ದೀರಾ? Fine. No, let them not file the final report.
Right.
There is the investigating officer shall not file his final report till the next date of hearing. Get the papers completely. You have seen the papers.
I've seen.
There is no indication, there is no marker drawn.
Mazar is there, but this aspect is missing. That is why I asked him if it is they have stolen, they should have.
395 ಅಲ್ಲಿ most
Oh.
important is CCTV.
ನಾನು ಫೋಟೋಗ್ರಾಫ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
We will direct. If need be, we will permit
That is why I asked the superior officer.
departmental inquiry against that man. He will permanently be awaiting posting.
ಅದು ಮಾಡ್ಲೇಬೇಕಾಗ.
Yes.
Yes.
Friday 2:30. Madam, ಅದರಲ್ಲಿ presence of these officers are noted and ಮತ್ತೆ ಬರ್ಲಿ, ಇವ್ರು ಬರ್ಲಿ.
Let them come.
ಬೇಡ, ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ದಿಸ್ ಆಫೀಸರ್ಸ್ ಆರ್ ನೋಟೆಡ್ ಅಂತ ಮಾಡ್ಬಿಡಿ ಅಷ್ಟೇ ಸಾಕು. Yes, continue the list.
75. Petitioner in this matter, my lordship. Prays for a week's accommodation, my lordship.
Interim order ಇದೆಯಾ?
Yes, my lordship. Copy is
what-
also served to the trial court
What's
advocate.
the matter? 138 ah?
Yes, my lordship.
List the matter on 3rd September.
I will be extended.
Interim order subsisting shall continue till the next date of hearing. Thanks.
76.
Your Honor,
I'm- You're for the complainant.
I'm for the respondent.
138 ah?
No, my lord.
ಮತ್ತೆ
406, 420.
Respondent complainant ಅಲ್ವಾ?
Yes.
Notice is not issued to you?
It has been issued, Your Honor.
Name is not shown? 70?
6, my lord.
Ah. Yes, sir. What's the matter?
Please, my lord. The petitioner is.
Time ಬರ್ತಾ ಇರೋದಾ?
No, my lord. Stay has been granted.
Granted. Yes,
We have filed an application for vacating the stay, Your Honor.
all right, yes.
Shall I please?
Hmm.
My lord, the petitioner is a investor. Kindly turn up into page number 21, my lord. The facts of the case.
Petitioner is the investor.
Investor, yes, committed to invest the amount of rupees 1 crore in his startup company around U Labs Private Limited.
Yes, sir.
And he has invested 25 lakhs in para number 7. However, he has invested only 25 lakhs into the startup, and as he did not wish to honor his commitment due to the personal reasons, he willingly forfeited to 25 lakhs in the startup company. This, according to the complaint, it ends up in year 2017. Further, in the year 2021, once again, he met the petitioner. The complaint met the petitioner in Delhi. And he introduced, the petitioner introduced one Maula Sharif, who is the MD in Gopal Krishna Sauharda Credit Cooperative Limited. And he assured that he will get the loan of rupees 5 crores from the said bank. And periodically he has induced the complaint to pay the amount of rupees 65 lakhs, which was paid to Maula Sharif. Further, he has alleged that on various dates till the year 2021, he has paid the amount of rupees 65 lakh 75,000 to the petitioner. And later, after receiving the said amount, neither he has responding to the calls that has been made by the petitioner, nor he has paid back the amount. This is the allegation made by the complaint against the petitioner, my lord.
Yes.
My lord, may kindly see in the para number 7, he has very clearly admitted that the petitioner has invested the amount of rupees 25 lakhs.
Para 7 of the complaint.
The petitioner has invested in the startup company of the complainant.
Of the complainant.
Of the complainant. And he has very vaguely has stated that he has forfeited that 25 lakhs. No reasons has been given why petitioner has forfeited that 25 lakhs. In para number 7, he willingly forfeited the 25 lakhs.
You have also registered a complaint?
No, I have not registered. So, because subsequently his wife has died due to the cancer in the year 2020.
Whose wife?
The petitioner's wife.
All right.
He was intending to invest the amount in the said startup company to make her, provide her a opportunity as a manager in that said startup company.
Yes.
Around U Labs. And in the year 2020, she has died due to the cancer. So that he was not able to make any complaint or request him to pay back the amount. Subsequently, after the death of his wife.
Is there a transaction between you and the complainant?
Please, my lord.
That is investment.
Investment.
No, other than that
Page number
transaction.
50, my lord.
Other than that transaction.
No, any other transaction between him and it.
Excuse me, Your Honor.
Him and the petitioner.
Wait. Get back to
Page number 50, my lord. Here, sir, our agreed upon tranche structure is as follows: 25 lakhs, 30 lakhs, 9 lakhs plus loan parts as needed.
And he has also agreed that total amount of transfer till now is 20 lakhs. Remaining 5 lakhs he has stated there,
Pending 5 lakhs.
25 lakhs.
That is the
That
investment.
is, he has clearly admitted in the complaint. At para number 7.
What did he invest for?
He has invested 65 lakhs, 64 lakhs
But for what?
for startup company. This
What
is a
what
chef's
happened
company.
to the company?
He has not started up the company.
No, invested in your startup company or complainant?
Complaint startup company.
The allegation is against you for what, sir?
For he has not paid, return back the, once again, he has alleged that I have obtained the amount of 65 lakhs 70,000 as a loan.
Loan. Yes.
In page number, para number 22, my lord.
Any document for that loan?
No documents has been produced.
All right.
Once he says that he has cheated him. Now he has stated in the para number 22, very clearly has stated that I have paid the amount of rupees 65 lakh 75,000 to Manish Prakash as a loan. If at all, if it is a loan, it's
Yes.
a civil transaction.
All right. Yes, madam.
Your Honor, there are two incidents. The first one is in 2017, where he says that he had made an investment in Around You Labs. This dispute is not regarding that incident. The dispute in question is regarding the incidents.
Use a mic.
The dispute is regarding the incidents that happened in 2021.
All right.
So in those transactions, we are not accusing them of, it is not a case where earnest money is being forfeited. A loan amount of the loan of the.
Where are the documents for loan amount?
The charge sheet has been filed and the record.
Charge
of
sheet
the
has been filed.
Yes, yes, Your Honor.
Where is the charge sheet?
I have the charge sheet with me here.
Charge sheet ಹಾಕಿದಾರಾ?
Subsequent, I came to know now.
Huh?
Yes, my lord.
How did you file the charge sheet? ಯಾವಾಗ ಆಗಿದ್ದು?
Stay was granted on 27/5. my lord, I
27/5
think
charge sheet?
19.
So the charge sheet filed.
No instruction, my lord, with respect to the charge sheet.
The charge sheet was filed on 19/6/2024.
Get the charge sheet. ನೋಡಿ ಅಲ್ಲಿ ಯಾವತ್ತು ಹಾಕಿದ್ದಾರೆ ಅಂತ.
My lord, 1/6/24, my lord, charge sheet is submitted to the court.
I have granted on stay on 27/5. How did the charge sheet come about? This court on 27/5/2024 had passed the following order. In the teeth of the interim order, it appears that the investigating officer, officer in charge of the police station has filed his final report before the concerned court. Therefore, the learned HCGP to secure instructions as to how, despite the interim order being granted, the final report, i.e. the charge sheet, could be filed before the concerned court by the station house officer, all officers in charge of the police station. List the matter on 20th August. Interim order subsisting shall continue till the next date of hearing.
Obliged.
Even otherwise, it's purely a recovery for money. You have registered the crime.
There are many references.
No.
And even in.
Impermissible in law. Anyway, get ready. Yes.
Even under section 415 of the IPC, example F.
Examples don't make everything, madam. Yes. You get ready and come. Name ತಗೊಳ್ಳಿ. Registry to print the name of so-and-so as appearing for the second respondent complainant. Next.
57.
Was appearing on behalf of the petitioners. The previous occasion, the complainant had sought time of 2 weeks to file a reply. They have not filed a reply so far.
What reply?
Statement of objections to the petition one.
ಹಾಕಿದೆ. What is this? Right health platter. So you give right health on a platter?
Dairy products.
Yes. Previous hearing, that was not the reason for adjournment.
International fraudsters.
My lords, if they don't wish to
America,
file a reply, my lords may kindly
Singapore,
post on.
America, SEBI has taken action. American courts have taken action. Tamil Nadu police have taken action. International fraudsters.
International fraudsters.
ನನ್ನ ಹತ್ರ judgments ಇದೆ. ಕೊಡ್ತಾ ಇದೆ.
ಕೊಡಿ.
My lords, this is a transaction between two Singapore entities.
Argument ಮಾಡೋಣ. ಮಾಡಿ, ತಾವು ಮಾಡ್ಬೇಕು.
ಯಾವ್ದು ZREC ಇದು?
ಹೌದು.
Network manufacturing.
ಸಿಂಗಪೂರ್ ಇದು ಇಷ್ಟೇ. Three companies are involved. One is Network. The other two are there. There is the Right Health Platter and the More. The Right Health Platter and the More, they are sister concerns. The directors here in Right Health Platter and More are one and the same. Officials are also one and the same. Right Health Platter would accept certain purchase orders from us, saying that we are going to supply some materials to you, pursuant to an order placed by More, which is their sister concern. ಅವ್ರ ಹತ್ರ ತಗೊಳ್ಳಲ್ಲ ಅವರು. ನಮ್ಮ ಹತ್ರ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ, ನಾವು ರೈಟ್ ಹೆಲ್ತ್ ಪ್ಲಾಟರ್ಗೆ ನಾವು ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. ನಾವು ದುಡ್ಡು ಕೊಡ್ತೀವಿ ಮೊದಲು ಇನಿಷಿಯಲ್ ಸ್ಟೇಜಸ್ನಲ್ಲಿ, ಸಪ್ಲೈ ಮಾಡ್ತಾರೆ. All of a sudden they will stop. We will also stop making the payment. But they will prepare false invoices, delivery notes, and obtain the amount from the bankers, HDFC Bank, ಬೇಕಾದಷ್ಟು bankers, financiers. But on the strength of the fabricated, false, forged invoices and delivery rates. That in a nutshell is the case.
Hey, my lords.
And yella foreign exchange.
Yeah, you're ready?
My lords may kindly have it next week.
Why?
Because if they don't wish to file statement of objections,
You don't worry about them, sir.
my
Now
lords
you
may
tell
have
me.
it any day this week also, my lords.
Yes, sir. ಯಾವತ್ತಾಗ? ಮಂಗಳವಾರ ಹಾಕ್ಲಾ?
ತಾತ್ಪರ್ಯ ಅಷ್ಟೇ, ಇದೇನಿಲ್ಲ.
ಅದು ಗೊತ್ತಾಯ್ತು. ಅಷ್ಟೇ ಕೇಸ್.
ಅವರಿಬ್ರೆ ಅವರು More should have gone to their sister and the petitioner and purchase the materials. ಇಲ್ಲ, ನಮ್ಮ ಹತ್ರ ಆರ್ಡರ್ ಕೊಟ್ಟು ನೀವು ಅವ್ರ ಹತ್ರ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿ ನಾವು ಅವ್ರ ಹತ್ರ ತಗೊಂಡು ಫ್ರಾಡ್ ಮಾಡ್ತಾರೆ. That is the fraud.
Tuesday.
I don't want to commence arguments, my lords, because I'm led by learned senior counsel, Mr. Dhyan Chinappa.
I know interim order he was there.
Yes, so my lords may have it on any convenient date.
Tuesday. Yes.
No difference.
Heard the learned senior counsel C.V. Nagesh representing the respondent. The learned counsel for the petitioner submits that the senior counsel Dhyan Chinappa has some inconvenience today. List the matter for Tuesday at 3:30 PM.
In fact, I was told that reluctantly he had the benefit of an interim order of stay.
He has.
Doesn't matter, mother. A stay is there, that's
He
it.
has. Not granted on the first occasion, but
Yeah.
later, yes.
Yes, on first 2 or 3 occasions, he could not get the benefit, and the 4th occasion he
Oh,
got.
yes, fourth
Doesn't matter.
occasion.
But he
Interim
got the
order to
benefit.
continue.
This is the 5th occasion. 6th occasion will close it.
Doesn't matter.
Yes.
Interim order to continue.
Yes, sir.
All right.
Deeply
Interim order subsisting will continue till the next date of hearing.
Deeply obliged.
Tuesday at 3:30 PM. Yes.
TV Act, my lord, interim maintenance.
Stay of further proceedings ಆಗಿರೋದ್ರಿಂದ he is neither paying nor representing before the court,
ಹೌದು sir.
even in spite of
Hello, what order is challenged?
Interim order about maintenance.
16/9/21.
Yes, my lord, under DV 12.
ಅದು maintenance order.
23.
5,000 is to
ಒಂದು ನಿಮಿಷ, maintenance order.
Yes, my lord.
ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿ. Court of Session under 29 file an appeal.
ಅಲ್ಲ,
I have
appeal
rendered it.
Maintenance.
ಅದು dismiss
ಇದು ಆಗಿದೆಯಾ?
ಅದು ಆಗಿದೆ,
Yes.
ಕನ್ಫರ್ಮ್.
Yes, sir.
Lord,
ಇದು ಮಾಡ್ಬೇಡ ಹಾಗಾದ್ರೆ, ಹೇಳ್ಬಿಡಿ. We'll finish this also. Arrears ಎಷ್ಟಿದೆ?
ಟೋಟಲ್ 4 lakhs, ಅದರೊಳಗಡೆ 110 ಕೊಟ್ಟಿದ್ದಾರೆ, 370 ಸ್ಟಿಲ್ ಪೆಂಡಿಂಗ್.
370.
Yes.
Yes, sir.
Lord, trial court granted my lord interim maintenance of 5,000 each of the respondents, 1 and 2. Respondent number 1 is the wife of the petitioner.
One is wife,
Yes, my lord. Respondent
two
2
is
is
the
daughter.
child.
Child daughter.
All right.
My lord,
What is wrong with the maintenance orders?
my lord, respondent number 1 is the engineering graduate working in Infosys.
Huh.
I produced a document, my lord, to show that, my lord.
Working in Infosys.
Yes, my lord.
What are you, sir?
But I am a professor, my lord, in private college, earning, my lord, only 29,800 rupees. I have produced document.
Professor in a private college.
Yes, 77.
Professor getting 29,000 is unheard of, sir. Yes.
77, you lost to spend this with paid,
Yes, sir.
77. Assistant professor.
Attend to associate to professor more ಇದೆ. You are at the lower rung.
Yes, lower grade.
Professor 29,000 ಅಂದ್ರೆ.
Yeah, lower grade ಇದೆ.
Yes. Hmm.
monthly income is my lord 29,800.
ಈಗ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್?
10,000 each, my lord. Sorry,
10,000 each.
5,000 each.
5,000 each.
Yes. Now, my lord, my lord, I am paying the fees of my daughter. Lordship kinds, my lord, receipts, my lord, on page 79, 80, school fees. I am paying right from 22.
So school fees ಕಟ್ಬಿಟ್ರೆ responsibility ಆಗೋಯ್ತು ಅಂತನಾ?
Well, I am ready to take my daughter and also my wife. And she is, my
They
lord,
should be ready to come ಅಲ್ಲ?
she is very, my lord, adamant and toxic behavior.
What behavior?
Toxic behavior.
Toxic
Yes.
behavior. Yes.
Not cooperating with my parents.
Cooperating with your parents.
Joint living.
Anyway, that is before the concerned court. We will not go into that. There is nothing wrong with 5,000, sir.
5,000, my lord, for
ಆಯ್ತು.
wife. She is earning, my lord, she is capable of earning herself.
No problem, sir.
No, she is capable, she
We
is
will-
engineering
we will-
graduate.
We will say wife will not receive anything. Child will receive 10,000.
For child, my lord, I have no objection.
10,000 pay, sir.
5,000, my lord.
No, pay 10,000 to the child.
I am paying, my lord, also.
I'll modify the order.
Maintaining.
I'll modify the order. Wife will not get anything. Child will get 10,000.
Extra 2,000.
That your
extra
ego is
2,000.
satisfied. ಅವಾಗ.
Yes, my lord, extra for
Correct.
extra 3,000 for my daughter. I am ready.
13,000 ಕೊಡ್ತೀರಾ?
8,000.
8 ಯಾಕೆ?
Yes.
Round figure 10.
Around 10.
Why 2,000 lane bargain? Giving it to your daughter, sir, nobody else.
ಅವಳು ತಿನ್ಬಿಡ್ತಾಳೆ, ಹೆಂಡತಿ ತಿನ್ಬಿಡ್ತಾಳೆ.
ಅವ್ರು ತಿನ್ಬಿಡ್ತಾರ? ಅವ್ರಿಗೆ ಸಂಬಳ ಬರುತ್ತೆ ಬಿಡಿ. ನಿಮ್ ಪ್ರಕಾರ she is earning well. Why are you worried? She will not eat your money.
Only to take care of daughter, he asked her to resign from the job, she has resigned at his instance.
ನೀವು ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ, ಅದು
ಒಂದು 25,000 ಮಾಡ್ಬೋದು.
ಅದು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಲೀಗಲ್ ಸರ್ವಿಸ್
ಬರೋದೇ 30,000 ಹಿಂಗೆ ನಾನು ಕೊಡ್ಲಿಲ್ಲ.
Search a better job, sir. Search a
out of
better job.
30,000, 1/3 is ordered.
Now, my lord,
He's staying with her
my submission,
mother.
my earning is only 30,000. My lord, I have aged parents to look after.
You describe yourself as professor. Where is the appointment order?
Lord, on page,
Serving as assistant professor.
no, assistant professor.
ಅಲ್ಲ, ಕಾಸ್ಟ್ ಟೈಟಲ್ ಪ್ರೊಫೆಸರ್ ಅಂತ ಹಾಕಿದ್ದೀರಾ?
ಹೌದೌದು.
Page number 77.
32 ವರ್ಷಕ್ಕೆ ಪ್ರೊಫೆಸರ್ ಆಗಲ್ಲ ಯಾರು.
77.
He is shown as assistant.
ಅರ್ನಿಂಗ್ ಎಷ್ಟು ಸರ್ ನಿಮ್ದು?
No, she has resigned from the job because of
Where is the resignation?
resignation. It is mentioned in the petition itself. Everyone knows.
Where is the letter of resignation?
No, that is not produced. It is, maybe it is produced.
If you have asked her to resign to take care of the child,
No, I have
you
not.
better well take care of
I
both.
have not asked
The
her.
document also. I
He
have
purposely, my lord,
Purposely?
yes,
Toxic.
to put me in trouble.
Toxic behavior.
Yes.
And when this order was there, passed, she was 2 years, now she is first standard. He has only paid, I have deducted that amount also, 31,000 he has
ಈಗ
paid.
3,70,000 ಕೊಡ್ತೀರಾ?
ಇಲ್ಲ.
ಕೊಡಲ್ಲ.
ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಇದು ಕೊಡಕ್ಕಿಲ್ಲ.
ತೊಂದ್ರೆ ಇಲ್ಲ. Yes. Heard the petitioner is before this court calling in question an order dated 16/9/2021 passed by the Court of Session in Criminal Revision Petition 27 of 2021, by which the order of the concerned court dated 15/1/2021 comes to be affirmed. Heard so and so. The petitioner is the husband, the first respondent, his wife, and the second respondent, the child aged 5 years. Marriage between the petitioner and the first respondent takes place on 1/9/2017, and child, the second respondent, is born from the wedlock. It transpires that later the relationship between the husband and the wife flounders. And on floundering of the relationship, several proceedings are instituted by the wife against the husband. One, setting the criminal law into motion for offense punishable under section 498A and 3 and 4 of the Dowry Prohibition Act. And the other, invoking section 12 of the Protection of Women from Domestic Violence Act 2005. The issue in the list does not concern the merit of the matter in the criminal, merit of the matter in the crime or in the domestic violence proceedings. The wife files an application seeking interim maintenance from the hands of the husband to herself and the child. This comes to be allowed by the concerned court in terms of its order dated 15/1/2021, directing payment of maintenance, interim maintenance at rupees 5,000. The husband challenges the same before the court of session in criminal revision petition before the revisional court at the moment. Before the revisional court in criminal revision petition 27 of 2021, only to be dismissed. It is these orders that has driven the petitioner to this court in the subject petition. The learned counsel for the petitioner would submit that the petitioner is earning 30,000 rupees a month as he works as an assistant professor in a private educational institution, and payment of 5,000 each to the wife and the child would be onerous on him. He would further submit that the entire school fee of the child is being paid by the husband, by the petitioner from 2022, na?
22.
From 2022 onwards. He would therefore submit that, he would further submit that the wife is working in Infosys,
Yes, that is my
employed in
information.
Infosys, and therefore there is no necessity for the wife to seek and grant and seek maintenance, and the court granting maintenance in the favor of the wife. Per contra, the learned counsel representing the respondent wife would refute the submissions to contend that after the birth of the child, at the insistence of the petitioner, she has resigned, she has quit the job, and she has to now take care of the child. The amount that is ordered is not so exorbitant that the petitioner cannot pay. He would seek dismissal of the petition. I have given my anxious consideration to the submissions made by the respective learned counsel appearing for the petitioner and respondent. The only issue that falls for consideration is whether the orders passed by the concerned courts would warrant any interference or otherwise. The submission of the the relationship between the parties is a matter of record. The husband is directed to pay maintenance at rupees 5,000 to the wife and to the child, each totaling 10,000 rupees per month. The submission of the learned counsel that the petitioner is only earning 30,000 rupees and therefore is not in a position to pay maintenance is noted only to be rejected. The petitioner, the learned counsel for the respondent, as submitted by the learned counsel for the respondent, if the wife has quit the job to take care of the child at the insistence of the husband, it is the duty of the husband to maintain the wife or the child as the wife and the child, and not wash off his hands from the responsibility of maintenance of the child. The payment of fees that the learned counsel for the petitioner has projected that the petitioner is paying would not mean that the husband would not pay maintenance for the child for living. Payment of fees is an altogether different responsibility apart from the husband paying maintenance to maintain the child and to the wife. If the wife is now not in employment, even otherwise, this is an order that has directed payment of interim maintenance, which will always be subject to further orders to be passed before the concerned court. Next paragraph. The learned counsel appearing for the respondent submits that as on today, no maintenance, even as directed by the concerned court, is paid by the husband except 30,000 rupees. According to the learned counsel, the arrears is 3,70,000. Is at 3,70,000. It is an added circumstance for the 3,70,000. On a pointed question to the learned counsel for the petitioner as to when the arrears should be cleared, the learned counsel for the petitioner submits that the petitioner is not in a position to clear the arrears nor pay maintenance. On all these factors, entertaining a petition of the petitioner husband who has defaulted in payment of maintenance and would also make submission that he would default maintenance payments of maintenance. Finding no merit in the petition stands rejected. Yes.
Please.
Madam, last confusion ಆಗಿದೆ ಕಳಿಸಿ ಮಾಡ್ತೀನಿ.
Senior held up in another court.
ಯಾವಾಗ ಫ್ರೇಮ್ ಆಗಿದೆ? ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದ್ರೆ ಆಗಲ್ಲ. ಮೇಡಮ್ ಅವ್ರಿಗೆ ಹೇಳಿ ಅವ್ರ ಹೆಸರು ಒಂದು ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಮೀನಾಕ್ಷಿ ಬಾಲ ಅಂತ ಬಡ್ಕೊಳ್ಳಿ. ವಿಜಯ KPR ಕೇಳಿ ಡಿಸ್ಪೋಸ್. ಎಸ್ ನೆಕ್ಸ್ಟ್.
In this case, my lord. Last occasion, your lordship directed to
Medical records, my lord, of the petitioner. On the last occasion, my lord, he was subjected to medical examination in Victoria.
Nimans,
Nimans
mental stability.
Please, my lord, a short accommodation, my lord. I'll
Why
place the
you have not
records.
taken? ಅವತ್ತು ಟೈಮೇ ಕೇಳಿದ್ರಿ. Anyway, we stopped the trial ಅಲ್ಲ?
Yes, my lord, there is an interim.
Learned HCGP.
Week's time, my lord.
A week's time to comply with the order passed by this court on 9/7/2024. List the matter on.
But so they are not provided any proper treatment. At least
20th.
let direct them to provide proper treatment.
That
my lord.
jail authorities ಕೇಳಿ. List on 20th in the fresh matters list.
Interim order may be extended.
Interim order subsisting shall continue till the next date of hearing.
Obliged. my lord.
Order there. Yes, sir.
Refreezing, my lord.
You have said
Yes, my lord.
you will place all the records, 388 cases registered
388
everywhere.
I'll place it, my lord.
ನೋಟ್ ಮಾಡ್ಕೊಳಲ್ವಾ?
Our additional SPP Asma madam appear ಆಗಿದ್ರು ಅವರು. I'll place it, my lord.
At the request of the learned madam, ಕೂತ್ಕೊಂಡೆ ಮಾಡಿ. Learned HCGP submits seeks week's time to comply with the order dated earlier order ಇದೆ ಅದು ಬರ್ಕೊಂಬಿಡಿ. Order dated so and so. List the matter on 20th. ಮೇಲೆ there is no representation on behalf of the petitioner ಅಂತ ಬರ್ದು ಇದು ಮಾಡಿ. Next.
For petitioners. The entire allegation is accused number 1, my lord. Allegation is that the accused number 1 has forged the signature of these petitioners and filed the wakalat in domestic violence case, my lord.
ನೀವ್ ಯಾರು? A5 and A6.
A5 and A6. Complainant is the wife of accused number 1, my lord. First wife of accused number 1.
First wife?
First wife of accused number 1. And accused number 4 is second wife of accused number 1. And I am we are parents of accused number 5 and 6.
First or second?
Second wife. Accused number.
Parents of second wife.
Second wife. We were dragged into domestic violence case. In that, the accused number 1 has forged the signature of petitioners and filed the wakalat.
Accused number 1 ಯಾರು?
Accused number 1 is husband of accused number 4.
First husband.
First husband.
Is it 2 wives and 2 husbands?
2 wives, 1 husband.
2 wives, 1 husband.
Complainant, accused number 1 is husband of complainant as well husband of accused number 4.
All right. ಈಗ ಇವ್ರ ಮೇಲೆ ಏನಿದೆ? Yes, government.
Please, my lord.
ನೋಡಿಲ್ವಾ?
I'll secure the investigation papers, my lord.
ಅದು last time ಹೇಳಿದ್ದೆ.
ಹಳಿದ್ ಹಾಕೊಳ್ಳಿ, I'll place it on record on Friday, my lord.
Then he will come up with one more by then. Yes.
On Friday, I'll place the investigation papers on record.
All 6 persons have hatched a conspiracy. ಯಾರು complaint ಇದು?
Complaint, my lord. Initially, complaint was not received, hence they preferred writ petition, my lord.
Oh.
GM police. At page number 23, the allegations are there. Para 3, my lord. The petitioner has initiated proceedings under Domestic Violence Act against her husband others in CMIS number 1915 of 2009 and CMIS number 1055 of 15. According to her signatures of accused, namely Kotraya, Ambuja, Naglingamma, Mahant Swami and Virendra have been forced by the petitioner's husband in the Wakalatnama filed before the court.
One minute. Petitioner's husband, who is that husband?
Accused number 1,
He's
Revana
not,
Siddeshwarayam.
he's not before the court.
No, only accused number 5 and 6, sir.
Notice agilva idu?
Agila.
I had accepted
Investigation
notice, my
papers.
lord, on the last occasion.
Ah.
I had accepted. I was
Oy,
directed to
ತುಂಬಾ
secure.
complicated case ಅಂತ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಇನ್ನು. ನಿಮ್ ಸಿಗ್ನೇಚರ್ ಫೋರ್ಜ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
Then ನಾವು ಇವ್ರನ್ನ ಅಕ್ಯೂಸ್ ಮಾಡ್ತೀವಿ.
No, and I'll just place the records
Yes.
day after tomorrow. my lord.
List on Friday in the fresh
My lord,
matters list.
I have secured the Wakalat, my lord, which they have said that is forged. A petitioner number signature is not forthcoming in that Wakalat.
ನಿಮ್ these
This petitioner number 2 Sokar signature.
No, I'll place the investigation. Let's give my.
Yes, list on Friday in the fresh matters list at the request of the learned HCGP who seeks time to place your investigation papers on record. List on so on. Yes, next.
Publish.
T group 83.
Memo na illa.
Memo
The
is there.
learned counsel appearing for the petitioner submits that during the pendency of the petition, police have the charge sheet is filed against against the petitioners. He would seek leave of the court to withdraw the petition, reserving liberty to raise a challenge to the charge sheet so filed during the pendency of the petition. Liberty so sought is granted. Petition stands disposed in the aforesaid terms. Yes, next.
Voting settlement.
Hmm. 2 weeks.
85. 85.
Petition in this case, my lords. There are three petitions between the same parties.
Settlement.
Settlement.
Offense.
Offense, one is DV case and two are 498A.
Kodi. What is at present?
Parties are present.
The petitioners in the cases at hand are the husband, his family members, and the complainant wife. Proceedings that are called in question are the setting the criminal law into motion for offences punishable under section 498A inter alia and the proceedings under the Protection of Women from Domestic Violence Act 2005. It transpires during the pendency of the petition, the parties to the list, i.e. the husband and the wife, have settled the dispute amongst themselves by drawing up certain terms of settlement, and in furtherance thereof have filed a joint affidavit of such settlement. What is the settlement? Separation.
Separation.
Of such settlement. The terms of settlement in the joint memo, which is supported by a joint affidavit, reads as follows. A condition in the condition in the affidavit so filed is quashment of a cooperation for quashment of the present proceedings. In the light of the settlement arrived at between the parties and the offences not being against the state or heinous, as they are the ones punishable under ONES once punishable under section 498A 504 inter alia, I deem it appropriate to accept the application seeking compounding hakilva, accept the affidavit, compound the offense and quash the proceedings against these petitioners. In that light, petitions are disposed, so and so criminal petition quashed.
So as per the conditions, 12 lakhs was supposed to pay.
Not paid.
Lakhs I have paid now, 10 lakhs has already been paid.
Now complete
Paying now.
amount is paid.
We have paid 2 lakhs just.
The learned counsel alli ಒಂದು quash anta barayak munche one sentence. The counsel for the petitioner and the respondent submit that the conditions of stipulated in the settlement are all fulfilled. Yes. Sorry. ಮೇಡಮ್ ಇದು ಎಕ್ಸ್ಟ್ರಾಕ್ಷನ್ ಹೇಳಿದ್ನ ಇಲ್ಲಲ್ಲ ಹೇಳಿದ್ದೀನಲ್ಲ.
Fresh matters, number one. Rohit,
And in
detail.
this case, madam, I am for petition, my lord, petition 1 and 2. My lord, the complaint, my lord, has filed PCR, my lord, the PCR referred case, interim, my lord, the investigation.
ಏನ್ ಬೇಕೀಗ?
My lord, interim order, my lord. In this case, your lordship has granted interim order regarding.
Connected matter in the same crime number, I think.
ಅದಕ್ಕೆ ಯಾಕೆ 230 ಮೂವ್ ಮಾಡಿದ್ರಿ?
My lord, the petition number 2 is my mother, my lord, they are the arising police.
All right, yes. Learned counsel for the
Sir.
petitioner submits that qua other accused in the same crime, this court has granted an interim order of stay in criminal petition.
My lord, court.
ಅದು ಅವರು ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್. In criminal petition so and so. In the light of the interim order subsisting qua other accused, the same interim order shall be granted, is granted to the petitioner as well.
Please.
Tag the petition along with so and so. Next.
Number two. Srinath, we.
Interim bail granted, last case.
Interim bail granted.
Interim bail granted, direction ಇಲ್ಲ ಅಂತ ರಿಲೀಸ್ ಮಾಡಿಲ್ಲ ಸುಮ್ಮನೆ ಲಾಸ್ಟ್
ಕೊಡಿ.
ಬೆಸ್ಟೆಡ್.
ಏನ್ ಡೈರೆಕ್ಷನ್ ಬೇಕು?
ಆ ಜೈಲ್ ಅಥಾರಿಟಿಗೆ ಸೂಪರ್ಡೆಂಟ್ ಜೈಲ್ ಸೂಪರ್ಡೆಂಟ್ ಡೈರೆಕ್ಷನ್ ಸ್ಪೀಕ್ ಆರ್ಡರ್
ಅದಕ್ಕೆ ಮದುವೆ ಆಗಕ್ಕ?
ಮದುವೆ ಆಗಕ್ಕೆ ಡೈರೆಕ್ಷನ್ 15 days ಇಂಟ್ರಿಮ್ ಬೇಲ್ ಕೇಳಿ ಅಷ್ಟೇ
ಕೊಡಿ.
ಸೆಂಟ್ರಲ್ ಜೈಲಲ್ಲಿ ಪರಪ್ನಗರ್.
This court on 24/7/2024 had passed the following order. The counsel for the petitioner has moved the matter on the score that a direction to the jail authorities to release the petitioner in terms of the interim bail so granted. ಯಾಕೆ ಹೇಳಿಲ್ಲ? ಇಲ್ಲೇ ಇದೆಯಲ್ಲ
ನಮ್ಗೆ
petitioner
specific
shall be
order
released
ಇಲ್ಲ.
ಅಂತ.
ಜೈಲ್ಗೆ ಸ್ಪೆಸಿಫಿಕ್ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂತ ಇದೆ.
ಏನ್ ಸ್ಪೆಸಿಫಿಕ್ ರಿಲೀಸ್ಡ್ ಅಂತ ಏನರ್ಥ?
ಜೈಲ್ ಸೂಪರ್ಡೆಂಟ್ ಗೆ ನಮ್ಗೆ ಇಲ್ಲಿ ಮೆನ್ಷನ್ ಇಲ್ಲ ಅಂತ.
Yes,
ಸೆಂಟ್ರಲ್
what
ಜೈಲ್
is-
ಮೆನ್ಷನ್ ಇಲ್ಲ.
The orders may not, the trial court releases them. The particular format has to be followed to release them. Probably there are that.
ನಮಗೂ ಅದೇ ಮಾಡ್ತಾರೆ.
Allah, please.
Who is that man who is asking? I have said petitioner shall be released on grant of interim bail. What does that matter?
So then,
Anyway, let him not be put to prejudice. Yes. ಬೇರೆದ್ರಲ್ಲಿ ನೋಡಿ ಮಾರಿ. Yes. The, sorry madam, ಏನ್ ಹೇಳಿದೆ ಕೊನೆಗೆ? So granted. The jail authorities are hereby directed to release the petitioner from 29th ಅಂದ್ರೆ ಇವತ್ತ? ನಿನ್ನೆ.
ನಿನ್ನೆ
From ನಾಳೆಯಿಂದ ತಗೊಳ್ಳಿ ಹಂಗಾರೆ.
ಪ್ಲೀಸ್ ನಾಳೆ.
Release the petitioner from the 1st of August 2024 up to 19th of August 2024. The registry is directed to communicate this order to the jail authorities without brooking any forthwith ಅಂತ forthwith. Yes.
Number three, Rajshekar.
Please, my lord. My lord, may kindly come to page number 14. One Nageshwari, my lord, she files a complaint against Janata Cooperative Bank and also the officials stating that her mother passed away in 2020. ಅವ್ರದ್ದು ಫಿಕ್ಸೆಡ್ ಡೆಪಾಸಿಟ್ ಎಲ್ಲ ಇದ್ದಿದ್ದು ರಿಲೀಸ್ ಮಾಡಿಲ್ಲ. And the bank authorities, my lords, it is alleged in the complaint that they have forged the signatures and ಯಾರಿಗೋ loan sanction ಮಾಡಿದ್ದಾರೆ ಅಂತ. And the loan sanction is one Praveen. I have nothing to do with this transaction.
Who are you?
My lords, I'm a businessman. I have nothing to do with any of this, my lords, the allegations.
You are the sole accused.
No, accused, I'm not an accused as such, my lords.
Then you have described yourself to be an accused. So become one.
My lord,
ನೀವೇ ಹೇಳಿದ್ದೀರಾ accused ಅಂತ. What's your name? Shiv Kumar. ನಿಮ್ಮ ಮೇಲೆ ಏನ್ ಹೇಳಿದ್ದಾರೆ?
I should have stated as a response. My lords, ನಮ್ಮ ಮೇಲೆ ಹೇಳಿರೋದು ಕೈಂಡ್ ಪೇಜ್ ನಂಬರ್ 20 ನಲ್ಲಿ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಈ ಮೂಲಕ ನಿಮಗೆ ತಿಳಿಪಡಿಸುವುದೆಂದ್ರೆ ಫಿರ್ಯಾದಿದಾರ ನಾಗೇಶ್ವರ ತಮ್ಮ ಠಾಣೆಗೆ ಹಾಜರಾಗಿ ಜನತಾ ಸೇವಾ ಕೋಆಪರೇಟಿವ್ ಬ್ಯಾಂಕ್ ನಲ್ಲಿ 2019-20 ಸಾಲಿನಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್, ಅಧ್ಯಕ್ಷರು ಹಾಗೂ ಅಂದಿನ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರ ವಿರುದ್ಧ ದೂರಿನ ಮೇರೆಗೆ ವಿಜಯನಗರ ಪೊಲೀಸ್ ಠಾಣೆ ಮೊಕದ್ದಮೆ ಸಂಖ್ಯೆ 156 of 2023
ಸೆಕ್ಷನ್ 420, 468, 417 ಸಹಿತ 34 IPC ರೀತಿಯ ಪ್ರಕರಣ ದಾಖಲಾಗಿ ತನಿಖೆಯಲ್ಲಿರುತ್ತದೆ. ಈ ಪ್ರಕರಣ ತನಿಖಾ ಸಮಯದಲ್ಲಿ ಸಂಗ್ರಹಿಸಿದ ಸಾಕ್ಷ್ಯಾಧಾರಗಳ ಆಧಾರದ ಮೇಲೆ ಪ್ರಕರಣಕ್ಕೆ
ಈಗೇನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
ಪ್ಲೀಸ್ ಮಲಟ್.
ಈಗೇನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ನಿಮಗೆ?
ಇವ್ರು ನಮ್ಮನ್ನ ಕರ್ಕೊಂಡೋಗಿ they we want to interrogate and Mellards within 48 hours ಬರಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. And Mellards in front of my house, Mellards
ಪೊಲೀಸ್ ವ್ಯಾನ್ ನಿಲ್ಸಿದ್ದಾರೆ.
And they are not even giving me a breathing time. And Mellards, I'm a businessman. And they say you produce, ನಿಮ್ಮ ಹತ್ರ ಯಾರೋ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಂತಾರೆ.
ಬ್ರೀದಿಂಗ್ ಟೈಮ್ ಕೊಡಿ. ಕೋಆಪರೇಟ್ ವಿತ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
Please Mellards. Please.
Don't take any coercive steps. The petitioner shall cooperate with the investigation, and in the garb of investigation, the respondent police are restrained from taking any coercive steps against the petitioner till the next date of hearing. List on 22nd. One HCGP, 2 emergent notice. First. Next.
Number 4.
Special situation. Kindly, my lord, have page number 120.
What special situation?
I'll, my lord, say, in fact, my lord, it's a special situation. My lord, under section 319, my lord, 5 accused persons who were dropped from the array of the charge sheet were, my lord, assumed for trial. My lord, kindly have, my lord, say, page number 120, the order of his lordship Justice V.V. Patil. My lord, made these observations. My lord, 4th line on page number 120. Page 120, my lord, 120. 4th line, my lord.
One
120, my lord.
Sessions court order.
Yes. During 4th line, my lord, during the investigation, the accused 6 who was not named in the FIR was planted in the case by the investigation officer, and at the instance of the proposed accused number 1, who was the MLA of so and so. However, the investigation officer did not conduct an investigation about the complexity of the proposed accused 1 to 5, simply filed charge sheet against the accused number 6, who did not participate in the commission of crime. Investigation officer washed his hands. PW 1 to 4 who were examined before the Sessions Court Bhadravati, who categorically deposed before the court about the complicity of the proposed accused 1 to 5, including their overtax. On examination of evidence of PW 1 to 4 coupled with the documents annexed to the charge sheet, at this stage clearly suggests the complexity of the proposed accused 1 to 5 in the case. From the inception of lodging the complaint before the police, the name of proposed accused number 1 to 5 found in the records of the prosecution alleging the overtax of the proposed accused number 1 to 5. There is much stronger evidence available on the record against the proposed accused 1 to 5 about their complexity of the case. The evidence of PW 1 to 4, if unrebutted.
You are the special counsel.
I am the special prosecutor. No matter what happens, all the witnesses were examined. 3 investigation officers, 3 CW 35, 36 and 37 were summoned before the court. My lord, they are the investigation officers who have filed a charge sheet saying that all these 1 to 5, my lord, are innocents. They were dropped. I initially made an application to the court. Now, since they have given a clean sheet to the accused who have been assumed by the court under 319, I may not be able to cross-examine them by considering them hostile. Therefore, consider them as court witnesses by exercising power under section 165 of the Evidence Act. That application was dismissed. Later on, when they came before the court, I, my lord, relied upon a recent judgment of our Honorable High Court and said, please allow me to put questions to my own witnesses, because I have to question this very investigation officer, because this is what is observed under the 319 order. If, my lord, I simply don't question him, the charge sheet stands. In the charge sheet, my lord, these accused persons who have been assumed by the court under 319, my lord, have already been given a clean sheet. I get nothing from these IVOs. Kindly, my lord, see, may I just take your lordships to page number 6, my lord. The breadth of, my lord, section 154 of the Evidence Act was, my lord, culled out. It's a reported judgment. My lord, on page number 6, the last paragraph, paragraph 5, having heard the learned counsel for the parties and having perused the petition papers, no reprieve can be granted to the petitioner, because in India, the law relating to hostile witnesses is broadly delineated by statutory provisions as interpreted by several high courts. Section 154 of the Indian Evidence Act provides for putting of questions by a party to his own witness. The section reads as under. This provision allows a party to proceeding, civil or criminal, to put questions to his own witnesses in the same way as the adverse party would do in cross-examination, of course, with the permission of the court, such a witness can be asked leading questions, questions relating to the previous statements in writing, and questions which tend to test his veracity to discover who he is and what he is standing in life insofar as to impeach his credit. However, under English law of evidence, a party is not permitted to impeach the credit of his own witnesses by a general evidence of his bad character or shadow antecedents, such as previous conviction or like. In India, this can be done with the permission of the court under section 155 of the Act, which reads as under, my lord, I skip the extraction. Then, my lord, on page number 8, as already mentioned above, section 154 permits the party to put questions to his own witnesses, and these questions might be those that can be put in cross-examination by the adverse party.
Witnesses have turned hostile?
My witnesses have not turned hostile, but my lord, today I am not prosecuting the case, my lord, in terms of the charge sheet. In the charge sheet, my lord, the charge sheet is filed giving a clean sheet. Court passed an order under 319, my lord, which is away from the charge sheet. Court felt that the investigation officers have, my lord, done, my lord, a great disastrous investigation. Therefore, these accused have to. Now, my lord, if I have to examine these 3 investigation officers, if I go by, my lord, the charge sheet, I cannot consider them hostile witnesses, because they'll be, if I take those depositions and I do not question them, my lord, the tragedy would be that I will have to, my lord, stick to charge sheet, my lord, which will not serve the purpose of 319 at all. Therefore, I initially requested, please treat them as court witness under 165 of Indian Evidence Act, so that I can cross-examine them. Next, my lord, that was rejected. Second opportunity, what I asked was 154 and 155 clearly, my lord, gives me a right that without even considering them hostile, I can put any questions to them. My lord, this is a right, my lord, as has been held by our High Court. My lord, this is what is judgment. My lord, I'll just read, my lord, only one last paragraph, my lord. Kindly bear with me, my lord, on paragraph, page number 8. As already mentioned above, section 154 permits a party to put questions to his own witnesses, and these questions might be those that can be put in cross-examination by the adverse party. However, it does not necessarily tantamount to cross-examining the witness. Stricto sensu, cross-examination means the cross-examination which the adverse party, as distinct from the party calling the witness, does. Therefore, neither party calling him nor the adverse party is in law precluded from relying on any part of the statement of such witness. Vide Prafula Kumar Sarkar. My lord, Prafula Kumar Sarkar is extracted. Then, my lord, all that I asked is 2 opportunities. The judgment of the Honorable Supreme Court, my lord.
Extracted.
Extracted. Now, my lord, I asked this. Either allow me to treat them as hostile. Then the judge would say, no, you can't treat them as hostile as long as they are deposing in terms of the charge sheet.
They are charge sheet witnesses.
Yes.
They are investigating officers.
They are not charge sheet witnesses. They are the investigation officers.
They are investigating officers.
Yes. 3 of them.
3 of them.
Yes.
You are examining them or cross-examining them?
In fact, my lord,
you are examining them.
Yes.
So you are examining them. Your examination should be in the parameters of examination, which should not transgress into cross-examination, unless you treat them as hostile.
Hostile. My lord, I asked, let me treat them hostile. The court says, no, you can't treat them hostile. My lord, if I don't treat them hostile, my lord, how do I cater to the needs of 319 case? Kindly see, my lord.
Yeah, now these 3 are brought in under 319?
Yes, all the 5 accused persons.
These were dropped under 319 while filing the charge sheet?
Yes.
Where is the order bringing them under 319?
This is what, my lord, page number 108. If your lordships would kindly have, my lord, page number 108, the order starts. And, my lord, the relevant portion, my lord, I read at page number 120. 120. And, my lord, this order has reached finality. They did not challenge it. Now, my lord, there is a situation. I am
accused 1 to 5.
There are allegations against this very investigation officers that they did a shoddy investigation. Now, my lord, if I don't question these investigation officers, I will not be, my lord, doing justice to the 319 case.
Now, they are brought in as accused.
Yes.
Under 319.
Yes.
Yes. What do you want?
Now, my lord, kindly see, my lord, tomorrow, if your lordships would kindly have page number 246. Once again, my lord, they have been called before the court. Date of trial is fixed. Tomorrow, my lord, I will have to examine them. and they'll not be hostile witnesses. I can't, my lord, question them. Tomorrow and day after, proceedings have to be stayed, my lord, till this matter is decided.
Heard the learned senior counsel, MS Shyam Sundar.
My lord, special prosecutor, my lord, in this case, I am special
sorry,
prosecutor.
please. Heard the learned.
In fact, my lord, I have filed my personal, my lord, memo of appearance in this matter.
ನಿಮ್ಮ ಹೆಸರಲ್ಲೇ ಇದೆ?
How's because, my lord, I am holding
Yes.
it. 301 permits me to do this.
Heard the special prosecutor, MS Shyam Sundar, appearing for the petitioner. The issue in the list is with regard to cross-examination of the examination of witness of accused, or what accused they are?
They are accused number 1 to 5, my lord, now 1 to 5. Accused, my lord, of offense.
Amongst to proposed accused, accused number 1 to 5. Accused number 1 to 5 were dropped from the array of accused while filing the charge sheet. An application comes to be preferred during the trial under section 319 of the CRPC, which comes to be allowed, and the accused 1 to 5 are back into the web of crime, web of proceedings, as there was abundant material to try them. They are brought in as accused 1 to 5. The petitioner now wants to put leading questions, which is in the nature of cross-examination, to these accused 1 to 5.
No, my lord, not 1 to 5. Investigation officers, my lord. CW 35, 36 and 37.
CW 35.
35, 36 and 37, who are the investigation officers?
Then it becomes difficult.
No, my lord, that is the only way, my lord. Kindly see, my lord, page number 120, my lord, for a moment. 120, my lord, I'll read only 4 lines. What happens, my lord? Investigation officers were, my lord, in fact, the investigation, the observation against the investigation officers were, my lord, 6.
Now, the investigating officer, 3 investigating officers had dropped these accused.
Yes.
Now they are brought back under 319.
Under 319.
All right, under
Yes.
319.
Yes.
So according to you, those investigating officers who had dropped these persons had conducted a shoddy investigation.
Yes.
Now we want to examine them. You can examine them, but they are investigating officers.
No, my lord, what would do is kindly, my lord, appreciate this, my lord, a catch situation, my lord. If I examine them.
22 or 44?
21, 22, my lord.
Yes.
What would happen, my lord, if I examine? That is the reason, my lord, I said it's, my lord, an unusual situation. If I, my lord, examine them, I have to examine them in terms of the charge sheet which is filed by them. No, my lord, if I examine them in terms of the charge sheet, my lord, they are not resiling from the charge sheet. No, my lord, I can't treat them as, my lord, hostile witnesses. Then, my lord, I will not be doing any justice to 319 case. Kindly, my lord, see page number 150, my
If
lord.
this is permitted without treating anybody as hostile, to cross-examine them at length, putting any question, it will be turning the procedure.
Then, my lord, I should be at least allowed to treat them as hostile. Then the learned judge, my lord, would say first, no, you will not be able, you will not be allowed to treat them also as hostile.
One-off situation ಅಂತ ಬರೆದ್ಬಿಡೋದು, ಆಮೇಲೆ that becomes
ಇಲ್ಲ ಅದಕ್ಕೆ at least, my lord, allow me to.
Sir, a witness can be treated hostile and cross-examined.
Yes.
That nobody need tell
Yes.
anything. Now they are your investigating officers. You examine them. You can't cross-examine.
No, my lord, what would happen is if I examine them, my lord.
Examine them, sir.
No, my lord, if I examine them, my lord, the extent of chief examination, my lord, I cannot put leading questions in the chief examination. He will simply depose.
Now the cat is out of the bag. You want to put leading questions. It is not clarification.
No, my lord, I don't even want to put leading questions. I want to put questions,
that's
my
what
lord,
you
which are
said
allowed
now.
under cross-examination. My lord, only one, kindly, my lord, kindly, my lord, allow me to, my lord, show your lordship's page number 120, my lord. Page number 120 for a moment.
What I thought was the accused who have been
No, I don't want to cross-examine.
No, sir, this I will not permit.
Alla, onde one nimsham, my lord. I'll try to impress upon your lordship.
Yes.
My lordship, kindly appreciate my situation.
Yes, sir.
If your lordship could kindly have page number 120, my lord. I'll, my lord, read it at the cost of repetition. Page number 120, my lord, after 4th line. During the investigation, accused 6, who was not named in the FIR, was planted in the case by the investigation officer at the instance of the proposed accused number 1, who was the MLA of Zones. However, the investigation officer did not conduct any investigation about the complicity of the proposed accused number 1 to 5 simply filed a charge sheet against accused number 6, who did not participate in the commission of crime. Investigation officer washed off his hands.
Initiate proceedings against the investigating officer.
No, my lord, now what would happen is accused number 6, who was added, he has already been discharged. He has been discharged. Now the lone accused persons who are standing trial are, my lord, the accused persons
1 to 5.
1 to 5 who have been assumed as accused persons by an order of the court.
Correct.
By an order of the court. My lord,
Right.
court assumes them as accused not on the basis of the charge sheet material, on the basis of, my lord,
Sir.
deposition.
No. See, they have been brought back as accused because the evidence that was there was more than prima facie necessary for them to be accused at the charge sheet level. So they're brought back.
No, my lord,
problem.
kindly, my lord, allow me to, my lord, just
Alright.
read it.
Sir,
Allow me to, my lord,
Purport
just
of
read it.
319 is that only.
Kindly, my lord, allow me to just.
At the
my lord.
time of deposition, if there is something, some
Yes,
some
precisely,
evidence,
my lord,
that is what, sir, at the time of deposition of witnesses, if there is something found which is more than what was what was found at the time of investigation, they are brought back under 319.
Yes,
They
my
are
lord.
brought back.
Now, my lord, now.
That doesn't mean,
Kindly
see,
appreciate.
if the investigating officer has conducted a shoddy investigation, he will face the music. That's a different thing. That doesn't mean the procedure should be permitted to be turned topsy-turvy only for the reason that you want to cross-examine them.
No, my lord,
sir.
kindly, my lord, appreciate my situation, my lord. If I, as prosecutor, examine them, my lord, they are the investigation officers. What they would say, my lord, they would only say in terms of the investigation papers where they have already given clean chit.
Correct.
Clean chit. Now, my lord, what would happen if I do not question
You
them?
can't turn them hostile, declare them hostile because they are investigating officers.
They are declaring their, my lord.
You can't declare
Yes,
them. They are
yes, yes.
you examine them in any way.
Yes. Now, my lords, kindly, my lords, my lord, allow me to, my lord, just read from this judgment, my lord. His Lordship Justice Krishna.
Yes, sir.
My lord, page number 8. My lord, at the cost of repetition, my lord. Page number 8, my lord. As already mentioned above, 154 permits a party to put questions to his own witnesses, and these questions might be those that can be put in the cross-examination by the adverse party. However, it does not necessarily tantamount to cross-examining the witness. Stricto sensu, cross-examination means the cross-examination which the adverse party, as distinct from calling a witness under section 137, does. Therefore, neither the party calling him nor the adverse party is in law precluded from relying on any part of the statement of such a witness. Vide Prafulla Kumar. Then, my lord, page number 9. The terms hostile, adverse, unfavorable, or unwilling witnesses are employed in the Indian Evidence Act by the draftsman in view of conflicting judicial opinions in England as to the true meaning of these words. It is a settled principle of law that ordinarily a party calling his witness is not allowed to cross-examine him if such party is an adversary in the proceedings. However, 154 and 155 are in the nature of an exception to this general rule. These sections are founded on the wisdom gained from long experience of the learned. These sections provide for relaxation of the general rule so that the cross-examination of hostile witnesses' truth is extracted. It is now well settled that the scope of section 154 is not limited to putting leading questions, but extends to whole range of cross-examination. A party will not be normally allowed to put leading questions to his own witnesses save by the permission granted by the court in its discretion. It is true that the discretion means, according to the rules of reason and justice, the exercise of discretion depends upon the facts and circumstances of each case. Before a court declares a witness hostile and grants permission to party to cross-examine his own witness, there must be some material to show that the witness has gone back from his earlier statement unjustifiably, or is not speaking truth deliberately, or has exhibited an element of hostility, or has changed its sides prima facie. My lord, this is what is observed.
Nothing exists here, sir.
No, my lord, this is what is observed on page number 120. 120, my lord, the order of my lord 319 clearly says, however, the investigation officer did not conduct any investigation about the complicity of the proposed accused number 1 to 5, simply filed charge sheet against
If this is permitted as simple as that.
No, my lord, not, my lord, simply, my lord. My lord, this matter requires consideration. My lord, may kindly appreciate my situation, my lord. If I don't cross-examine these investigation officers, who, my lord, according to the observations made by the court on an earlier occasions, have conducted a shoddy investigation just in order to, my lord, aid accused number 1 to 5 escape.
Sir,
My lord, if I don't question them.
Against these people who are prima facie observed to have conducted shoddy investigation, at the final order, any order may be passed by the court,
But my lord,
directing departmental inquiry
my lord, the
or
accused-
prosecution against.
Accused will escape. Accused will permanently escape, my lord. This is what is observed. Kindly see, my lord. The court says it is in order to aid the accused persons, my lord. These investigation officers, my lord, did plant another accused person who was nowhere concerned.
We'll see, yes.
And therefore, my lord, what would happen is,
Allah, respondents here.
respondents,
And who is to answer?
they have to answer, my
The investigating officers.
not the investigation
Then-
officers, my lord. The pro forma respondents are, my lord, the accused persons, and the sixth respondent, my lord, is the complainant.
Then we will have to ask now Jagdish to appear,
ಇದ್ರಲ್ಲಿ ಆಗ್ಬೋದು.
only to assist the court.
Yes, my lord. This matter
Because
requires.
you can't come this side and argue that.
Illa.
Yes.
This matter, my lord, requires consideration for this, my lord, special situation. Now, my lord, I have to do justice to my lord 319 case. 319 case is what
Sir.
court felt.
You have to do justice to 319, que accused 1 to 5. Cross-examine them however you want.
No, my lord, my lord, if I don't cross-examine the investigation
No, no,
officers, my lord.
You can examine the investigating officer.
Investigation, my lord, accused persons, I can't
Cross-examination
examine. my
of
lord.
the investigating officer will be by the accused.
ಅಲ್ಲಲ್ಲ ಅದಕ್ಕೆ my lord, that is 154 and 155 says, my lords, may I just take your lordships to my lord Evidence Act for a moment? my lord?
Yes, sir.
154 in its clear, my lord, simple language.
It is quoted here, sir, in Justice Dikshit
My
order.
lord, nowhere it says hostile. Nowhere it says, it only says questions that may be put to my own witnesses. Now, my lord, I may have to examine these my lord,
Questions that
investigation
would be put
officers.
to your witnesses is
Yes.
the nature of examination in chief.
Yes,
It's all right?
yes.
In the examination in chief, your asking of questions cannot be in the nature of cross-examination unless you turn your own witness hostile.
Yes, well, that is what is settled law, my lord. I understand. My lord, that is what is settled law. But this judgment, my lord, is an exception where the honorable
This
court says.
unsettles the settled law?
No, it
Then-
does not unsettle, my
then,
lord.
sir-
It in fact develops it, my lord, to a next level.
Oh,
My lord, in fact,
Sir, if I permit this, then it will be turning.
Allah, but this
procedure
requires
topsy-turvy.
consideration, my lord. What would happen is, now, my lord, if I don't cross-examine them, their investigation as they have done, dropping 1 to 5, my lord, stands. There is nothing more I can develop as a special
They
prosecutor.
are brought back into the web of crime. Cross-examine them and nail them.
No, my lord, I cannot.
Why do you want
unless
to
and until
support?
they-
Why do you want to support the investigating officer? They're
Well,
back as accused.
But my lord, as special prosecutor, unless they step into, my lord, the defense evidence box, I can't even, my lord, call them. How can I, my lord, request? How can I summon the accused persons, my lord, as special prosecutor? I am catering the need of the state. And, my lord, I am more particularly, my lord, working in terms of, my lord, doing justice, my lord, as for 319 order. 319 order clearly says these are the investigation officers who did investigation, but to aid the actual accused persons. So, my lord, if I don't question them as to the way in which they investigated, have they investigated it properly, etc.
Because he's on this side, you'll have to assist the court. One copy could you?
ಕೊಡ್ತೀವಿ. ನಾಳೆ ನಾಡಿದ್ದಿರೋದ್ರಿಂದ it should be, my lord, urgent till, my lord, this matter is decided.
The learned additional SPP is directed to assist the court as an amicus, as the special prosecutor is the petitioner in the case at hand. The counsel on record shall serve. ನೀವೇ ತಾನೆ?
ನಾನೇ
The petitioner shall serve the set of papers upon counsel Sri B.N. Jagdish. ನಾಳೆ ತಗೊಳ್ಳ?
ನಾಳೆ ನಾಡಿದ್ದಿರೋದ್ರಿಂದ, my lords, there may be an interim order, my lord, to stay the proceedings till then.
No, 1 minute. The learned, in the light of the question meriting an answer, the concerned court shall defer its proceedings for 2 days, for 1 week. List the matter tomorrow at 4 p.m.
Yes. This order may kindly be
ಆಗತ್ತಾ madam?
uploaded, my lord, so that we can give.
Recommend. Tomorrow ಆಗತ್ತಾ? 4 p.m. ಆಗತ್ತಾ? ಇಲ್ಲ ನಾಡಿದ್ದು ಹಾಕ್ಬಿಡ್ಲಿ. ಪರವಾಗಿಲ್ಲ, ಅದೇನು ಮುಗಿದೋಗುತ್ತೆ ಜಲ್ದಿ. We'll have it on the 1st at 4 p.m.
Mr.
First
T.H.
at 4
Hanmantraya also would come, he would also, my lord, aid the case. He is,
Why?
my lord, appearing for the accused persons.
He will also aid the case.
Allah, he will also aid the court, my lord, because he objected this very application, my lord. He is appearing for the accused.
319 application is objected.
Allah, application. I filed an application, my lord, seeking special permission, my lord, specifically permission to cross-examine them under section 154.
Yes. I have my own doubts. Let's see. Yes, Jagdish.
Today's
go
order
through the
may kindly
papers
be
and-
uploaded so
That
that
will be
we
done,
can
sir.
request the court below.
Oh, ನೀವೇ ಹೇಳ್ಬೇಕು ಕೋರ್ಟ್ಗೆ.
ನಾ ಹೇಳ್ತೀನಿ, but my lord,
ಆಗತ್ತೆ.
court would require something, my lord. So great.
First at 4 PM. 4 PM ಏನ್ ಹೇಳಿದ್? Yes.
Bill number 5.
Transfer to Dharwad.
Transferred. The counsel for the petitioner submits that the petition is wrongly filed before this court. Therefore, the petition is at liberty to file the same before the Dharwad bench. For statistical purposes, the petition stands
Certified copies
disposed.
may be ordered to be returned.
ಅಲ್ಲೇ ಹಾಕಿ.
ಆಯ್ತು.
Yes. For statistical purposes, petition stands disposed. ಇನ್ನೇನಿಲ್ಲ. ಆಯ್ತು ತಗೊಳ್ಳಿ. ಎಲ್ಲಿ? ದೃಶ್ಯಂ. ಪ್ರಸನ್ನ ಕುಮಾರ್ ಅವರಿಲ್ವಾ?
Number 96.
But it appears, there's one more petition may not filed by the co-accused in this very matter. Which is,
ಪರವಾಗಿಲ್ಲ, ನಿಮ್ದು ಹೇಳ್ಬಿಡಿ. ಮೇಡಮ್ ಯಾವ್ದಾರು ಬಾಕಿ ಇದೆ? ಯಾವ್ದು ಇಲ್ಲ ಅಲ್ಲ? ಹೋದ್ರಿ ಅಷ್ಟೇ. ಆಯ್ತು. ಇವ್ರು ಇರ್ಬೇಕಾ ಕಳಿಸ್ಬೇಕಾ ಅಂತ ಹೇಳಿ. This will take some time. For the hearing date ಕೊಟ್ಕೊಂಡು.
Notice ಕೊಡಿ.
Why is Rahul waiting?
88
90?
and 89.
ಏನದು?
Regular matters.
Oh, further hearing matters. We'll have it on Friday. All the further hearing matters will be repeated on Friday. Interim orders idre they'll be extended. Prasanna Kumar P. ಅದ್ರಲ್ಲೂ ಯಾವ್ದು Prasanna Kumar? 95.
Adeno ado, for the first time, may not, I think my matter is connected with that.
ಆಯ್ತು. Friday.
In 95.1,
ಇರೋದು
NT, my lord.
ಎಲ್ಲ ಒಬ್ರು ಹೇಳ್ಬೇಕಾದ್ರೆ ಸುಮ್ಮನೆ ಇರಿ. ಬೇಡ, ಫ್ರೈಡೆ ಹಾಕಿರ್ತೀನಿ. ಮತ್ ಮಂಡೇ ಮೈ ವರ್ಕ್ ವಿಲ್ ಗೆಟ್. ಪರವಾಗಿಲ್ಲ, ನಿಮ್ದು ಬೇಕಾದ್ರೆ ಆಮೇಲೆ ಸಪರೇಟ್ ಆಗಿ ಅಡ್ಜಸ್ಟ್ ಮಾಡೋಣ. ಹೈದರಾಬಾದ್ ಅಲ್ಲೇ ಇರಿ, ತೊಂದ್ರೆ ನೋ ಪ್ರಾಬ್ಲಮ್. ಫ್ರೈಡೆ ಹಾಕಿರ್ತೀನಿ. ವಿ ವಿಲ್ ಅಡ್ಜರ್ನ್ ಇಟ್ ಟು ಅ ಡಿಫರೆಂಟ್ ಡೇಟ್ ಆನ್ ದಟ್ ಡೇ. ಇಲ್ದರೆ ಒಂದೊಂದೇನೆ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಮಾಡ್ತೀನಿ ಅವತ್ತು ಅಂತ ಹೇಳ್ತೀನಿ ಶಂಕರಪ್ಪನವ್ರೆ. ನಾನು ಯಾರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಲ್ಲ, ಅವತ್ತು ಅಡ್ಜನೆ ಮಾಡ್ತೀನಿ. All further hearing matters on Friday.
My lord, may I submit, my lord? My lord,
Wherever interim orders are there, they'll get.
my lord, in 95.1, my lord, they have made a company as a party, my lord. The company is under insolvency proceedings, my lord. Insulated.
Friday ಹಾಕಿದೆ ಅಂತ ಅವತ್ತು ಹೇಳಿ.
86.
ಯಾವುದು ಸರ್? Fast over matter. Wait.
86 dictation ಇದೆ. Allowed 86 dictation ಇದೆ anytime.
Friday.
Yes, 95. But that one.
Friday, sir.
Correct. One other matter was clubbed along with it. Let them serve the copy on us so that we can ask the bank to appear in that matter.
Well, Friday we'll see. Yes.
Well, 92 and 93 reporting settlement. Parties are Friday. Last time also.
Where were you?
Not reached my last time.
ಅವಾಗಲೇ ಕರೆದಾಗ ಎಲ್ಲಿ where were you? ಆಯ್ತು, ಆಮೇಲೆ ನೋಡ. ಕರ್ದ್ ಬಿಡಿ. ಏನ್ 498 ಏನಾ? ಪೋಕ್ಸೋನಾ?
Married ಆಗಿದೆ.
ತೊಂದ್ರೆ ಇಲ್ಲ. ಪೋಕ್ಸೋ ಆದ್ರೆ ಬರ್ಲಿ. What age of the victim?
Now, at the time of incident, she was 17 years, 6 months, 17 years.
ಅದೆಲ್ಲ ಹೇಳಿದ್ನಲ್ಲ. When do we take on?
Marriage ಆಗಿದೆ. So both the parties are present, my lord.
So what, sir? Wait. Special bench matter. First ತಗೊಂತೀನಿ. First on Thursday. Jagdish, ಮಧ್ಯಾಹ್ನ 2:30 will close all the settlement POCSO matters only. and then get into fresh matter. Yes. Thursday. ಯಾವ ಊರು ಸರ್? ಹಾ, ಆಂಧ್ರ ಪ್ರದೇಶ್ ಹೇಳ್ದಂಗೆ ಹೇಳ್ತಾ ಇದ್ದಿಲ್ಲ, ಆನೇಕಲ್ನ. ಇಲ್ಲೇ ಬರಕ್ ಹೇಳಿ. ಎಸ್, ಈಗಲ್ಲ, ಥರ್ಸ್ಡೇ ಬರಕ್ ಹೇಳಿ. ಆಯ್ತು, ಕೊಡಿ ನಂಬರ್, ಕೊಡಿ ಯಾವ್ದಾರು.
ಅಲ್ಲ ಇದೆ ನಾನು whatever I am ಅಂತ ಹೇಳಿದ್ದೀನಿ, that's what he is saying.
ಅದ 96 ಸರ್ ಇದು. ನೀವು ಮುಗಿಸಿ ಸರ್.
Please.
ಒನ್ ಮೋರ್ ಅಕ್ಯೂಸ್ಡ್ ಬೇರೆ. ನಾವು ಯು ಟು ಇಟ್. ಬೇರೆ ಯಾವ್ದಿಲ್ವಾ? ಫಾಸ್ಟ್ ಓವರ್ ಎಷ್ಟಿದೆ ಮೇಡಮ್? ಫಾಸ್ಟ್ ಓವರ್ ಏನು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಇವತ್ತಿಗೆ? ಫಸ್ಟಿಗೆ ಹಾಕೋಣ ಇದನ್ನ. ಫಸ್ಟ್ಗೆ ಆಗಲ್ಲ, ಕೊಡಿ. ಒಂದ್ ಮಿನಿಟ್, ಫಾಸ್ಟ್ ಓವರ್ ಕರ್ದ್ಬಿಡಿ ಮೇಡಮ್. ಟ್ರಾನ್ಸ್ಫರ್ ಒಂದು ನಿಮಿಷ, ವೆಯ್ಟ್. ಫಾಸ್ಟ್ ಓವರ್ ಕರ್ದ್ಬಿಡಿ. ಅದು ಗೊತ್ತು. ವಾಟ್ ಈಸ್ ಯರ್ ಗ್ರೌಂಡ್ ಸರ್? ಏನಿಲ್ವಾ? ಹಾ,
4 ಸ್ಟಾಂಪ್ ಪೇಪರ್ ನಲ್ಲಿ take the signature by purchasing the
petitioner shall serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement in the next 2 days. List the matter on Tuesday next in the fresh matters list. Till such time further proceedings before the concerned court shall remain stayed. Please. Yes, in next carry the password.
Second list 38.
38.
for petitioner.
ಏನು urgency sir?
Sir, it is under, we are challenging the 138 proceedings under the trial court, my lords. Idರಲ್ಲಿ we are not at all concerned with the party who has filed the complaint before the mayoral court, sir. The check value.
Same order ಮಾಡಿ ಮೇಡಮ್. ಈಗ ಪ್ರೀವಿಯಸ್ ಹೇಳಿದ್ನಲ್ಲ, ಸೇಮ್ ಆರ್ಡರ್ ಟ್ಯೂಸ್ಡೇ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್.
Please, ma'am.
ಎಸ್, ಸರ್ವ್ ಮಾಡಿ ಅಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ಅವ್ರಿಗೆ.
Please.
ಎಸ್, ನೆಕ್ಸ್ಟ್.
41.
My lords, the complaint is filed by the GST authorities, my lords, and it's for evasion of tax, my lords. The urgency is that, my lords, on the basis of the FIR that's been registered, taking into consideration as a predicate offense, the ED may be proceeded to register the ECR under which I'm under the threat of arrest, my lords.
All right, one additional SPP. 2, the principal additional director general.
MN Kumar is
Learned counsel, so MN Kumar is directed to accept notice for the second respondent. Again, list the matter on Tuesday in the fresh matters list. Till such time, further proceedings shall remain stayed.
Very good.
Yes.
Great.
Next, ನೀವು madam. ಇದು ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ, ಹಿಯರಿಂಗ್ ಆಗಿಲ್ಲ, ನಾನು ಮಾಡ್ಬೇಕು.
ಅಷ್ಟೊಂದ್ ಸರಿ ಮಾಡಿದ್ದೀರಾ ಹಿಯರಿಂಗ್, ಮತ್ತೇನು ಹಿಯರಿಂಗ್ ಆಗ್ಬೇಕು?
There is
ಫ್ರೈಡೆ ಕೊಡಿ ಅದನ್ನ. ಪ್ರೊಸೀಜರ್ ಫಾಲೋ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ, my submission is that, my lord, the
time ಇಲ್ಲ, Friday.
ಒಂದೇ ಸೆಂಟೆನ್ಸ್, pre-trial disposal ಗೆ ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ, that is totally in violation of principles of natural justice. 7 page ಆರ್ಡರ್ ಬರ್ದಿದ್ದಾರೆ, ನನ್ನ ಪ್ರೆಸೆನ್ಸ್ ಇಲ್ದೇನೆ, in violation of section 273 of the old CRPC.
ಅದು ಕೊಟ್ಟಿರಿ, put it into the file. We'll take it on Friday.
Yes.
Yes, ಇನ್ನೇನಿದೆ?
51.
The respondent number 2 in this case. My bank account has been frozen, it's been over a year. Applied for that also to be released.
That served the application yesterday to me. I'll file my objections to it.
For what? Refreezing?
Yes, your lords.
Why?
File my objections, your lords.
ಆಯ್ತು ಮಾಡ್ಲಿ. ಯಾವಾಗಿಂದ ಫ್ರೀಸ್ ಆಗಿದೆ?
1 ವರ್ಷ ಆಯ್ತು, but actually the application was served. Perhaps there is some change of wakalat, I really don't know.
Change of?
Wakalat, I think perhaps Mr. Mirji was appearing.
He is not appearing? You are not appearing?
I'm appearing.
Some confusion.
ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಯಾರ ಹೆಸರಿದೆ?
ನನ್ನ ಹೆಸರು ಇದೆ.
ಇದೆಯಾ ಆಲ್ರೆಡಿ?
Yes.
It says NOC, so I assumed anyway, doesn't matter.
That's all right. List on again Friday.
Friday, great.
Friday ಆಗುತ್ತಾ? Objection ಹಾಕ್ತೀರಾ ಅಷ್ಟರಲ್ಲಿ?
A week's more time, 1 week
But
time. your lords.
we had originally served on the council, we
Sir,
found on record.
ಒಂದು ವರ್ಷ
sometime back,
ಆಗಿದೆ.
but anyway, it's all-
Wednesday next.
Much.
Seventh, my lord.
Seventh.
Interim order, please be extended.
ಇದೆಯಾ?
ಇದೆ.
Interim order subsisting shall
Got it.
continue to the next date.
Lords, there's no interim order, your lords. Last three.
ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ.
ಇದೆ. What had happened was.
There is no interim order that gets
Your lordship,
extended.
please extend it.
No, if there is no interim order that gets extended. ಇದ್ರೆ ಅದು get it.
There is an interim order. In between on one given
Interim order,
hearing, it was
comma,
not
if
extended.
any subsisting today shall stand extended till the next day.
Great.
ಎಲ್ಲಾರ್ದು ಆಯ್ತಾ? ಎಸ್, ನೀವು ಹೊರಡಿ ಮೇಡಮ್, ನೀವು ಹೊರಡಿ. ಅದಕ್ಕೆ ಬೇರೆ ಎಲ್ಲ ತಗೊಂಡಿದ್ದು, ನೀವು ವೇಟ್ ಮಾಡೋದು ಬೇಡ, ನೀವು ಹೊರಡಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಷ್ಟೇ. ಅದಕ್ಕೆ ಇಫ್ ಎನಿ ಬೇಡ ಬೇಡ ಏನು ಬರಿಬೇಡಿ. ಹಾಗಾದ್ರೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ಲ. ಎಲ್ಲಿ ಅವ್ರು ನಂದಕುಮಾರ್ ಹೋದ್ರ? ಎಸ್, ನೀವು ಹೊರಡಿ ಮೇಡಮ್. ಸ್ಟಾರ್ಟ್ ಸರ್. ಕೌಂಟರ್ ಸ್ಕ್ರೀನ್ ಪ್ಲೇ ಹೇಳ್ಬೇಕಲ್ಲ.
I made an effort to decipher the whole, Lord, how this.
Madi.
I made an effort. On page 24. What is the first information report? Not by the second respondent. But for the offences under section 409, 465, 201, 110 and section 7 of the prevention of crime. Page 24. Not my first legal submission to your lordships is not under section 17 of the Prevention of Corruption Act. The batter respondent number 1, Battarayanpura Police, will not get jurisdiction to register any case. Not section 17, C, first proviso.
Battarayanpura police station will not get.
That is number 1, not the, you know, kindly come to me.
ನಂದಕುಮಾರ್ ಸರ್, ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟೇ ಇಲ್ವಂತೆ ಯಾವತ್ತು. ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟೇ ಇಲ್ಲ. 1 minute. Let him not wait for that. Yes.
Not please see the order dated 29/9/23.
ಇದೆ ಮೇಡಮ್.
It was extended regularly. Somewhere once in between, perhaps it was not. That may have been.
Perhaps once in between it is granted.
It was not extended. The reach agidilla athara anagidirbodu. I must tell your lordship that it may not have been extended once.
29/9, 22/9/23.
Sorry, my lord. The interim order was originally granted on 29/9/23. That's what. May I just pass on, my lord?
I don't see any interim order in this.
Sorry, your lordships are looking at criminal petition 9110. of
Yes.
23 and 9136 of 23. There appear to be two, but I can pass on the.
ಯಾವ್ದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿರೋದೇ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಅಷ್ಟೇ. ಇರೋದು ಒಂದೇ ಇಲ್ಲಿ.
But I'm.
ಲಿಸ್ಟ್ ಆಗಿರೋದು ಒಂದೇ. ಆರ್ಡರ್ ಶೀಟ್ ನೀವೇ ತಗೊಳ್ಳಿ ಸರ್.
Please, no, I'm seeing from the.
ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ನೀವು.
Website details.
If there is no, if there is no interim order.
Of course,
there is no interim order.
But my lord, I'm reading out the order as I read it. Learned counsel for petition submitted the allegation against.
In which petition, sir?
My lord, this is what it reads. It reads in 9136 of 23, IO granted earlier extended, in 9110 of 23, and then the order is granted. May I just pass on?
It's some, it shouldn't seem like Google showing the way where there is nothing.
Pass it on to your lordship. In your lordship should see 29/9/23.
This is 9136 of 23.
Allah, but please see right below that 9110 of 23.
29/9 ತಗೊಳ್ಳಿ ನೀವು ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ಬಿಡಿ.
I'm sorry, I don't want, my lord. Your lordship says it's not.
ಇಲ್ಲ, it's not there.
But I don't know how this is uploaded then.
Anyway, maybe in that petition it is uploaded. It's already delinked. Let's see, will ಯಾವತ್ತು ಹಾಕಿದೆ?
7th of August.
7th of August. 7th.
Please.
By then, whatever objection you have to file. Otherwise, account will be defrozen. Yes.
Great. really peculiar that the daily orders of the website says that there is an order.
No, it must have been printed in the other petition.
But it refers to granted in the earlier petition extended.
No,
So I
but
don't-
it's
anyway,
not there in the order sheet.
Please.
Starts.
No, there are two things not in this FIR. One is, Your Lordship, kindly also have a look at page 27, which is registered by police sub-inspector. Not, now, may not kindly have a look at, not the first proviso, not section 17, not may I just read,
Madam.
section 17.
Madam, PC Act coding. Madam, pardon me, someone could, yes. You can ask your officers to sit.
Section 17 would start, not with a non-obstant clause, it's a notwithstanding anything contained in the Code of Criminal Procedure, no police officer below the rank, in the case of Delhi Special Police Establishment of an Inspector of Police, in the metropolitan areas of Bombay, Calcutta, Madras and Ahmedabad, and any other metropolitan area notified under section 8, subsection 1 of the CRPC, of an Assistant Commissioner of Police, elsewhere of a Deputy Superintendent of Police or police officer of the equivalent rank. He should be the IO. The exception is, shall investigate offence punishment under this act without the order of a metropolitan magistrate or a magistrate of the first class, as the case may be, or make any arrest thereof, therefore without a warrant, provided that if a police officer not below the rank of an inspector is authorized, only that a person who can authorize or investigate is a person not below the rank of an inspector, authorized by so and so, by the government, in this behalf by general or special order, he may also investigate. But this proviso says the minimum is inspector, that too when a state authorizes. The FIR registered may not by
whom?
By the sub-inspector of police.
Very registration. Investigate.
Sorry, I'll get back.
And also it says, or a special order, he may also investigate such a without the orders of a metropolitan magistrate or a magistrate of the first class.
Who has investigated?
Like FIR ಹಾಕಿದೀವಿ ನೋಡಿ
FIR ಹಾಕಿದ್ರಿ, investigation ಯಾರು ಮಾಡಿದ್ರು?
ನೋಡಿ it says ಠಾಣಾಧಿಕಾರಿ
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ?
ಇಲ್ಲ no.
ಅಲ್ಲಲ್ಲ 2 days ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ ಇದು.
ಇದು ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
2 days ಅಲ್ಲೇ.
That's what my
2023 ಇದಾ?
20.
Yes, sir.
Under 153, the moment not 157, you lost my opinion.
Section
157 subsection 1. It says the moment FIR is registered, investigation would commence. You lost my 157
The moment
subsection 1.
FIR is registered, your stay is granted.
ಅಲ್ಲ ಅದಾದ್ಮೇಲೆ 2 ದಿನ.
ಅದು 2 ದಿನ.
No, my lord, it appears my learned friend has this big file, which he says he has collected in 2 days.
No. That is with respect to the offense which he has committed.
ಅಲ್ಲ ಈ ಕೇಸಲ್ಲಿ ಏನು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿಲ್ಲ. That is his grievance.
The primary contention is the battery in para police first respondent, he is not authorized
All right.
to register an FIR
Next contention.
for offence not under section 7. Then not the second contention is, but your lordship will find not page 34. The preliminary inquiry report not of an officer of the rank of not Assistant Commissioner of Police.
Preliminary inquiry report.
Preliminary inquiry report. Not your lordship may kindly may not have a look at not page number not 42.
ಅದೇ exonerating you.
Exonerate ಅಲ್ಲ ಅದರಲ್ಲಿ ಏನಂತ ಹೇಳ್ತಾರೆ not I was under the impression that is only this 70 or 72 lakh rupees, but my lord, apart from this 72 lakhs.
Page ಯಾವುದು?
Page 43 my lord. ಆಮೇಲಿಂದ 43 ಇಂದ
13 ಅಲ್ಲಿ 72 lakhs ಇದೆ.
6 ಅಲ್ಲಿ 6 ಎಂಡ್ ಅಲ್ಲಿ ಪೇಜ್ 43 ನಲ್ಲಿ ಫಸ್ಟ್ not 4 lines 70 ಲಕ್ಷ ಮತ್ತೆ 2 ಲಕ್ಷ ಅಂತಿದೆ.
ಹೌದು.
ಅದು your lordship may kindly come not to para 7. It is not that may not had seized only 72 lakh rupees and handed over to may not the next IO. This 28 lakhs 85,000 was also may not seized. That was also handed over. ಇದರಲ್ಲಿ ಡಿನಾಮಿನೇಷನ್ ಬರ್ದಿಲ್ಲ ಈ PF ಅಲ್ಲಿ.
So you accept 72 and not,
No, both amount not has been handed over by me.
sorry.
An impression was given saying that 72 lakhs was seized, it was recovered, and not he sent it took it to his home. Thereafter he has brought it back. But no, what has been given is not only this 72 lakhs, but also this 28 lakhs to 85,000. Then what you lost may kindly also have a look at. ಇದರಲ್ಲಿ 28 lakhs 85,000 ಅಲ್ಲಿ ಏನ್ ಡಿನಾಮಿನೇಷನ್ ಇತ್ತು ಬರ್ದಿಲ್ಲ. That's where may not the possible exchange of bundles. No, my lord. Kindly have a look at page 44. 44, para 9, 10 and 11.
I am there.
ಬ್ಯಾಟರಾಯನಪುರ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ದಿನಾಂಕ 26/2/23 ಹಿಂದಿನ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಸೋನ್ಸೋ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅವರು ಠಾಣೆಗೆ ಹಾಜರಾಗಿ ಶ್ರೀ ಸೋನ್ಸೋರ್ ಅವರಿಗೆ ಠಾಣಾ ಪ್ರಭಾರದ ಸ್ವತ್ತುಗಳನ್ನು ನೀಡಿರುವುದು ಮತ್ತು ನಿಂಗನಗೌಡ ಸೋನ್ಸೋ ಪಾಟೀಲ್ ರವರು ಪರಿಶೀಲಿಸಿ ತಮ್ಮ ವಶಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳುತ್ತಿರುವ ಬಗ್ಗೆ ಠಾಣಾ ಸಿಸಿಟಿವಿಯಲ್ಲಿ ದಾಖಲಾಗಿರುತ್ತದೆ.
Transfer of charge.
ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಚಾರ್ಜ್ ದಿನಾಂಕ 26/2/23 ಬೆಳಗ್ಗೆ ಸೋನ್ಸರ್ ಅವರು ಹಣವನ್ನು ನಿಂಗನಗೌಡ ಅವರ ಮುಂದೆ ಹಾಜರುಪಡಿಸಿದಾಗ ಠಾಣಾ ಸ್ವತ್ತು ಪಟ್ಟಿಯಲ್ಲಿರುವ ಹಣವನ್ನು ಪರಿಶೀಲಿಸಿ ಪ್ರಭಾವವನ್ನು ತೆಗೆದುಕೊಳ್ಳುತ್ತಿರುವ ಮತ್ತು ಹಣವನ್ನು ಸಿಬ್ಬಂದಿ ಮೂಲಕ ಎಣಿಕೆ ಮಾಡಿಸಿ ಪುನಃ ಸಿಬ್ಬಂದಿಯರ ಮೂಲಕ ಠಾಣೆಯಲ್ಲಿ ಇರಿಸುತ್ತಿರುವುದು ಸಿಸಿಟಿವಿ ಫುಟೇಜ್ ಅಲ್ಲಿ ಪರಿಶೀಲಿಸಿದಾಗ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಬ್ಯಾಟರಾಯನಪುರ ಠಾಣೆ 26/2/23 ಪೊಲೀಸ್ ಠಾಣೆಯ ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅವರು ಚೇಂಬರ್ ನಲ್ಲಿ ಹಣವನ್ನು ಎಣಿಕೆ ಯಂತ್ರದ ಮೂಲಕ ಎಣಿಸಿದಾಗ ಬ್ಯಾಗ್ ಮೂಲಕ ಟೇಬಲ್ ಮೇಲೆ ಇಟ್ಟುಕೊಂಡು ಕೊನೆಯವರೆಗೂ 500 ರು ಬಂಡಲ್ಗಳು PI ರವರ ಟೇಬಲ್ ಅಲ್ಲಿ ಇಟ್ಟು ನಂತರ ಬ್ಯಾಗ್ ನಲ್ಲಿರೋ ಹಣವನ್ನು ಸಹ ಪರಿಶೀಲಿಸುತ್ತಿರುವುದು ACP ಕೆಂಗೇರ್ಗೇಟ್ ರವರು ನೀಡಿರುವ ಸಿಸಿಟಿವಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. Ultimately, my lord, at the end of my lord, the report it says, not at page 45.
ಸಾಬೀತಾಗಿರುವುದಿಲ್ಲ.
Not I had brought your lordship kind notice.
This is the report of the ACP. Against whom D is initiated now for writing this report.
That I do not.
That's what the SPP says.
Yes, I placed for your lordship.
Huh?
I placed for your lordship.
Placed also. Yes.
Now, you know, I think he has not.
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ ಅದೆಲ್ಲ.
Like, he has not given not anything in writing.
ಯಾರಿಗೆ?
ಅಲ್ಲ ಏನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ. Not he has filed not just one
ಅಲ್ಲ,
page.
he has given many documents, investigation papers of earlier cases.
My submission is not if he says something in writing, but I can not say counter.
No problem.
I can say my
Then we will permit investigation to go on.
ಅಲ್ಲ ಇವಾಗ ಏನಿದೆ ಅಂತ ಅಟ್ಲೀಸ್ಟ್ at this stage.
ಅಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಏನಿದೆ ಅಂತ. You want, we will permit investigation. Then we will write the script later. ದೃಶ್ಯಂ 3 ಬಂದಿಲ್ಲ ಅಲ್ಲ?
ದೃಶ್ಯಂ 3
ಬಂದಿಲ್ಲ.
ಬಂದಿಲ್ಲ.
ಅದಕ್ಕೆ 3 ಇಂದ 4 ಗೆ ಸ್ಕಿಪ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಇದು.
317 ಹೇಳಿ.
Not what I have done. I ಹೇಳ್ತೀನಿ ಅದನ್ನ. After 17, not I had brought your lordship kind notice. Not Charan Singh's not judgment 2021
Yes,
part
sir.
6.
Preliminary inquiry.
Preliminary inquiry.
ಗೊತ್ತಾಯ್ತು. Yes.
That where FIR shall not be lodged.
This is considered in Vijayalakshmi's case. Not in all cases ಬೇಕಾಗಿಲ್ಲ ಅಂತ. ಅದು ನಿಮಗೆ ಬೇಕಾಗುತ್ತೆ in other cases where you are.
ಅಲ್ಲ ನಾನು ಹೇಳಿದ್ದು ಇದು ಪ್ರಿಲಿಮಿನರಿ ಎನ್ಕ್ವೈರಿ ಬೇಕಂತ ಹೇಳಿಲ್ಲ. ಪ್ರಿಲಿಮಿನರಿ ಎನ್ಕ್ವೈರಿ ಮಾಡಿ ಪ್ರೂವ್ ಆಗದೆ ಇದ್ಮೇಲೆ you shall not register FIR.
What preliminary inquiry?
Not your lordship will find not is para.
The ACP's preliminary inquiry.
But that is they conducted by them, not by me.
ಗೊತ್ತಾ ಅವರೇ ಮಾಡಿರೋದು. ಈಗ ಪ್ರಿಲಿಮಿನರಿ ಎನ್ಕ್ವೈರಿ ಆದ್ಮೇಲೆ ತಾನೇ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿರೋದು.
Preliminary inquiry ಆದ್ಮೇಲೆ not now my learned senior friend is contending that they will not being satisfied with this preliminary inquiry, they got conducted one more preliminary inquiry through some other officer.
Oh, that nails you.
That's what not it is said.
Investigation permit ಮಾಡಿ ಏನು ತಪ್ಪು?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾದರೂ ಅಫೆನ್ಸ್ ಆಗಿದ್ರೆ ಅಂತ. Money is there intact. I have given 72 lakhs plus 28.5 lakhs. That money is also there, not intact.
Money is there, notes are changed.
ಅಲ್ಲ 28.5 ಲಕ್ಷದನೋ ಇದೆ. ಅದ್ರಲ್ಲಿ ಇದ್ದಿದ್ರೆ ನಾವು ಹಾಕೊಂಡಿರ್ಬೋದು. Not CCTV indicates that I have given the entire money.
Money is there.
Not your lordship also may I just not bring to your lordship kind notice. Your lordship asked me, what did you do after not recovery of the money? ಇದರಲ್ಲಿ may I just not sir.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಅಲ್ಲ ನಾನು ಹಾಕಿದ್ದೀನಿ. not page number not 6 my lords will find 6. Oh, this is the first PF not dated 14/10/22.
72 lakhs though.
42, 47 lakh. Other 72 lakh bit by bit and pieces not is recovered.
ಸರಿ.
1410 ಗೆ 47 ಲಕ್ಷ. Which is not seized under PF. Reported to court on the same day. Not on 1410.
Page
not page 6 you know.
Page 6.
Page 6 not it has been reported to court. Your lordship will find ಅಂಕಣ ಕೆಳಗಡೆ ಇಲ್ಲ ಕೊನೆ 4 ಲೈನ್ ಇದೆ.
ಇದು 47 lakhs.
47 lakhs. ಒಂದು ಎರಡನೇದು your lordship will find the next page. 15 lakhs of the same case, additional 15 lakhs. That's on 1810.
ಆಯ್ತು. 62 lakhs, sir.
62 ಆಯ್ತು. That's also reported to the court. Not thereafter, not at page 8, on this, after not these two recoveries, not this petitioner would write, not to the income tax authorities on 2010 itself, about not the recovery of this money. But on the very same day again, not somehow your lordship will find not page number 11. Further sum of rupees 10 lakh not has been recovered on 20th of 10, 72 aito. On the same day, the second respondent to take over investigation. By then, your lordship will also find not the order sheet of not me, the petitioner, reporting about not seizure of this money not to the court.
No, when was it seized, sir?
No, it was seized on 1410 and 1810 and 2010. On 1410, I seized not 47 lakhs. Page 6, not. Then not page 7, 1810, 15 lakhs.
ಇಲ್ಲ ಈ ಅಮಾನತ್ ಪಂಚನಾಮ ಡ್ರಾ ಮಾಡಿದಿರಲ್ಲ
Sorry.
ಅದು PF ಆಗಿದೆ.
PF ಆಗಿದೆ, it's reported to court. Reported to court. Mazar ಆಗಿದೆ, PF ಆಗಿದೆ. Then 7 not page 7, 1810, 15 lakhs. Immediately thereafter, not a report is sent to the income tax authorities, which your lordship will find not at page 8. On this very day, not a further sum of rupees 10 lakhs also is recovered, not at page number 11. This also is reported to court, which is not found in the order sheet. Not your lordship will find the order sheet, not at page 14, not. On 2110. Not the next the officer will report it to the court on 2110 because I was there only till 2010. Accused so-and-so, yes, so-and-so produced before me at so-and-so. On inquiry, accused did not complain. TGR has filed signature of the accused. IO has filed remand application, medical certificate, alleged offence under section so-and-so. The offence is non-bailable. As per remand application, IO has seized 72 lakhs as per the instructions of accused. Still investigation not complete, so there are sufficient grounds to remand the accused. This also is reported to the London magistrate. Not I report not to the income tax authorities on 20th, which I brought to your lordship by notice at page 8. Thereafter, investigation is handed over, taken over by second respondent.
Yes.
Then not IT would also file not wakalat in this very case.
No, IT has sought
page 20.
that amount and it is transferred to income tax.
Yes, 2910, your lordship will find not page 20. 9 days thereafter, not IT would file the application on 2910. She so-and-so would file power for IT and application. Income tax not authorities along with an application. It is filed on 2910. But I was there for 8 days. I recovered money, reported to the magistrate, reported not to the income tax authorities. That's all not I have done. This money is subsequently ordered to be not given to the income tax authority. Income tax.
It's given to the income tax
department.
No misconduct.
No misconduct.
No ingredients of 406.
No ingredients of 409. Not even temporary misappropriation. Nor not sections 7. Demand or
Criminal misconduct.
Demand or acceptance or recovery.
Demand acceptance, self-oblique. Anyway, it's an FIR. Yes, sir. Ashtana.
That's all not I think I can decipher not from the records. For 8 days he was there. This is what he has done for 8 days.
Lord, I'll not repeat whatever I've said on the last occasion. Kindly take my list of dates and events, Lord, which I will only go through that so that the story is again refreshed.
No, I have not. I have not forgotten it.
Yes, what are dates and events.
Yes, sir.
Investigation report.
List of dates ಕೊಟ್ಟಿದ್ರೆ ಆಯ್ತಾಯ್ತು ತೊಂದರೆ ಇಲ್ಲ.
ಅವರು ಕೊಟ್ಟಿದ್ರಲ್ಲ ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್
ಅಲ್ಲ ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಕೊಡಕ್ಕೆ ನಾನು
ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಕೊಡ್ತೀನಿ.
ಬರೀ ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಕೊಡಿ.
ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ pull this out and give.
ನಮ್ಮ ಪಿಟಿಷನ್
ನೀವು ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಕೊಟ್ಟು ಅವರೇ ಹೇಳ್ತಾರೆ ಮ್ಯಾಟರ್ ಫಾರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
On 29.
My difficulty is this petitioner is my client since several years. The second respondent is known to me. The officer who conducted second P is also very well known to me. I am in a very precarious.
Therefore, under that obligation is arguing. So I will not pursue the matter anymore.
No, I have to write the judgment, sir.
He says, hello.
Yes.
On 29/9/2020.
Last submission, section 3 and 4 of the Prevention of Corruption Act. It should go not to any FIR should be submitted to the special court constituted under section 3 and 4. This is before the magistrate.
We'll see.
My lord, the lord has the list of
Because
dates.
section 7 ಇರೋದ್ರಿಂದ.
Section 7, well, 17A, not permission.
17 yes, sir.
I'm not the action taken. Decision taken.
What decision? Decision in discharge of official duty? 72 lakhs alliro 2000 note denomination change ಮಾಡಿ discharge of official duty.
No, they will have to say, not what happened, what was the denomination in the remaining 28.5 lakhs.
17 decisions taken in discharge of official duty, they should not be punished ಅಂತ ಅಷ್ಟೇ. Yes.
My lord, 29/9/2022, my lord.
ಮತ್ತೆ ಅದನ್ನ ಓದ್ಬೇಡಿ, ನಾನು ನೋಡ್ಕೊಂತೀನಿ.
Yes, yes. Now I'll only refer to serial number 3, my lord.
Seizure Mazar.
On 3 dates. my lord.
ಅಷ್ಟೇ 14/10/22 seizure happens.
Kindly go to that page, my lord. It is
Page
at 6
6.
and 8.
Yes.
My lord, now the denomination in all the property folio is 500 rupees, my lord.
Yes.
Now I will straight away take a lordship to the inventory by the income tax authorities, my lord.
Yes.
My lord, that is at, my lord, page, my lord, serial number 21, my lord. Page number 80. Page number 80.
Serial number 21.
21, my lord, serial number 80.
Page number 21 na.
Alala. Page number 82, serial number 21. ఇది అలా ఇండెక్స్ ಅಲ್ಲಿ
ಬಂದವು.
Yes. Page number 80.
82 serial number.
Page number 82.
I am inventory of cash found.
Yes, 82.
Okay.
82. Your lordship sees the denomination, my lord. This is by an IRS officer taken from the
2000.
2000 rupees. It is in vogue even on
All
this
right.
day.
ಅದು ಗೊತ್ತು.
Not in circulation.
2500, 200, 100.
100.
But seize ಮಾಡಿದ್ದು only 500.
Only 500. Only 500. And kindly now go to the report filed by the DC, the ACP to the DCP immediately thereafter.
Page.
Not the next page at 59. The bundles found is of SBI Bank. The next page, 60, page number 60.
60.
60.
Next page ಅಂದ್ರೆ
89. 89, sorry, 89. ಅಲ್ಲಿ ಇದಾಗಿ ಸದರಿ ಅವರು ಹಾಜರುಪಡಿಸಿರುವ ರೂಪಾಯಿ 72 ಲಕ್ಷಗಳಲ್ಲಿ 5 ಲಕ್ಷ ನಗದಿನ 2 ಬಂಡಲ್ಗಳ ಮೇಲೆ SBI ಬ್ಯಾಂಕ್ ಬ್ರಾಂಚ್ ID so and so dated 9/1/2023 ಅಫೆನ್ಸ್ ಆಗಿರೋದು ಸೀಸ್ ಮಾಡಿದ್ರೆ 22 ಅಲ್ಲಿ. ಇವ್ರು ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ವಿಡ್ರಾ ಮಾಡೋದು ID ನಂಬರ್
ಅಲ್ಲ, ಅದು ತೆಗೆದಾದ್ರೂ ಕೊಡ್ಬೇಕಾರೆ.
And thereafter, my lord, inquiry is found guilty. Not only in this offense, my lord, this is his habit. 20 lakhs ಬೇರೆ ಸೀಸ್ ಮಾಡ್ತಾರೆ, ಅದನ್ನು ಮನೇಲಿ ಇಟ್ಕೊಳ್ತಾರೆ. ಫಾಲ್ಸ್ ಇಂಪ್ಲಿಕೇಶನ್ ಮಾಡ್ತಾನೆ ಈ ಮನುಷ್ಯ, ಎಲ್ಲಾದ್ರೂ ಸೀಸ್ ಮಾಡ್ತಾನೆ, ಸೀಜರ್ ಅಲ್ಲಿ ಬರೀ 50% ರಿಪೋರ್ಟ್ ಮಾಡ್ತಾನೆ, ಬೇರೆ ಲ್ಯಾಪ್ಟಾಪ್ ಅದು ಇದೆಲ್ಲ ಸೀಸ್ ಮಾಡಿ ಮನೆಗೆ ತಗೊಂಡು ಹೋಗ್ತಾನೆ. He doesn't even find place in the property folio. These are all the offenses committed.
He has opened a franchise.
ಗೊತ್ತಿಲ್ಲ. ಗೊತ್ತಿಲ್ಲ. So therefore, prima facie have made out a case. So therefore, my lord, the investigation should be allowed in the present affair. My lord,
Investigation should be dropped.
should be dropped on the, he might say. My lord, may I pass on the, how he walks into the bag? ಸ್ವಲ್ಪ pictures ಇದೆ. Pictures ಇದೆ, ವಿಡಿಯೋನು ಇದೆ, pictures ಕೊಡ್ತೀನಿ. He walks in with two.
ನಾನು ಹೇಳಿದ್ ಲಾಸ್ಟ್ ಟೈಮ್ ದೃಶ್ಯಂ ಅಂತ.
ಅಲ್ಲಿ ನೋಡಿ, ಫಸ್ಟ್ ಪಿಕ್ಚರ್ ಅಲ್ಲಿ ನೋಡಿ, he walks in. Now turn the number 2, my lord. It's next page, number 2. Next page. ಅವ್ನು ಬರುವಾಗ ರಿಸೆಪ್ಷನ್ ಇದೆ, ಅವ್ನ ಪ್ರೀವಿಯಸ್ ಪೊಲೀಸ್ ಆಫೀಸರು ಸಲ್ಯೂಟ್ ಹೊಡಿತಾರೆ. Now he walks in the red t-shirt, ಸ್ವಲ್ಪ ರೆಡ್ ಕಲರ್ t-shirt. Behind him walks a man with 2 bags.
ಮನಿ.
ಅವತ್ತು
26/2/2023.
Yes, next day was the inventory. He follows the case of withdrawal application filed by the income tax officer. Next to page 4. ಅಲ್ಲಿ all are ಅಲ್ಲಿ bag, he walks in with the bag to the locker there, places it and escapes before the present incumbent could take charge. These are all he's a dangerous man to the society. From what the present scenario shows, he shouldn't be let scot free, my lord. Submission, prima facie have made out a case for investigation in the present
Page 3. I am not there.
Page 3.
He is not there.
ಇದ್ರಲ್ಲಿ page 3.
Page 3 of his photo. I am not there. And there is nothing to indicate who is this man, how is he connected to me.
ಅದು ಇನ್ವೆಸ್ಟಿಗೇಟರ್ ರಿವೀಲ್ ಆಗುತ್ತೆ.
You are not there ಅಂದ್ರೆ ರೆಡ್ t-shirt ನೀವಲ್ವಾ?
Not this man, not I, not this, your lordship will find a page, not.
No, red t-shirt ನೀವೇ ತಾನೆ?
Not page, not 6, not 1 ಅಂತ 6 ಇಲ್ಲಿದೆ first.
That's all right. The man with the red t-shirt is you.
ನಮ್ಗೆ
ಕೊಡ್ಲಿಲ್ಲ,
colour ಕೊಟ್ಟಿಲ್ಲ.
ಕಲರ್ ಇದೆ ಇಲ್ಲಿ ಕೊಡ್ಲಾ? ಅಲ್ಲಿ ಅಲ್ಲೇ ಇದೆ ಒಂದೇ.
Oh, ಇದು ಕೊಡಿ ತೊಗೊಳ್ಳಿ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ this appears to be not the petitioner.
Appears to be, red
Page
t-shirt
6.
is you.
Page 6 ಅಂತ ಹೇಳ್ತಾರೆ. May not
That
this
is what
appears.
the SPP is saying.
Of course, his instructions may not may be correct.
Red t-shirt is you. One
But
who
he is holding some
following-
papers. He is holding
No.
some papers in his hand.
Yes, yes. One who is following you.
ಅಲ್ಲ one who is following you ಅದು ಇಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ಲ.
ಇಲ್ಲೇ ಇದೆಯಲ್ಲ. Following your instructions
Not your lordship will find.
with two bags full.
ಅಲ್ಲ ಈ ಬ್ಯಾಗ್ಸ್ ಇರೋದು 11:30 ಅಂತಿದೆ. 11:30.
11:30 AM, sir.
ಅದೇನೆ. ನಾನ್ ಬಂದಿರೋದು 11:30, 8:58. Your lordship will find me not.
11:30?
8.
Sir, 11:38.
ಅಲ್ಲ ಈ ಬ್ಯಾಗ್ ಬಂದಿರೋದು ಅವ್ರ ಪ್ರಕಾರ 11:30ಗೆ.
ಸರ್ ಇಲ್ಲ, ನೀವು 11:30ಗೆ ಎಂಟ್ರಿ, ಫೋಟೋಗ್ರಾಫ್ ನಂಬರ್ 1. ಆಯ್ತಾ? ಆಮೇಲೆ
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ನಾನು ಕಾಣ್ತಾ ಇಲ್ಲ. 11:38ಗೆ ಎಂಟ್ರಿ.
ಬ್ಲಾಕ್ ಅಂಡ್ ವೈಟ್ ಇದೆ ಅಲ್ಲಿ.
Page 4 your lordship will find me not. 11:30 it is again 11:38.
ನೋ ಅದು ಸ್ವಲ್ಪ ಪಿಕ್ಚರ್ಸ್ ಅವ್ರು ಕರೆಕ್ಟ್ ಆಗಿ ಪ್ರಿಂಟ್ ಮಾಡಿಲ್ಲ. ಸಿ ಪಿಕ್ಚರ್ ನಂಬರ್ 1 11:30, then come to the next page 11:30 18 seconds you enter the police station. ಆಯ್ತಾ?
ಅಲ್ಲ ನಾನಲ್ಲ, ಅದು ಹಿಂದೆ ಇರೋದು ನಾನಲ್ಲ. This is not the petitioner.
ಯಾವುದು?
ನೋಡಿ in this photo with the bag.
With the bag
with white shirt.
ನೀವಲ್ಲ.
A person with the white shirt.
With the bag it is not you.
Not you.
Please not.
He is the assistant.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಇಲ್ಲ.
ಇಲ್ಲಿ ಮುಂದೆ.
He is not there in this photo.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇದರಲ್ಲಿ in this not
ಮುಂದೆ
photo with the
ರೆಡ್
bag.
ಟಿ ಶರ್ಟ್ ಯಾರು ನೀವೇ?
ಅಲ್ಲ ಈ ಫೋಟೋ ನಮ್ದಿಲ್ಲ.
ತಗೊಂಬಿಡಿ ನೀವು ಕಲರ್ ನೋಡಿ.
Color.
ಮೇಡಮ್ ಕೊಡಿ ಇದು.
Lord, now kindly turn to the index. Once more, Lord.
Anyway, ಇಷ್ಟೆಲ್ಲ ಇಲ್ಲಿ 482 ನೋಡೋದೇನು? Matter of investigation straight.
Lord, kindly see Roman number, serial number 7, my Lord. 8/1/2022, next page index ಅಲ್ಲಿ. Dates and events ಅಲ್ಲಿ.
Page.
My Lord, the list of dates and events ಕೊಟ್ನಲ್ಲ, ಅದರಲ್ಲಿ serial number 7, 8/1 dated 8/1/2022.
Correct.
There are 3 reminders issued to him to deposit the money. In spite of all this, we issue, ACP would issue notice to him to deposit it in the treasury and get the receipt at least. Lord, kindly see that. 3 reminders have been issued. He would not care. 8/11, 17/11, 26/11.
ಇಲ್ಲ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ. Not.
Let there be a finding on this, because last time we invited one finding. So therefore.
Yes. Anything else, Prasanna Kumar sir? Heard reserved. ಇವತ್ತು ಎಷ್ಟಾಯ್ತು? 3 ಮೇಡಮ್? ರಿಸರ್ವ್ 1 ಆಯ್ತು, 2 ಆಯ್ತು, 3 ಆಯ್ತು. ಪ್ರವೀಣ್ PCP ND ಅದೊಂದೇ. ಎಸ್ ಸರ್.
Please.
ಅದು ಅವರು ನೋಟಿಸ್ ಕೊಡಬಾರ್ದು. ಎನ್ರೋಲ್ಮೆಂಟ್. ಎನ್ರೋಲ್ಮೆಂಟ್.
Yes, the son has come all the way from America.
America to see his father get back into profession. Will release it. Yes. ಆಯ್ತು.